try not to run so late today, so we need to get going. I don't have any announcements first thing this morning, so we'll just jump right into the agenda. And so what we have up first in our presentations on permanency and adoption, first we have Rachel Jones, who is a foster parent. Is that you? Okay, go ahead and come forward. And go to the mic there, and then just make sure that the light is on. Is there? It's not. It's red.
How about now?
Yeah.
Okay.
Yeah, you might pull it down just a little bit for you.
There we go. I just want to spit in it.
You're fine. Welcome to our committee.
Thank you. Appreciate you guys having me and giving me this opportunity to share with you our story and experiences. I wanted to open by saying, what would you say about a child whose sink case lingered in the Kansas foster system for almost 9 years? What would you say about a child whose bio parent spent over half their life in prison for violent crimes, attempted murder, armed robbery, promoting prostitution, harboring a fugitive from justice, assault, distribution of an illegal substance? And then imagine how the state contractor worked very hard to try to reintegrate this child with a bio parent stating that was in the past and we are only interested in the future. I'm here today to share my experiences with the Kansas child welfare system and ask for your help in facilitating meaningful reform. The purpose for me speaking with you today is not to criticize or be unkind. My purpose is to raise awareness and share with you my experiences with the Kansas child welfare system, specifically in regards to the administration of sink actions, and to use those experiences to highlight opportunities in the system for meaningful reform. My husband and I became foster parents to help our child who was a child in need of care. We retained legal counsel and entered as interested parties. The case took almost 9 years to reach a conclusion. The road was rough, emotionally damaging to our child, and filled with bureaucracy. Our fight for the best interest of our child came with a price tag of over $150,000, and that's not including other ancillary expenses. Some examples of events that led to the 9-year sink actions were we had a bio parent termination of rights that was overruled by the appellate court, specifically citing mishandling of the sink action by the state contractor. Continuances being granted by the court, there were over 10. A falsified ICPC, which is the Interstate Compact on Placement of Children. The bio parent's attempt at an illegal private adoption by a family member. And the bio parents being allowed to indulge in atypical behaviors and general disregard for the sanctity of the sink action. This experience made us question the process design and made us ask, what's truly the objective? Is the objective to serve the parents or to serve the most innocent and vulnerable citizens, the children involved? Observation number 1, the initial objective is always reintegration. Why isn't there a meaningful evaluation period for the family, parents, children, and extended family by an impartial third party? Someone not connected to the case and who does not have an agenda of reintegration. This would not be a one-and-done objective, as this would need to be done over a period of time. Sometimes it takes a while for a person's real intent and character to show. Instead of running headlong into reintegration, take some time to get to know the people involved, really know them. If reintegration is always the objective, why are we subjecting children to the trauma of being removed from their homes instead of providing more in-home services and robust support? Observation 2, reintegration plans are basically all the same, one size fits all. A home, car, job, and bank account are the cornerstones of what is required for reunification. There may be other tasks on the plan, but they can be removed or downplayed. We found the case plans to be very high level, and in some instances glossed over and downplayed serious issues such as drug testing, relationship with the child, family dynamic, and tasks not completed. There's a court report that is submitted by KVC and DCF to the presiding judge. There is a case plan administered by KVC. The content and tone of these documents can vastly differ, and we question why they are not the same. There should be a more customized report to each reintegration plan for certain bio parents. For example, there should be specialized reintegration plans for parents who have sexually abused their children, who are battling addiction, who are physically or emotionally abusive, who are involved or have been involved in human trafficking and promoting prostitution, who are involved or have been involved in illegal drug trafficking, or who have meager parenting skills or are neglectful. It seems there's a lot of focus on fixing broken children to send them home to deal with broken parents, but no significant efforts to fix broken parents so they can sustain a home that is suitable to meet the social, emotional, and physical needs of their children. One-size-fits-all reintegration plans do not address the key issues. There needs to be very specialized and customized plans for parents that fit in these categories and more. In our case, the KVC caseworkers downplayed or were unable to identify a lot of serious issues. Past behaviors of the bio parents must be acknowledged regardless of when they occurred. In our case, the bio parent had drug tests that showed evidence of use and failed drug tests. The bio parent was on a color code but refused to abide and would only test on days of visits with the child. And this was allowed and even downplayed by the state and the court. In addition, KVC did not verify back to the source documentation submitted by the bio parent. This was substantiated by a denied ICPC that stated the bio parent failed to provide any required documents, meaning lease for the apartment, car title, proof of income, etc. I find it interesting and concerning that if another state could make this determination, why couldn't we? It seems the standards for parenting and tax completion are quite meager. Again, if the goal is reintegration and the standards are so low, why are we going through this painful process? What are we trying to accomplish? In our case, our child's case was very difficult and complex. It involved complex family relationships, generational trauma and abuse, and people that were willing to lie and deceive to get their way. Yet our case was handed over to the newest and most experienced caseworkers, time and again, and there were over 10 caseworkers in almost 9 years. Well, I have no doubt these caseworkers had their degrees in social work and early childhood development, that is academics. These complex situations require caseworkers with real-life experience. To expect a person with little to no life experience and base minimum training to be making life-altering decisions for children is unrealistic. Many of the caseworkers weren't even parents themselves. Many professions require extensive internships, apprenticeships, or residencies before releasing new employees into real work on their own. Why is that not the same case for these workers who, again, wield a great deal of influence in truly life-altering decisions of children? We had several caseworkers who turned out the same court report and plan again and again. There were no revisions. There were no modifications. It appeared no one had reviewed or provided a second managerial review, or if they did, no one noticed or cared. They just copied and pasted. And we also had several caseworkers that were willing to misrepresent the facts to keep reintegration on track, and I can provide you those details later if you so desire. Observation 4. The bio family seems to be the only option for permanency. While the bios may be in some instances known to the child, is this truly the best place for them? Often issues that cause the child to be removed from their home are due to repeated and generational traumas. We were told by KVC workers that their study shows children who are with bios do better in life, and that if we did not support the relationship between our child and the bios, we would risk losing our child because we would be sabotaging reintegration. We had a family member that stepped forward stating they wanted to adopt our child. This family member had previously seen our child one time in their entire life. There was no attachment. There was no bond. We were told by several KVC caseworkers, this also created another delay in our case while we waited for this opportunity to be vetted, and it took over a year. The family member had an ICPC performed by their state of residence, and that state concluded there was serious concerns about placing the child in this family member's care. But this didn't cause anyone to stop or consider what was best for the child. The child started having serious behavioral and emotional issues following visits with that family member. KVC again dismissed the behaviors as normal. But eventually the family member walked away when they found out they had to complete a full legal adoption before they could take the child out of Kansas. Observation 5, visits, family therapy, and parenting classes are conducted by KVC employees, usually caseworkers, who have a vested interest in reunification. If KVC is handling all aspects of the SYNC case and their only objective is reintegration, how can the best interest of the child really be achieved? Should KVC or any service provider be the only resource for all aspects of the sync case? For all sync cases, the answer is probably not. Instances involving marginal parenting, as highlighted previously, should be handled by third-party professional family therapists and parenting group therapy. In closing, I've had a lot of people say, it's too broken to fix. We don't know where to start. How do we fix this? Quite simply, if the process was designed to serve the best interest of the child first and only, that'd be a good place to start. Sync cases are complex with multi-layered issues that cannot be resolved with a checklist. It's not some person's opinion of what's in the child's best interest or a parent having a home, car, job, bank account. It's a solution that takes time, careful evaluation, and scrutiny. Someone also commented to me, parents have a constitutional right to parent their children. Well, maybe so. But these children are citizens of the United States, too. They have rights, too. Living under the same roof is not parenting. Parenting is being there to provide constant love, comfort, support, guidance, and safety. My house may not always pass a white glove test, but it's usually picked up and relatively clean. There's always a hot meal on the table, help with homework, clean sheets and a warm bed. It's wiping tears and bandaging knees. It's sitting in the freezing cold or scorching heat watching baseball games and band concerts and school functions. It's being there for that child and that child knowing that they have someone who loves them and will always be there for them and that they are safe. That is family, and that's what a parent is supposed to do and what a child should expect and deserve no matter who they live with. Thank you.
Thank you, Rachel. Committee, do we have any questions for Rachel? Senator Gossage.
Rachel, thank you so much for being here and for your clear and concise testimony. I just have a couple of questions. What would you consider meaningful evaluation under your observation 1?
I think that the observations should be, if you're talking about before we decide which way we're going to go with the reintegration plan.
Right, because I understood you to say 9 years, my goodness. So there should be a cutoff time where meaning that they've had a reasonable amount of time to evaluate the biofamily and determine it's time to allow this child to have a different permanent home. So what would you consider this meaningful evaluation? So I wanted to re-clarify my question so you understand where I'm going.
I think it should be, you know, I've been a hiring manager for a long time, and people are always going to give you as referral the people that they know are going to give them good referrals. So I think this should be a lot more arching. You know, the parents are going to obviously put up in front of you the people that are going to give them the best references, you know, mom and dad and brothers and sisters and what have you. Who's talking to the bosses? Who's talking to the neighbors? Who is checking their social media websites? Who's checking their online activity? In our particular case, there was a lot of illegal activity that was going on online, and there was a known presence with the Kansas City Police Department. None of that was checked. So I don't know that I have I guess you'd say a perfect solution, but we need to be talking to people more than just who the parent tells us to talk to.
And where is the child now?
Right there.
Hi there. And have you adopted him, or where are we in
Yes,
this
we have.
process? You're going to make me cry.
August 22nd, we adopted. So, thank you.
And then the next question would be, do you have specific recommendations for this committee? And if so, can you get those to us?
Yes.
Great. Thank you so much. Thank you, Madam Chair.
Senator Faustido.
Thank you, Madam Chair. Wow, okay. So I was trying to look for your name. Rachel.
Yes.
Thank you, Rachel. Initially, I was going to, the way your testimony was presented, I was going to ask if you were the bio parent, foster parent, or adoptive parent, but you've answered that already. Congratulations. So would you, this oversight that you speak of, would you recommend, or have you known of I'm going to call it, for a lack of a better word, maybe like a citizens review board of some sorts of neutral people who don't know anyone. However, they might be a former social worker or someone who has some knowledge of the process. Would you recommend that we establish those in different parts of the state of Kansas?
Absolutely. Absolutely. So I think there needs to be a lot more eyes on this process, and those eyes need to represent different factions. So yes, I would absolutely positively agree with you. So,
And I know that we talk about providing shelter and love and all of those things that you shared with us. You know, however, Madam Chair, sometimes I struggle with the biological parent, mother, giving birth. You know, so the God-given, you know, right or love, that even though those individuals have those addiction problems, or they are low income, or they are illiterate, or whatever the case might be, you know, I hear people on both sides who are struggling with addiction say, oh, I still love my child, although I can't provide these other financial things for them. So with that said, you talked about 9 years. So, and usually, generally, within the law, it's about 12 months that we should consider placement. But I just want people to kind of consider every case is different.
yes.
So when we make that cookie cutter time limit, every case is different. But I do agree that the the paper trail, or that information, I keep saying a carbon copy of, you know, here's what I've done, the biological parent, here's what I've done. I want them to leave the courtroom with, you know, a list. And when they complete that, those 5 items, it's a check mark, so they don't have to do it again. And then I want the foster parents or the adoptive parents to have information. And if they're in that child's life, we talked about the attachment piece. And so this is a difficult situation that we're all charged with to address. But I appreciate you sharing your story with us today. Thank you, Madam Chair.
Senator Baumgardner.
Thank you, Madam Chair, and thank you so much for being here today. A question that I have is what we have heard from others previously, that the foster parents don't have a voice when decisions are being made. And you don't, that's not one of your specific observations, but where do you think it would be most appropriate? Would it be a part of that meaningful evaluation where the foster parents would have a specific voice in that process?
You are correct. I did not address it. No, we did not. And yes, I do. The challenge that we found with it is the advocacy was construed as trying to sabotage reintegration.
Right.
And yes, I mean, I think the foster parent, I mean, they live with that child 24 hours a day. I mean, who, you know, I know the parents in probably a lot of cases have a keen insight into their child, but, you know, this foster parent is, I guess you'd say, while connected to the situation, removed from the situation. And I think that they are highly qualified to speak to the situation. In our case, we addressed serious issues, and we were told, well, that's normal. Well, that's normal. Well, that's normal. Well, it's not normal. It's typical, and it still isn't right. So, you know, let's focus on why this kid's having these problems. Let's get to the bottom of it instead of dismissing it by saying it's normal, because obviously there's a problem. And if we really want to have a meaningful reintegration, or we really are looking at severing ties, we need to understand where that's coming from.
And Madam Chair, my follow-up question is exactly where you led us, because you do share that when a family member stepped forward, when the family member stepped forward and they'd only seen your son once before, but then you indicate that when he was having those visits, then you did see behavior changes, which I think from what we've heard from other cases is new trauma is being imposed.
Yes.
So did KVC or DCF provide any type of pre-visit sessions, or once those visits were occurring and the trauma behavior was being seen, did they provide any services for your son?
No.
Okay. I think that's important for us to know, because that needs to be included and provided for children, because the contractors and the agency know that if they start to try that integration with someone that really the child is not familiar with, it creates that new level of trauma, trust issues, and fear. Fear is so significant. And so I thank you for being here. I absolutely am so happy that we were able to see a smiling face back there.
Yep.
Thank you.
Thank you.
Senator Gossage.
Thank you, Madam Chair. Just a quick follow-up question. Did you reach out to the Child Advocates Department?
You mean CASA?
No, the Child Advocate position. I know that it's not been there for 9 years, but was that prior to your adoption? I mean, was this, that department perhaps was set up after you had adopted the child? I'm seeing a nod from
Yeah,
my...
we just adopted him August 22nd, so.
Okay.
I will tell you, speaking very bluntly and candidly, we were very cautious with how we proceeded, because we were constantly being threatened and in constant fear of having our child removed. Your sabotaging reintegration was hung over our head nonstop.
And so you felt like if you were to reach out with the Child Advocates office, that it wouldn't be neutral?
Correct.
That they might, okay.
Correct.
And who did you feel were threatening you? Was it the caseworker?
Just caseworkers.
The caseworker.
PERS, multiple.
Multiple. Thank you very much for
Thank
being
you.
here.
Thank you.
Yeah. Oh, Rachel, we're not done with you yet.
Sorry.
Just Senator Gossage is done with you. Representative Ousley.
Thank you, Madam Chair, and thank you for being here. Thank you for sharing your story. And just to kind of follow up on that question right there, the Office of the Child Advocate, I believe, has been established for the last year, and I wanted to make sure that that's what you were considering as a non-independent option to go, because the intent of the office was certainly to be a safe place for individuals such as yourself to come without fear of retaliation. And it's a new office, newly established, still getting up and going, and I just wanted to make sure that that was what you were aware of, that the senator was asking about.
Okay. No, I wasn't, and now I am.
Okay, because it's something new that has been put in place to help with this sort of situation, so that situations like yours can move forward without fear of retaliation. And I've said it to several people in the committee room, we're working on it. It's a slow process, but it's a piece of the puzzle, so thank you.
And if I could say, I listened to the testimony yesterday, and heard some of the solutions that were being offered up. And I have to say, our child's in the Blue Valley School District, and we got probably the best support, the most robust support, and the most meaningful support from the school. who really didn't have the resources to do it, but made an effort because of our situation. So back to one of the original questions, beefing up our schools so they're ready to deal with these issues, I think is a huge part of the solution.
And I agree. It's a spot where there are eyes on the kids, they're not isolated. And it's probably another committee, but I think that was mentioned yesterday, in funding for schools. But we do ask more and more of our schools, and they are constantly stepping up. And if we can put more services in that school, I think we do reach a broader base. So I'm happy to hear a story of, the school being able to help. So thank you.
Absolutely.
Representative Carlson.
Thank you, Madam Chair, and thank you so much. It was a long way to get to a happy ending, but we're so glad to hear a happy ending. And my question is kind of different because, is this the first child that you have fostered?
Yes.
Okay, so when you went into foster care, did you intend for it to be permanent?
We were what was called in our kin. We knew the family. So we became foster specifically for the purpose of helping this child.
Okay, and the only reason I'm asking that question is that sometimes it's been thrown at people that, well, you knew that this was a possibility. You knew that this wasn't going to be temporary, but that's really not the case in your case. I mean.
Correct.
So I'm just trying to say that, no, you didn't just fully expect this, but this is what it came to, and so you fought for it. But sometimes I get a little bit polarized when people say, well, now you knew that this wasn't going to be permanent. Well, you might not have gone into it, but then due to circumstances, that's exactly what's best, and that's what it turns out to be. So thank you very much. Thank you, Madam Chair.
And Rachel, thanks for sharing your testimony with us today. I am wondering, in this long nine-year process, and I apologize if you already said this, but where along that line were parental rights severed?
They were severed twice. The first time was October of 2018? 2018, 17, 18? I know I should know, but I don't. They were severed, and Biodad appealed. And then the second termination was February 28th. And that's the one that stuck.
So the 19th would have been, in 19, that would have been 3 years ago. So you spent 6 years of that time just in the court system and.
Yes.
Okay. All right, I think that makes a difference in how long it takes to achieve adoption there. Other questions? Senator Faustido.
Thank you, Madam Chair. So with a follow-up on the chair's question, so in your statement of you were, and I don't believe I've heard that term before, you said you were you were
Non-related kinship.
non-related kinship. Non-related kinship. Can you elaborate?
In other words, the difference between, I guess you'd say, a foster is they usually don't know the family. I mean, they're given a child that they don't know the history and what have you. We knew the family, so we were what was called in our kin. So we were not related fosters. We knew the biological family.
Well, yeah, I can see your son is, you're not biologically related.
Obviously.
But, I mean, was it a longtime family friends? You went to school with them? You just knew them from the community?
Knew them for a while. Friendship. So.
Okay. Thank you, Madam Chair.
Okay, further questions? All right, thank you. Now we're done with you.
Okay.
Thanks a lot for being here. So next up, we have Megan Mansour. Good morning. Welcome to committee.
Thank you, Madam Chairperson Kincannon. Thanks for having me. I was joking earlier that I've been watching a lot of The Crown, so if I accidentally say Your Majesty or Your Highness, you're welcome for that. Okay. My name is, as Chairperson said, Megan Mansour. I am an adoption attorney in Wichita. I've been practicing for, gosh, it'll be 15 years in April. And I am very happy to be here. I'm very happy that you're taking up this issue. I practice solely in family building, as I call it. So I do adoption, surrogacy, gestational carrier agreements, and then foster care litigation. And that's exactly what we have been hearing from Mrs. Jones, who just spoke so eloquently. Thank you for your work and very well put. If I had a dollar, for every client that calls me and says such similar facts, I mean, 9 years may actually be the longest I've heard, but I have not even looking to do this work, just have phone calls from foster families that need some help aligning the direction of their case. And I think this is a very tough job, that you all have, and also that DCF has and the agencies have. I know you've heard a lot of testimony and you've heard from a lot of great people. I do think we can start with the basis that everyone has good intentions. So anything I say is not meant to be disparaging to any specific agency. You'll also know that I sometimes intermix the specific agency names because I work in a lot of different counties and they have the different contracts. So I tend to just say St. Francis for everyone, and that's not necessarily the case, but that's who I work with mostly. And I have a good working relationship with workers in St. Francis and supervisors and DCF workers. They also know I'm not afraid to go to court and fight about this. I've represented many families that have we've had a finding of no reasonable efforts, which I'm going to talk about, and gotten direct placement. I'm in the middle of 2 right now sibling split issues that are very similar to the DeHaven case that I believe is why you all are here. And it's kind of ironic because I typically tell my clients, we have to stay on this path and follow the trajectory of the court and the process. And that, sometimes getting a lot of publicity isn't maybe the most effective route, but I am very happy that this is what they have done and that you are listening, because we certainly can do better than what we are for our kiddos. With that, Madam Chairperson asked me to talk about the process. And what I hope to do is some of this will be review, I think, but I'm going to go through kind of a sync case from the beginning. And feel free, please, to ask questions throughout. I think it might be better than saving everybody to the end if you do have questions. If you don't, that's totally fine too. But when I look at the cases that I have been hired to litigate in foster care, it mainly falls into the 2 kind of controversial categories, I think, that look at kinship or blood over the foster family and what that looks like in attachment. And then also the idea of a sibling split, which is, I believe, what is happening, or at least part of what's going on with the DeHaven family. I think that one thing that I hope we can do in the system is not pit those against each other. That I think the foster families, as you well heard, have many concerns, and those should be given a voice at the appropriate time. I also do see where we have to constitutionally protect the bio parents, and again, that is a hard job that the agencies have. But most of my experience is past termination of parental rights and where we're looking at placement and reasonable efforts by the agency and DCF. And so I will probably throw in a few case examples as we go. One thing I was going to say is, because I don't have it in my presentation, and one of the representatives asked about the Office of the Special Advocate, I am happy to see an additional third-party governing body be instituted. I believe that I had the first case that they took up to investigate. And we had, I think, a fruitful or a thorough investigation, and we had a conversation with DCF and all the workers. My one thought on that, and again, I just didn't want to forget since it's not in here, is that they made a finding, although maybe the technical term is not finding, but in their results, they found that the agency had made mistakes and had not proceeded in the correct way. However, it didn't really make a difference. We still had to go and get direct placement and fight a big fight about subsidy. And that is, I hope a lot of you know, and I can talk about it, subsidy is a huge deal for kiddos getting out of the system. And when you have direct placement, which is what I'm going to talk about, that is not a foregone conclusion. And when I'm talking about subsidy, I mean there is a financial monetary amount, but there's also the medical card. And that is huge for families. You don't know exactly what medical issues your kiddo may have in the future. And that can be really prohibitive, or yeah, it's prohibitive to placement if you can't have your medical card, for sure. Okay. I've been told to wait till it is up on the screen. There we go. I was thinking of one case, again, I'll keep doing this, but one of Senator Gossage, I think, asked about the kiddo that hadn't ever met the child, their foster child that hadn't met the family that they were hoping to or working towards reintegration. I have a case that we just got good news in yesterday. The child has been with the foster parents for 4 years. She is a little 4+, so basically her entire life. They did an ICPC for the grandmother that got denied, and after 3.5 years decided that they had to do an ICPC, so out of state, for the great grandmother, and the agency said that we still have to do this. And I argued to the court, you don't have to do this. That relative had never met the little girl, never met her. The ICPC got denied just as of yesterday. So now the agency will not have to, hopefully they can waive the best interest staffing and move forward. But that is not uncommon. And I think some direction or a different way of looking at that at some point, if a family member does not have a relationship with that kiddo, we don't need to be doing ICPCs for 17 different family members that have never met the kiddo. So that just popped into my brain. Okay, so we're going to talk about the phases of sync. I'll try to make that fast. The players, parental rights, interested party status, you heard a little bit about. Reasonable efforts, which is a really huge one as far as what DCF is required to do. The sibling split specifically, and then the status of appeals, because that's also certainly well within your ability to take a look at. Okay, I think many.
We have a question
Yes.
already. Senator Pascudo.
Thank you, Madam Chair. Thank you, Megan.
Yeah, Megan's great.
Thank you.
Your Highness will work too.
Interested party status.
Yes.
So I introduced that bill. I introduced that bill to become law. My question to you regarding that, so I somewhat agree with the statement you just made. However, do you find this in the courtrooms? I hear from a lot of grandparents who are interested party. Mm-hmm. And in the law, in the language, I believe it says, so if that interested party, if the courts know how to locate them, if that interested party has shown interest in seeking custody or a relationship or visitation with their grandchild, mm-hmm. that they would then receive a letter from the courts or the attorneys or whomever, DCF, whomever, or the contractors. And I'm finding that they don't. Have you, because I've been in the courtroom where I've had to actually say this grandparent did not receive a letter and the grandparent was able to prove that they had submitted information to the courts of their whereabouts, their address, their name. Have you found that to be the case in any of your hearings? Thank you, Madam Chair.
Thank you, Senator. So I guess there's a difference between identifying a grandparent and locating them, which is different than immediately or granting interested party status. So the statute does say a grandparent shall become an interested party. However, that has to be requested. You have to go to court and request that in some fashion. You don't have to have an attorney to do that. I've certainly had relatives and foster families make that request in court, but a grandparent has less of an issue with, as we heard Mrs. Jones talking about, the idea that they may be circumventing reintegration, and that's why interested party status is difficult for foster families, and I do want to talk a lot about that. I do think maybe the bigger issue that you're addressing is the work to identify kinship and have them involved as early as we possibly can. And I do think, despite at least stated efforts, we are not identifying family as soon as that we need to. And when a grandparent is identified, kind of to her point, what's a reasonable amount of time to determine if they're the appropriate placement or not? I have a case right now where the kiddos, it's a sibling split issue, but now also kind of a grandparent issue. The kiddos have been, it's a situation where there were older children in the system and then a baby was born. They are all with the same family now, although the older children were like 6 and 8 when they came into custody. The infant was not subjected to the same trauma, but they are now in the same home. That's a difficult placement. The grandmother in that case has been involved. She was determined for the last 2.5 years not to be an appropriate placement, and there is documentation of that. Well, now my clients have decided we can't take on the behaviors of the siblings together. And I am not a therapist. I joke I play one in court sometimes. But they have had trauma, and I think that is what is causing these behavior issues. The little brother has not. And the family has decided we can't adopt them, but they would like to adopt the brother. And now all of a sudden the agency is saying, oh, grandma's appropriate. She can have all 3 of them, despite significant issues with her, and God bless her, but simple housing issues, the people in her home. It was extremely documented why she was not appropriate for 2.5 years. And to her credit, she has been involved. The kids are having major behaviors after they see her. It's the same home that they suffered trauma in. I think we need to take a look at that. And I have concerns when, and the guardian ad litem does as well, when we have determined a family member is not appropriate and then all of a sudden they are. That was a tangent, Senator, so I apologize. But the grandparents should be engaging early and often so that we can decide, are they the appropriate placement? And if they are, let's get them there. So then the foster family doesn't have to be 2 years down the road.
And Megan, thank you, Madam Chair. My specific point was this. So I have seen factual information to whereas the grandparents initially were notified and engaged, and then as the procedure moves forward to like adoption or permanent placement, that grandparent will just accidentally hear that there's a court hearing, and they have proved to me and others where they would call the courts and say, when is this hearing? They were never given a date. They are not receiving notification in the mail that this hearing is taking place. They're not given in writing, which the law says that they must be given if they are denied, they're not getting those things. The courts are not doing what the law has
Determined, yeah.
for them to do. And I was just wondering, because I hear that a lot, that when we talk about interested parties and we haven't seen them for a while, there are some that are actively trying to engage, but the documentation states that they're not, because the courts is not doing their job. This is a mess, Madam Chair. But thank you, Megan. I'm good with your answer. You can go on.
I mean, I've had cases where I was granted interested party status and then wasn't getting notice and wasn't getting, there's some logistical things with that takes some time, and I've had to, call and say, I need that court report. I'm an interested party now. And I don't think that is untrue or happens. But what I tell people is, this is a little bit on the flip side of that. If you are a family member and you want placement, you need to be breaking down doors until someone listens to you. I tell family members that if you're out of state, you need to move in state. I am sorry. That is the reality of this situation, because these children, if they're not with you, bio family out of state, they're bonding with someone else. And I know that is a very hard, tough situation. I had a client, and it was a aunt and uncle, and the kid was in California. And I said, think about this. The foster family is caring for this kiddo. You want to be a placement, but if that takes 2 years, you really got to give it a lot of thought. Is that what's best for that kid at that point? I think that we can have the best of both worlds and maintain a family relationship, and also not have to have that attachment disruption that happens after a child is extremely bonded to the foster family. We should be moving kids to bio family. It's just that the bio family can't call, the clerk one time and say, nobody called me back. You have to be the squeaky wheel. And I am a broken record on that when people call me. Like, you just can't take no for an answer. Okay, let me see where we should go from here. Okay, that we've kind of already talked about. That's just the overview. So, temporary custody. So the court and the district attorney is going to file a case for ex parte, an order saying we have reasons to believe that this child would meet the definition of a child in need of care. They file and get an order to remove the child, put the child in police protective custody up until the temporary custody order or the hearing. So you have 72 hours, the court does, to set a hearing so that the parents can go to the temporary custody hearing and be heard. I will tell you, in practice, bio parents don't request evidence. So that means they're going to court and they're saying they do get a court-appointed attorney, or they have an attorney, but the vast majority of them are acknowledging that there's probable cause that this child is a child in need of care, and then the case proceeds to, they set an adjudication hearing. Adjudication is, I don't know if I have the definition up there, but that is just the court's determination that a child meets the definition of a child in need of care. So that is, they're not getting their needs met. They may be, it's likely that if not removed, they would be harmed. Those are all very clearly in the code. Adjudication is a higher standard. That is clear and convincing evidence. That, again, most bio parents do not request an evidentiary hearing. So, I mean, their attorneys don't call witnesses and say, prove it, DA. What am I doing wrong? What's going on with this child? I would say a lot of cases in Sedgwick County have to do with substance abuse, unfortunately. So that may be more black and white. If you have a positive hair follicle, you may not want to take it to, have evidence on that. Disposition.
Representative Ousley.
Thank you, Madam Chair, and thank you for that. And I hate to interrupt, but what would be evidence if a parent were to bring that, prove it DA? What could they bring forward? What would the DA have that says this, other than, a complaint to the call center?
Well, once there is a DCF call that says, I have concerns about this kiddo, DCF will do an investigation first. So they've had a caseworker go out to the home and meet with the child. some of this, somebody else here is probably better versed to talk about this specific detail, but they're going to have information that they put in their petition for the SINC finding, the child need of care petition. So if a parent was going to have evidence, they might testify themselves and say, that's not true. You know, how you would disprove an allegation of drug abuse if you are positive. Maybe, I mean, I've been surprised on some cases that there are some situations where a script may test positive in some legitimate thing. They may have a doctor come, testify or something like that. So it would be family, friends, themselves. It's rare, and that I'm typically involved, like I've said, for foster families, but that is what I would anticipate that some just general idea of what they might ask for. But I do always think, take it to trial, and that kind of goes back to what the foster mother said, or adoptive mother. If it's a foregone conclusion that this child's going to be removed, a lot of these are not really put to use in practice, and that's between the person and their attorney, So I can't speak to all of that, I guess, but it is rare. So disposition, I was thinking about disposition, getting ready to speak to you, and I was thinking, well, it's not that big of a deal. It's where the court grants the custody of the child to DCF. Potentially at disposition, the court could choose someone else. So I've had cases where I have been the private petitioner in a child need of care case for grandparents. And then I've asked the court, don't put legal custody with the secretary, grant legal custody with us, the family. That is a really big deal, as I was thinking about it, because disposition, legal custody is who is in charge. But I mean, I don't even think I could say 99.9% of the time. It is always the secretary. And then you're looking at, as we've heard, the goal of every child need of care case is reintegration. So that is really frustrating for foster families. And I just had a call this week, and I was like, I get that you're frustrated. That's just how the process is going, and you have to wait for termination. And I didn't hear a lot of problems. It's just, I get it. It's, hard. So then if they're not working the plan on termination, then reintegration. Yes.
Senator Gossage has a question.
Thank you. A quick question. Could you, for our purposes, just define adjudication and disposition on your little chart?
Yep. And actually, I brought them, so I can just read it for you.
Thank you.
Okay, so adjudication is under KSA 382250. District court determines whether the child is a child in need of care. So it's that simple. I could pull it up, actually, in my book. Everyone needs one of these if you don't have one. The whole SINC code at your fingertips, although I like the old one better. Okay. Petitioner must prove by clear and convincing evidence that the child is a child in need of care. And then you would go back and look at the definition of child in need of care. At 2201 is rather extensive. 382201 defines child in need of care as a person less than 18 years of age at the time of filing the petition or issuance of an ex parte order and amendments who, and then it goes on and lists 8, 9, 10, 11, 12, 13, 14, many things that would meet that definition. Disposition, district court enters an order that addresses the custody and the case planning of a child adjudicated as a child in need of care. So you determine the child meets the definition of a child in need of care, and then the court says, this is the custody of the child, because you're removing the child from the parent's custody.
And so then that is where the court would determine, in most cases, that the state would be the guardian at the disposition stage?
Yes.
Thank you.
Exactly.
So we have a couple more questions
Yes,
right
sure.
now. Senator Faustido?
Thank you, Madam Chair. Megan,
Yes.
you mentioned that if hair follicle testing came back positive, then there was no reason to look into things to just move on. Madam Chair, I think I've stated this before in these committees over the years, and I disagree with anybody in this room and on this issue because, as I said, I have 3 different cases where 3 black women, African-American women, which I'm the only one in this room, and my hair is different from these 3 African-American women that I personally know, that I went to grade school with, junior high school with, high school with, and the yearbook pictures prove, and recent pictures with these women prove that their hair is still the same length that it was when we were in junior high school. I don't know why, but their hair just doesn't grow as fast and often as mine does. Even if I cut it, Madam Chair, it just keeps growing. And, I'm like, maybe I could get a husband and they could climb up on my hair. But that's
you mean,
not,
may I interrupt you, Senator?
that's not worked yet. But these women who have actually finally, one did adopt her own grandchildren after getting an attorney, which was costly, and legal aid in Wichita, Kansas, legal aid, they helped for a while, but she had to really prove that she had not smoked marijuana since high school, some 40 years ago, I'm telling my age, but
Was that a situation where there wasn't, they
but
couldn't
yeah,
get enough
I just
hair?
wanted to say that.
Is that they couldn't get enough hair to do the test?
I just wanted to say that, Madam
Okay.
Chair.
Okay.
Representative Ruiz.
Thank you, Madam Chair. I was going to ask Megan, when we get to that parental rights, I don't know if we're there yet. And there's choices is reintegration or termination. Is there ever a third choice? Do other, and how is this determined? Is this state, I know it's in statute, but do states have different statutes? Is this a federal requirement?
No, well, I mean, do other states? I don't think that, that's an interesting question. I mean, Kansas is subject to ASFA, Adoption and Safe Families Act, and those have requirements for findings. You have to have a permanency hearing every 12 months. I don't know. I can't state if other states have a different way of looking at a third option. I mean, Kansas, there is a very rare third option where you can have a finding of unfitness and not terminate rights, and then that is a permanent custodianship. The child is still removed from the family or the bio parent, and for all intents and purposes, they aren't exercising parental rights. That's extremely rare. I did it once because I do crazy things, but that was a good compromise for the parents. Their rights weren't terminated, but the grandparents became the permanent custodian of the parent. So I think those are pretty,
Set in stone?
yeah, clear paths. Like you're either getting the kids back where they need to go or you're trying to make a plan for placement elsewhere.
I was just curious, and where do we get the book?
Well, yeah, the court is where I always get it. But I'm trying to think, I think it's the judicial, oh yeah, here we go. Office of Judicial Administration, Chief Justice Marla Lukert. So maybe you
We'll
can
have
all.
them here later.
Oh, good, there we go.
Yep.
It's very helpful.
Yeah.
Yep.
So at this point, we are slowing you down to
Okay.
a snail's pace. So let's hold our questions now. We've got some space here by the slides that you can jot them down. And because I think as you talk, you might answer some of the questions.
Yeah, that's a good point.
So,
Yes.
yeah, let's hold our questions.
Thank you, Madam Chairperson. Okay, so the players, I think this mainly goes without saying, but there's a few points I wanted to make. So we have the judge, all the attorneys and DCF. I was thinking about an analogy that isn't great, but if you're driving a car, it's like the judge is maybe the traffic laws and the policeman that might pull you over. The attorneys are kind of the person driving the car, and then like DCF and the contractors are like the other parent in the car, which is usually me, that does all the hard work. You're like, quit kidding your brother, and the kids are back there and you're telling them what to do, and someone drops something and you have to climb over a seat and help them out. So the kids and the bio parents are like, when do we get there? So the court surface officer is not something in every county. Sedgwick County has them. And I thought I'd just skip to this because when you look at the breakdown of the numbers, Sedgwick County obviously has a disproportionate, and actually all the 5 counties have a disproportionate number, and that does affect in practice how things are done. And I'm sure you've already heard this, but things are not done the same throughout Kansas. And I practiced in, quite a few counties, mainly around Wichita area. But it's widely different based on the county, the contractor, the judge. A lot of that impacts it. I believe the judge has a lot of authority to make rulings as to the best interest of the child. We have case law. NRA DC says the court has the authority to review placement decisions. I think that falls into sibling split. I think that is obviously it's direct placement, but the court can oversee things. But in general, courts are waiting for that information from the contractor and the attorneys to make decisions on the case. Obviously, they're not doing the investigation themselves, but that they have vast authority to make rulings in regards to the best interest of the child. Now, by placing the child in the custody of the contractor and DCF, the secretary, the state of Kansas, and then whoever contracting agency has it, they are the ones making the specific placement decisions. And that includes reintegration efforts, looking for the bio or the kinship placement. And that's obviously a huge job and a huge part of what's going on here. I don't have DECA and KBC, and apologies, those are who I typically work with. The attorneys, of course, a bio parent, if they don't have counsel that they've retained, they get a court-appointed attorney. I will tell you, there's been some interesting small county situations where I'm like, where's the bio parent's attorney? But in general, that is the norm. You should have an attorney. You have a constitutional right that was already spoken of. Garden ad litem, as most of you know, of course, is the attorney that is appointed to represent the interests of the child. A garden ad litem is not what the child wants. It is what is in the best interest of the child. And garden ad litems have a really tough job, but I looked at the requirements. It's a judicial rule, Rule 110, that says guardian ad litems are required to interview the child and are required to have ongoing contact with the child, and that is mandatory. And I will tell you, that is not happening. And I have sympathy, and a lot of the guardian ad litems in Sedgwick County are my friends, and they're awesome, and their caseload is too high. But that's not happening. And maybe there is a caveat to that it says the judge can find good cause to depart from that. I don't know if there's just like a standing departure that I don't know about it, but I have to beg guardian ad litems to go meet with kids. I have a case in, maybe I shouldn't say the county, but a smaller county, and there was major issues, and that kid was reintegrating. It was happening. And I called the guardian ad litem like 3 times to say, go to that house. Just go see that kiddo at that house. At one point, I think he says he did see him. I don't know if it was at his home or not. But we could use some work on that piece of it, I'd say. Okay. So we talked about that. That just really impacts. So parental rights we kind of spoke about. This is kind of where foster parents are left, like, where do I fit in here? And I hear just so many calls, and people end up being my clients, where, it's like, we asked them to do this, the toughest job that you can imagine. Be this kid's parent, put them first, do everything that you would do for your own kid. But then, I hate to say it like this, but then just sit down and shut up. We don't really, there's too much going on, and I get it. I do understand the goal is reintegration, but there does seem to be maybe some middle ground where we can have more welcomed input by the foster family. And that's not the case everywhere. Obviously, I see extreme examples, but it's not uncommon that they really feel like they're not heard. A foster family can provide a report to the court before the hearings. I will tell you, I feel like they're largely ignored. Some judges, I think, read them, and others definitely don't. They're not ever asked in court, what is your opinion? What do you think, Mom, who has had this kid now for 3 years? It's not. So then they call me and want interested party status. And again, I'm not trying to gloss over termination of parental rights, but that's not really that's not really what I think we're looking at, and you're taking it all up. But my expertise is more in after that piece, because it is really hard to go advocate for a foster family before termination of parental rights. The goal is reintegration. When you have interested party status, what you're asking for is to have a voice and to litigate in some capacity in that case. Before that, it's hard to convince a judge that why is that necessary. I have advocated and got it in some cases in a limited capacity. You know, Your Honor, we're not trying to be involved in termination. We understand that is not our role, but we want the court reports. We need to be able to see what's going on with this kiddo. I will tell you, it's interesting. The agency always tells me, you as attorney, Megan, you get the court report, but you can't let the foster parent can't read it. I have to summarize that to them, which I haven't yet to kind of find the exact rule there, but I'm a rule follower. That's what I do, because that's what they tell me I'm supposed to do. But if you don't have interested party status, you're not even getting the court reports. Your workers may not give you any substantive updates on what's going on with your kiddo's parent. I mean, can you imagine that? I know you've heard a lot of people speak, so they probably have said this, but you're caring for a kiddo and you don't know anything about how long is this kid going to be with you? What's going on? Did they pass their hair follicle? And I think that's a disservice to the kid too, right? Because we do want our foster families to be supportive and helpful for the bio family. Look, kiddo, I'm thinking of my kids' names, but they're kind of hard and unusual. Look, Rami, you get to go see your mom today, but you don't want to be really excited about visits or where the case is going if you don't know that that's the last time they're going to see her. It's just, that's tough. And it's just, I get that that's hard. And I get that we have a system that is already overrun, and we can't have the practicalities of foster families all rushing to court and wanting to talk for an hour and a half. And I get that that's difficult. So I don't know that I have all the solutions, but we're asking these foster parents to do an impossible job. And I will tell you, maybe I shouldn't admit to this, but I have people call me and ask me about foster care versus private adoption. And I'm like, well, it is really hard for me to advise people to do foster care because of the cases that I get. I mean, I will tear up now. It's hard because you have to be ready to let a child go. And a lot of these cases, man, I'm a crier, so I saw go up at the same time as my kids. It's like, man, this kid is 3, my kid is 3. And to her point of the caseworkers, I don't know that you have to be a parent to do a good job, but man, my perspective is different now that I have 3 wild boys at home. Okay. So that's it. Even if you've had a kiddo for years, you may not be getting the information. We kind of went over this. Some of these are shall, some of these are may. Foster parents are may, even if they've had a kiddo for a long time. I will tell you, once rights are terminated, most judges don't have a hard time granting me interested party status, because then it's like, okay, now we get it. Things are different. Now we're looking more at placement. Excuse me. I have argued, lived with, the statute doesn't really read that it has to be the child's lived with them prior to, or I mean, yeah, prior. But that is in practice, because I've argued the opposite and was not granted that. So I think the best part is just that the court has the opportunity to grant anybody interested party status if it's in the best interest of the child. So at any point, the court can grant that or can restrict it later. One right that the foster parents do get is at 6 months, after you've had a kiddo for 6 months, and if the agency or contractor wants to remove the child, you are by statute required to get notice in writing that they're removing the child. And then you can request a hearing. That's certainly where I've been called in the past. I will tell you, sometimes you don't get that notice in time and they're coming to get the kid tomorrow. We have fought that before. Okay. So there's reasonable efforts on both ends that the DCF has to complete, reasonable efforts to reunify the family and provide the work and services for the bio parents to reintegrate. And then there's also the reasonable efforts that the DCF has to provide for finding a placement. And that is where sometimes we get to the option of direct placement. And I'm sure many of you are aware of that, but 382270 is actually I don't know if you, oh yeah, it's on the bottom. That's the statutory authority for custody for adoption. So that is the statute that grants the court the right to determine where is the child going to go, who has legal custody after termination of parental rights. So typically, I mean, again, it's 99.999% of the time, the court would enter a termination of parental rights, and then they're granting custody again into the secretary's into the secretary's legal custody for the determination of adoption. That, I don't have a slide on the best interest staffing, but once the termination has happened and the child is in the DCF's custody and agency to determine adoption, then the case moves forward on where are these children going to end up. And the best interest staffing is a meeting of the professionals that looks at who is going to be the adoptive resource for this child. When, for whatever reason, a family, I mean, anybody can request direct placement, but in my experience, it is when I have requested it is a foster family is BIS, term we use, is considered in the best interest staffing, and someone else is considered, and then the foster family is not chosen to adopt. So then, you know, they call me and they're desperate. We've had this child for, 3 years, and they're going to remove, one case I had in, I think Kingman, a family had a kiddo for 3 years. I mean, think about that, 3 years. He was fairly young. It wasn't like a teenager. And then a relative out of state became involved. They BISed that. My clients weren't chosen. We requested direct placement and lost. So direct placement, the good news on that one is that kiddo is doing okay, but they stay in touch with him, which is awesome. So for a direct placement, you have to have 2 findings. So when I say that, I mean, you're asking the court to remove the child from DCF and place directly with who you want to adopt. But you have to have, it's a 2-step process. You have to present evidence to the court that DCF has failed their requirement of reasonable efforts, whatever that can look like. I can give you examples. Honestly, I was thinking of cases, and I feel like the path to reasonable efforts hasn't been that hard. Again, I kind of cringe saying this, but it's mainly because they don't follow their own policy in the cases that I had. It's like you have the caseworker, well, we didn't do that. Well, I mean, and it's not for good intentions. It's hard. It's a hard job. But that I've had many findings of no reasonable efforts. It doesn't always mean that we get placement, but it's a two-step. So present evidence to the court that there's no reasonable efforts of what DCF and the agency has done. And then you ask the court, okay, court, you already put this child in the care of DCF for adoption. Remove the child because they messed up and place with our client or with the foster family. That is certainly a welcome outcome for families that are desperate to, adopt. But it's not ideal for a lot of reasons. If a child is removed from state custody, there is no guarantee, and I would say the majority of the ones I have successfully argued and gotten placement, they're not getting any adoption subsidy. And that can mean no medical card. Typically, I think it does. I'm learning more about the subsidy, and I think we can also do better on educating on that and advocating to make sure families get what they are actually federally required to get for kiddos. But there's no guarantee, and that's another fight. And, this is costly. To pay me to fight about this, it's costly. I mean, I try to do some pro bono work in this area because people break my heart, but it's burdensome on so many levels. In a lot of those direct placement options, I think it's worth saying that the foster families that I represent and how I feel personally about it is, again, you really can't have the best of both worlds. The DeHaven's child can know the other kiddos. It's not a zero-sum game here. We don't have to just pick one or the other. I have represented many families who I know to this day still see the siblings. They do. And I understand that the guardian ad litem or the district attorney or whoever is concerned about that there's no way to guarantee that. But when the option is removing a child who has, in some cases, never had any trauma, they've never had an attachment disruption. I think the child welfare system, we can all agree that the fewer attachment disruptions bond to your caregiver, especially a primary caregiver, the fewer the better. So if we can prevent that and still have that family connection, we should be looking for that. And I know there are speakers later today, they're going to talk to this, I hope, but one thing that I have been asking DCF for is I really would like numbers and data on outcomes for kiddos who are with their relatives, who are going, because they tell me, and I've heard many testify at court, this is what's better for them. It doesn't matter. And I don't mean to be downplaying it, but I mean, basically kids are resilient. They're bonded, they'll rebond. Well, don't tell that to me for my kid. I mean, it's a little shocking, some things that I've heard testify. And I'm not an expert on attachment, but I have heard many testify who are, and that it is not an if, it is what damage is that gonna do to that kiddo. I have a case right now in another county where a kiddo had been with my client for 18 months from the hospital. Older kiddos already in the system, never placed together throughout the case. She had special needs, the young one. My client is foster mama of the 18-month-old. Family members, they're half siblings, which I do think is worth saying here. The relative of the half siblings who are older want to adopt all three. It's not a relative to my kiddo. It's the relative to the half siblings, okay? That's fine, it's still a relative. She will embrace getting to know them. The agency refused to include my client in the best interest staffing because there was no sibling split. And I asked the court to order a sibling split, and it worked. The outcome of this case, I'll get to it, but the judge didn't order it at the time. She said, no, you're ordered to consider foster placement of the 18-month-old. Well, then we attend the BIS, and I argue, and I'm like, we can pretend all we want, but we need a sibling split. Those kiddos placed with that family, only 6 months at the time of this whole argument. So my argument at court was, we don't know their outcome. I really hope that they do great with that family, but we don't know. They have had trauma and abuse, and they're not through the honeymoon period with that family. I got word a couple weeks ago, so we got a sibling split, and the agency decided to leave 18-month-old with my client. We got news right after that the family with the 2 older kids disrupted. So we wanted to move the 18-month-old from my client, who had never had an attachment disruption, move her out of state with siblings she had never been placed with before they had even been there a year. And then lo and behold, there's a disruption. That is heartbreaking for those kiddos. I don't know the details, but what are we doing here? If the agency wants siblings together, they need to be together during the case. I cannot understand letting a case go for 2 years. Again, I think kids should be together. I do. We can start there. But I do not understand letting a kiddo be, bonded and, attaching to a primary caregiver without another one, and then saying, nope, sorry, you don't know your siblings, your half siblings, and you don't even know that relative, but you're gonna go there. That's hard for me. Okay, so sibling split is kind of where that comes, and it's also where, and I'm sure I'm just gonna keep on talking, but sibling split is where all of these kind of mesh together. What's the court's authority, who's deciding it, and how does that impact a best interest staffing? I mean, you've heard my example where, and that's happened more than once. If you don't have a sibling split, no one will be considered in that best interest staffing for adoptive placement who is not saying yes to all the children. So that means sometimes you're not considering a family who's had custody since birth for a kiddo. Right now, let's see if I have this. So here's the factors in a sibling split, and I think these are great factors. I 100% agree with that's what we should be looking at. That would give us more information on when we should be looking at a sibling split. But a huge one is the shared history and trauma. If kids were removed from a home and they share all of that and they can do well together, then their shared history. If a child was born later in the system, I don't know that we should be treating them the same, because lucky for that kid, they didn't endure it. And maybe that's because that is one of the benefits of these, cases. Obviously, we hope that's right. So you can read those. They're logical and well put, I think. When you're looking at the authority of this, right now, and I'll tell you, since I'm practicing, a sibling split the way that works has changed, and I might get it wrong, someone can correct me, but right now it rests, from my understanding in a recent case, it rests in the contractor. So it's one of the agencies. DCF can be involved and they may give input, but it's really just determined. It used to be that I think that the agency would make the request and DCF had to approve it. Now it's staying at the level, and I think in general that's been a recent change where I think the effort is to keep some of the decision making with the people who are living the case, so it's not a glass house of DCF overseeing things in the BIS or in the sibling split. I think, which is good, but it's all very intermingled, so it's hard to determine some of that. I think 100% the judge can order a sibling split. The agencies don't agree with me on that. But it is very clear the authority that the judge can determine best interest and that oversees placement. And if you can give a judge a decision of, judge, do a sibling split or have an argument for a direct placement and risk the kid not having subsidy or doing all of that, I think it's a better option. And again, I've just not seen the data to show the outcomes are better for kids that have all suffered trauma, that they should be adopted together. But I would like to see it. I also think we won't have, I feel like that data is hard to get because in my experience, which is anecdotal, but families who adopt kiddos in a more direct line are more apt to then find other family members. And what I hear from DCF is we have disruptions where we have kiddos that can no longer stay safely in homes of adoptive parents. And that is hard and troublesome. And what do you do? I mean, I've had 3 calls in like 6 months of foster families with teenage kiddos, of course, when everything is very hard, mental health issues that have just gotten out of I always say the acronym wrong, but a PRFT or just like thank you, you guys know. They couldn't be home, they had to go into a hospital, and they have nowhere to go. The parents are worried that the kiddo will hurt their other kids in the home. And someone in the agency is telling them, if you don't take this kid, we will make sure there's a criminal case against you. That is ridiculous. We are all trying to do the best we can. These families call me in tears. They have paid thousands and thousands of dollars to find out-of-home placement for these kids all over the United States. If there's anything that we need to fix, it is what can we do for those families? Because they have nowhere to go. And there's a place in Augusta that was doing some great stuff. They're revamping. People are desperate for that. And here's the thing. We don't know what these kids' outcomes are when they're young. And it gets worse as they get older. I know you've heard all that, but it's devastating. I had a client call that we did help find her a safe place, and I think she did well there till she turned 18. Like, that's enough, right? Good luck, you're 18. And they cared. I mean, they're desperate. They adopted a sibling set from out of state, and they were like, I'm making up the ages, but like 6, 8, and 9, I don't know. They had suffered severe trauma, these kids, and the adopting family did not know it. I mean, I think you can assume something, but they didn't know the extreme. All 3 of those kids at some point were not safe in the home. They had tried to commit suicide. They had tried to hurt others. I'm sure they had a reactive attachment diagnosis. If you don't have someone talking to you about RAD, please have someone talk to you about reactive attachment disorder. And that dad called me and said, if these kids had been adopted individually, we might have been able to save this. And this wasn't a family placement, right? So they had a sibling set. We might have been able to help one of these kids, but putting them all together in the same home was throwing them in a river with no life preserver. They drowned each other. And that is horrible and gut-wrenching. But I just think we're really simplifying the trauma and the impact of trauma on kids later. And it's not, a family who loves you is great, and to me, blood is something, and I don't want to, but it's not everything. The status of appealing these, as I'm sure you all know, anything after termination is not appealable. So NAC, and then a case after that just was cited this year, NE, confirmed that these findings, so a direct placement finding, or no reasonable efforts finding and a direct placement, you have nowhere to go if you don't win at the district court level. Is that good? Is that bad? I don't know that I'm here to tell you one way or the other on that. It provides certainty, and some of the kids, we do need that. But you probably well know this, but both of those cases came it back over to you guys and said, well, this is what the legislature intended. If because of the way the statute is written, it states that it talks about termination, and then after that, nothing else is, after a placement decision. So that would be, maybe up to modification. I don't know that a 2-year appeal period for a, 3-year-old is the right decision. I don't, but I filed a writ of mandamus to the Supreme Court this year on a direct placement decision, and that wasn't successful. So I don't think that's like the highest thing you could ever try to do, and it didn't work. So they're really stuck right there. If we could fix the underlying issues, we wouldn't have to get to that point, which I know is just a simple task. Okay, I've been talking about my cases the whole time, so I will see what you have for me.
All right, we'll open it up to questions. Senator Gossage.
Thank you so much for this testimony. It's very helpful. I actually had a conflicting committee that I needed to go to, but this was so compelling that I stayed.
Thank you. It really
In
deserves your
the-
attention.
Thank you.
Not me, but the kids.
Under the interested party status slide, it mentions close emotional ties and also fourth degree relative. Would a child care worker who has been with these children daily for 3 years be considered a close emotional tie?
Well, yeah. I mean, I don't know. Like in the context, I think the difference would be when you're going to the court and asking for that, you do need to be ready to show, in my experience, why you need interested party status. So if you're typically, like I've said, I advise clients that really, I don't typically ask for interested party status until rights are terminated. And then at that point, we don't need to make any bones about it. We want to adopt this kid, and we want the case, we want the court reports, and we want to be able to come to court and know what's going on and advocate. So I think you may meet that, close emotional ties, but I think you'd have to have a goal maybe in the case that would be compelling for the court.
So if the parent has terminated rights and the foster care family, for whatever reason, could not adopt, but then there is a child care situation
Oh,
for
yeah.
that 3-year period.
Oh,
that would
yeah,
make sense.
absolutely. Yes,
Okay.
yes.
Also, we heard you say that we're not seeing the visits from the guardian ad litem. This is not the first time we've heard this. We hear this over and over. Yet, we were given this yesterday, showing a green light for child worker visits occurring 95% of the time from all of I'm sure they'll address this, the department will address this later. But can you give me an idea on how often you've heard that the visits are not being done?
Well, I think that may be a different standard, that is the caseworkers, which I don't know that those are happening either, if I'm being honest with you. Certainly the case that I have, they're not. That was one of the no reasonable efforts. You haven't had a caseworker there in 8 months. But I think that is worker-child visits where each kiddo has their own worker and they're supposed to go see them monthly. So that's probably happening much more often than the guardian ad litem, the attorney going to meet. Those wouldn't coincide from my perspective, yeah.
So then perhaps the department can address where that would show up in this chart, the GAL report or the GAL visits.
Yeah, I don't think that the DCF takes any ownership over that.
Okay. Do you know
That
who
that's
would?
independent, the court would.
Yeah,
Okay.
we'll hear later from.
Okay, oh, good. All right.
But I would be very happy to hear about that, yeah. And if I'm wrong, I hope I am.
All right, thank you so much. I'm sure the rest of the committee has many questions. Thank you, Madam
Thank you,
Chair.
Senator.
Representative Ruiz.
Thank you, Madam Chair. I was wanting to ask a question. It's around the interested party status. And I don't know, you probably know this, maybe, that other states have a foster parent bill of rights. And, certainly I think we need to look at that also. And I'm wondering about what that does with this interested party status, and how does it mesh?
Well, I can't speak to other states' Bill of Rights, but I can make some assumptions and speak a little bit to what I think that might do. I think some clear expectations of what is a fair question or fair information for a foster family to receive from the agency, would be helpful for them. Because that's just a struggle that I talk with families a lot, which is, I flat out tell them, you don't have any rights. You don't. We can get rights when, you can get rights as interested party status, but that's not guaranteed. And again, the timing is really tricky. And I've had judges deny interested party status after termination. They don't want to hear from foster families, and they don't want me in there messing things up, So that's tough. I do think, I didn't look into that. I know like Arizona has done some new legislation on reform in their child welfare system. I know North Carolina, there's a Quad A attorney. I'm in the Academy of Adoption Attorneys, Assisted Reproduction, anyway, the National Group of Adoption and Surrogacy Attorneys, and there's an attorney from North Carolina, and I know he's always told me they put some of these outcomes for foster and attachment into, attach it to financing to their contracting agencies. But my concern is that the focus is definitely, and I would love to hear more about this, and maybe Ms. Armstrong will talk about it later, but I think they do have goal outcomes, or, kinship is preferred. And if there's one thing I would implore you, and that DCF implore, is that is not appropriate. What's appropriate is the best interest of each individual kid, because that is not the same. Some kids should absolutely be with their blood relatives, and some kids should not. So I'm sorry, Representative, I don't have a good answer for you.
No, that was good. Thank you. Thank you, Madam Chair.
Representative Humphreys.
Thank you, Madam Chair. Thank you, Megan, so much for being here. Really appreciate it. I just had a quick question about the authority, sibling split authority, and just the authority of, the judge. And that's something we've talked about a lot in the last, even yesterday and previously. So you mentioned that it rests now, it seems like, in the contractor, but it was with DCF. But was that like a definite, was that a trend? Was that a definite rule, regulation we're changing? What I'm trying to drill down to is, even statutorily, who does have the authority, and what discretion does the judge have in sibling split, but also just in other child placement decisions? Do they always have to just take the recommendation of the agency?
Well, I don't believe so, because I think the judge has the authority to, in Re MR says the judge can review placement decisions, has the authority to review placement decisions, or DC, I'm sorry, in Re DC. And you can read, the definitions and the intro to the sync code says the child need of care code the court must construe the code and apply the following in all decisions overseeing a child need of care case. Consider the safety and welfare of the child, make the ongoing placement and mental emotional needs their considerations, acknowledging the perception of time differs from adult to dispose of the proceedings, and there's many, many more. I wouldn't, it is accurate that the judge places a child in the legal custody of DCF, and then they make placement decisions. But those are reviewable by the judge. So I think the judge has the authority to decide, I'm going to order a sibling split. And I've had judges order sibling split. I've just also had judges not. And the last one didn't make a determination that the authority was there. It was just a different way to answer that. There isn't a case that's reviewed a judge's authority on sibling split. So that would be helpful, but we don't have that. And it's not, to answer your question too, Representative Humphreys, it doesn't say in the code, a judge can determine a sibling split, because a sibling split is the product of policies put in place by DCF, okay? But the best interest of the child is the ultimate governing authority, and the court absolutely can do that. And I didn't list all of these, but there's many cases that have looked at placement before NAC and said, and this is good, I'm glad you jogged my memory, the courts, the Kansas, across the street, they have said, you cannot only look at blood. You have to look at everything. You have to look at the best interest of the child. It cannot be an arbitrary determination of blood relative. And NRACC says child time. I mean, there's good case law. It's just that now we have no appeal path. So you argue that at district court, and if you don't win there, you don't have anywhere to go. So to answer on it, I mean, not that I wasn't trying to be straightforward. It's not in the code. The code doesn't say that, but that's because that's a term of art by, DCF, and I think it makes sense. But the thing that I have a problem with too is that, as I already said, in practical terms, they've already done a sibling split by placing them in different places. So then why are we acting like our hands are tied to determine the right placement? You've been saying that this placement was appropriate for 3 years. I get that we want the kids together. We'll put them together earlier in the case.
Yeah, thank you. Really appreciate you being here.
Thank you.
Thank you, Madam Chair.
So that appeals process issue, is that something that we should address, in your opinion, that we should address legislatively?
Well, that's a tough one for me because, it's either saying in the code, you have a right to appeal these decisions, or you don't. They've said clearly we don't. Saying yes does mean that you open up a lot of angst and timeline for kiddos that will be not determined. That's tough.
Because every one of them then is going to be appealed.
Yeah. My clients that we did that writ for certainly would have appealed.
Yeah.
So I don't know. Do I believe in the judicial process? It should go forward, and there's a reason we have the Court of Appeals? Of course. I went to law school, but I don't. For kids, that's hard. I think to be really upfront, we have so many problems. And some of the lawyers are probably going to kill me for not saying, yes, change this, it's appealable. But there's a lot of issues and problems to fix. And that's not a hard fix. You could change that code right now and say, and all decisions are appealable. I would want maybe some data
I would feel better about that if I had complete trust that every district court judge is educated and on the law and
attachment.
Yeah, and attachment.
Yeah. Amen to
Where am
that.
I? Senator O'Shea.
Thank you, Madam Chair. Are guardian ad litems paid?
Yes, they're paid.
How much?
Very low. It's a so that's through, and I'm really not the expert on this part, but every county does something different. And I do think that is a problem. They have a contract, and then, like in Sedgwick County, the parents' attorneys and the guardian ad litems have contracts, and then it's like you provide an accounting of when you go into court, and then it's a certain amount for what you do. You get paid on your task, which that's any job. At least I know that's the parents. I'm pretty sure that's right. I don't think it's like a set salary. It's like you get paid for what you do on each case.
We'll have an opportunity
Okay.
to have another speaker.
Yeah, I do think
address that.
we need more of them. They need better pay, and
Better pay would create,
better, yeah. And I
better
think
quality.
honestly, that's part of the issue with the casework. I always want to start, and I say to every foster family who calls me, they're overworked and underpaid. Recently, I've been getting kind of feeling like that benefit maybe generous, but I know it's hard to hire people, but we are there. It is the people fresh out of college that we're asking to do all of this. And that's tough. I think, and the turnover is crazy. She said she's only had 10 caseworkers for 9 years. I thought that was like, well, congratulations. Most people call me and say, I'm on my 16th caseworker in a couple years. I mean, that might be a little exaggerating, but many. So if we could have less turnover, and I think those workers need to be paid more. I hope that would help the quality of candidates. I'm really speaking out of turn here, but that's my opinion.
Senator O'Shea, were you done? Senator Falscadeau, did you have a question?
Yes, thank you, Madam Chair. It's kind of a follow-up on your point, Madam Chair. But Megan, you said that you work in different counties throughout the state of Kansas. Is there one thing that you would be helpful if all of the different counties, because I talked to some of the attorneys over in Sedgwick County and the differences when they travel. Is there one thing that would be helpful if it were unified or consistent in this area that you're speaking of today? Thank you, Madam Chair.
I'm trying to think of, I might have to think on that, Senator. I can't think of like one thing that's like, that's the biggest problem. I mean, I'd have to think. I can't think of like one exact thing. It's just, it's a different animal everywhere you go. And then.
Madam Chair, what I guess the point that I was making, and you can share later, is that I hear that there are so many inconsistencies of dealing with if you were dealing with the same similar case in Sedgwick County, and you go to another county, it's the outcome and the procedure is totally different. And you know, because I get calls from people I live in Wichita, but I get calls from Salina, Hutchinson, Johnson County, and it's just, you know, it's a similar case, but the outcome is totally different depending on the county. Thank you.
Yes, Senator. I think that's largely due to different case workers having different training or goals and how I think that's a boots on the ground problem or inconsistent, because that's what I see too. I just talked to a family this week that said, and I was like, are you sure that their kiddo was allowed a visit with a parent who the worker said was high? I'm trying to think of a better way to say that. High. And they let the visit continue because the caseworker was there to supervise. And I'm like, well, actually, Senator Falscadeau was the first thing I thought was, well, that would never happen in Sedgwick County. I mean, the crazy things do happen that those workers have to deal with. I had a call on a case a couple weeks ago where the mom apparently went into St. Francis high and they ran over the parking thing and all this, but they luckily didn't have that visit. So I don't know. I mean, I think that's a boots on the ground case management worker difference maybe, because it really is, again, they're the ones in control of the car. I mean, they dictate a lot of it.
We have a question from Senator Holscher online.
Thank you. Thank you, Megan, for being here. I want to go back to the sibling split, and I know that there have been a couple different questions on it, but I just want to make sure I understand correctly. It sounds like because it's not defined in code, we potentially have various judges who feel comfortable making the split, but then others who don't. Is that correct?
I would agree with that.
Okay.
Yes.
I just want to make sure I had that, that I had that straight in my mind. Thank you.
Yes. Thank you very much. Good to see you.
You too.
For a while I was like, yeah.
Other questions? Let me make sure I got mine answered. On the guardian ad litem, it's knowing what we've talked about and what we've heard in the past, is do you, in your experience, is the judge committed to the recommendations of the guardian ad litem and the caseworker? I mean,
Yeah, the guardian ad litem holds a lot of weight, and it's really as good as it's only as good as your guardian ad litem. Unfortunately, some just read the case, read what the worker gave them, and, say that to the court, and there's not much else. Again, I think to defend my, some colleagues, I think a lot of that is the amount of casework the amount of cases they have, and they don't have the ability to, and they are dependent upon the case team largely, even the best ones. But I would say in most counties, the guardian ad litem is hugely influential and holds a lot of weight. Now, that fluctuates and it's different. I mean, there's some variation, but when I have a case, I'm like, well, what does the guardian ad litem think? Because I want them on my side. And certainly one I lost, a heartbreaker, a couple years ago, the guardian ad litem was staunchly opposed to my clients adopting. And that was really a big part of, I think, the judge's decision-making. One thing that, since you're talking about guardian ad litems for a second, that I think is something that should be considered, which comes into place with sibling splits, is that I feel like we have conflicts of interest with guardian ad litems. They're charged with representing a whole sibling set. It is, I've argued for it and never received it, where how can you have the same interests for a kid who's been over here with this family for 3 years and the sibling set has been in 15 placements because they've got behaviors? How is the guardian ad litem to advocate for both interests? I mean, she could go in and say, this kid's best interest is this, and this kid's best interest is that, but as a group, they're not the same. And I think most say they are and say, well, they have to be together. That was the issue that I asked the Supreme Court to look at, but they didn't want to. So I do think that is an interesting issue, and I don't know. I mean, on some cases, it's like, well, the devil you know is when the devil you don't. I don't know, having there's the judicial, efficiency and having like 15 attorneys in every case, but maybe on the tough ones. Maybe on the cases that have a direct placement request, or we know the kids have been in separate homes and we have families who are going to go to battle. Maybe that's when we need to, when their interests are not aligned, you're putting the guardian ad litem in a really tough spot. Because
but you don't think the guardian ad litem can see the separate interests?
Well, I mean,
I feel like
I guess it's just that it's certainly very nuanced, and I think they're capable of it, and maybe that's, on that case that I requested it for, it was like, no, I see, and I just think they all have the interests are the same.
Yeah.
But that's not the same as,
Well, it'd have to be a good guardian ad litem that has, that's engaged
that.
and.
Yeah, I mean, that's easy for me to say on that case because I wanted one outcome and she wanted the other, and the kids were in different placements. But I guess in general, can we agree that kids' interests are not the same if they haven't been in the same placement for years? It sort of seems like that's kind of clear.
Yeah.
I don't know. That's just a...
So I just want to say that we know that the guardian ad litem has a big caseload and that they're underpaid. That's given, but I think that's giving them an excuse too. Because if they may have a big caseload, but we're hearing months and months, or sometimes never interviewing that child. They don't even know who, they come out in the hallway and call for a child and they don't even know who they are. Yeah, we need to do something about the pay and the whole situation, but if they're constitutionally required to make those visits, then they need to be doing that. Let's see, I had another question here. I think somebody else asked it. Do we have any other questions from the committee? Yeah, oh, sorry, you told me that before. Senator Baumgardner.
Thank you for being here, Megan. You know, as we look at this, what are the problem or what are the pain points? So we talked about guardian ad litems, and we've already established from what we've heard that many of them don't know the children or the situation. In that case, they're influenced by whatever the agency point person as well as the contractor point person are saying. And they're looking from the lens that seems to always be influenced by their policy, particularly with regard to siblings. Two policies, siblings and reintegration. So when you have an agency and then the contractors that they have hired, where their lens is no sibling splits and reintegration, that seems to be an overwhelming, two overwhelming hurdles when we're looking at the best interest of the child. And then I look at the testimony just that we had today and that we've had repeatedly, where the foster parents have no say, have no input. They are in a position of, if you're not an advocate, then you're essentially the enemy of the agency. But we have that interesting thing that you spoke just briefly about, and that was the BIS, the Best Interest Staffing report. So when a guardian ad litem who is connected with the children and is aware of what's going on isn't listened to or isn't a part of that meeting, when we have grandparents where you indicated grandparents by statute automatically receive interested party status. We repeatedly hear from grandparents that they have no idea that they, one, have that status, and no one in the system is notifying them. No one is telling them, you have best interest status. It doesn't mean that you are wanting necessarily to adopt the child or take guardianship, but should have an active voice as it moves forward.
May I
Jump
correct
in.
one thing? I do think
Yeah.
you have to request interested party status. So a grandparent has to ask the court to grant that.
It says grandparents shall automatically receive.
But it's at the request at
At the
court.
request. Okay.
Yeah.
So
So
then-
but the bigger point, excuse me for interrupting you, Senator, is that grandparents really should be, if they want to be active in the case, the grandparents are only one person removed from the parents. So where I think we have to search far and wide for relatives that aren't the grandparents sometimes, and that can be difficult. In theory, you would think that the grandparents really could easily be involved in the case. And should be. And I mean, the grandparents aren't always the right place, but if they want to be involved, they certainly should be. So I think there's some definite improvements for that communication, sure.
So no one's taking ownership of that communication. So again, it gets back to, with that direct placement of the judge, what proof do they ever really receive of what's the best interest of each individual child? Because we've heard repeatedly that caseworkers are cutting and pasting prior reports, and those are brought as to current reports. We have gals that have never met with the child or the foster parents. We have all kinds of emails from grandparents. They can't even be in communication with the child that's in foster care. They can't even get that arrangement. They are completely boxed out, if you will. So how is it that the judge is ever going to, with knowledge, make a determination an appropriate determination as far as a sibling split. Again, where you have that layer upon layer of this is our policy, even though it's not law. But we know of all kinds of different pockets throughout the state where judges, they're not going to rule against DCF. They're not going to rule against a contractor. Who is there in the courtroom to defend the best interest of the child with accurate, relevant information?
Well, I think it's, maybe the question is more powerful than any of the, answers. I think sometimes they aren't, and it's a difference of the agencies think they are, and I think there is, sometimes that is the case, but I see your point, Senator. I think it's maybe more rhetorical, but in the cases where I have brought those direct placement requests, the foster parents are providing the evidence. We are. I am. I'm calling. We're hiring therapists to do a attachment assessment. They're charged with providing all of that information to the court and getting that information to them, because I've gone in there and it's like everybody else against us, the DA, say all the attorneys on the agencies, and we're friends, it's all fine. But the guard ad litem, and then I'm calling witnesses, that are not there, because we know what their testimony is going to be. And to your point, I was thinking of this earlier, it's like the foster parents are keeping track of this. I mean, I have clients that have, my associate was looking through somebody's very meticulous spreadsheet about all the information in the case, and you better believe there's no caseworker with that information. They're the ones that are keeping track of all of this stuff. They missed a visit. They did this. This is what happened at the last visit. This was at the last hearing. No, all the last court report had this misinformation. But I think we're putting that burden very simply on the foster family or on the relative that wants placement. Because again, that's kind of the way that's the way it's set up. But it is really frustrating when clearly reasonable people could disagree on some of these cases, but yet you go to trial and not one person from DCF or St. Francis or anybody will say, yeah, maybe that is right. It's like, are we going to battle to win because we want to win? Or are we going to battle because of what's in the best interest of the kid? And that's easy for me to say because I'm an advocate and I have a clear, client, but it feels very much, and forgive me, agency workers that are here, but it feels very much like you pick a winner and then we get the evidence to show what we want it to show. At least, again, I have extreme examples. That's who hires me, extreme examples. But I think that's to your point. It's like there's no one thinking, it is very much, in my experience, you can't, everybody's kind of like, well, that's what was decided, so I'm not going to go against that person, and they're all connected. I was just telling, on the way down here, telling my associate Kayla, who's here, a story about a case where I went into a small county and definitely got hometowned, and we didn't win on direct placement. They ended up adopting, but the only reason we had a case was because they had a caseworker that was willing to lose her job and go after and disagree with her supervisors. I mean, that's not right. She didn't. She stayed working there, but she was brave and went against it. And I think, again, not every time. I just feel like I have to say, these are extreme examples, but it doesn't feel like in a lot of these cases, they're open to new information to change their minds, okay? We've got behaviors. This is what's happening. Well, it's just normal, like the adoptive mom said. That's normal. Well, what takes enough information to get, how much more information do you need to be presented with to consider other decisions and other options? And that's what seems frustrating, that it's like, I mean, I talked to an agency attorney last week and I'm like, you won't care about what the therapeutic input is. And he's not the one in, in the decision-making necessarily, but he's like, they're not waiting for that. They're going to do the BIS, and your clients aren't going to be considered. So I have a hearing set on that one.
I just have 2 more questions based on what she had said. So who represents the foster parents unless, if they don't have best interest status, they don't have a voice in the courtroom. Is that correct? Unless they hire an attorney and spend the money to get that story out. Is that correct?
Yeah. I've had some judges will grant relatives attorneys that are court appointed. But in general, foster parents are going to have to hire an attorney. Yeah.
And sorry, Senator, and how much is that?
How much do I charge?
Yeah, well, how much does it cost to hire an attorney?
It's not $150,000 though. I think it varies. My hourly rate is $315. That's not even that high, guys.
Right.
For attorneys. But the point is, to your point, Senator, to your point, of course they can't afford that. No one can afford it.
Last question has
I'm
to do
being very honest. I hope what I say in here stays in here. No, I'm just kidding.
This is being live streamed. There we go. So you mentioned the case that you represented for the one child that had siblings that were in a different home, and you were able to get the siblings split, and they were adopted out. But then there was a break.
They weren't adopted, luckily. The disruption was prior to the adoption. But again, it was a couple months.
So are you familiar with any failed adoptions? I've heard that phrase, but I've not been able to find any documentation on failed adoptions.
Oh, yeah. We've done readoptions for kiddos, which again, I know is like, DCF's like, that's less likely to happen if it's a relative. And I don't know that that's the case. I don't have any kind of numbers, but I did a readoption a couple years ago. These cases with older kiddos, they would absolutely be a failed adoption or a disrupted adoption, but there's no one to adopt. There's no safe place for those kids to go. So that's a failed adoption if your kid is in a, out of home placement for the last 4 years until they're 18. That's failed. But that's older siblings. There's certainly younger ones. I don't have any data on that. I wish we all did, but yeah. There are agencies that specialize in readoptions. Not here, but like national. There's one in Texas that I have used where it's like you have a situation where someone needs to disrupt, and then they have families that understand and are willing to, and that's the one that agency helped a client of mine a couple of years ago. So it definitely exists.
Okay, last question, Senator Gossage.
Thank you, Madam Chair. Again, thank you for being here. We receive many emails. That's why you see our computers up as we're sitting here from people going, I'm listening in, here's my input. Could you please ask this question, et cetera, most of whom are foster parents. So a question that I have, and this one person that just had emailed us said, when I would sit in the courtroom during my foster son's sync hearing, my heart would pound having to keep information inside when they were sharing, questioning, or discussing inaccuracies or stating they didn't have the knowledge, when I'm thinking, but I do have the answer. So I think definitely getting input from these foster parents, I can't imagine not wanting, that input. And so my actual final question is about direct placement and the difference between direct placement and not getting a subsidy. Could you just address that real quickly?
Right. So every child who's adopted out through the foster care system, and Kayla can stand up here and tell you better than I can, it can automatically you qualify in different ways. So Title IV-E subsidies, which can be a monthly actual payment. Then you also get a medical card automatically, when those qualifications are very easily and clearly met when a child is adopted through foster care. When you remove a child and do a direct placement, then you don't have the same protections or qualifications that need to be met to get that subsidy, meaning money, monthly money, and a medical card. If the child has already been determined eligible for SSI, which would need to be, a special needs kiddo, then that problem is less of a problem because the medical card is easily determined based on that SSI determination. And as I said earlier, I'm really trying to learn more about it. But essentially, you're not guaranteed the subsidy that you would automatically get, which, by the way, is pretty low. I mean, the subsidy for adoption is, what is it, Kayla? What is the amount? Someone else can tell me.
The maximum's 500.
Yeah. So 500. So 500 a month, you stand to get unless you show special circumstances. And again, there's others in the room that could speak to this, but they don't. Special circumstances are a no-go unless you want to hire me and fight about it. And I think part of that is a disservice too. Like maybe this isn't. Every kiddo doesn't need that, but why is it such a set thing about we always do it this way? There's very clear guidelines through federal subsidy and the medical card that you have to meet. And now I lost what I was even asked. But
Thank you, Madam Chair.
So
Thank
glad
you
that
so
happens
much.
to other people. And now the real final answer of final question, Representative Humphreys.
Thank you. And it's a little bit of a comment, mostly to the committee. But Megan, thank you for drawing our attention back to the fact, like when you talked about the caseworker that was willing to be fired, that for drawing our attention back to, it is the kiddos, as you love to say, it's the kiddos that we're trying to protect, and not policies and not agencies.
Yes.
And so as we're considering our recommendations on this committee, I just hope that we will keep that in mind, that, there are, it seems like things we can do that are going to help the outcomes of the children. And so that's, I thank you for drawing our attention to that. Thank you, Madam Chair.
Well, thank you so much. I think we've had you up there for quite a while, and
Thank you.
Feet might be sore. I do want to add one thing that you said right in the beginning, and I may have misunderstood how you said it, but this committee has been in place for a couple of years.
Oh, okay. Mm-hmm.
And so I didn't want you to go away thinking that we were just created because of the DeHaven case.
Right.
That's what kind of brought us to the media attention anyway.
Right.
To the work that we're doing. But yeah, we've been in place. We meet quarterly.
Awesome.
And, yeah.
I appreciate that. Your job is not a small one, so thank you for your attention.
Thanks for being here and helping to educate us.
Thank you very much. Mm-hmm. Bye-bye. Thanks.
So next up, we have Dr. Kayla Byers with KU School of Social Welfare. Good morning. Thank you for being here, and thank you for patiently waiting.
Thank you, Madam Chairperson and members of the committee. Thank you so much for having us here today. I'm here, Dr. Kayla Byers. I'm an associate research professor from the University of Kansas School of Social Welfare. I'm here also with my colleague Lana Getz from the Office of Judicial Administration, who I believe is joining us online as well, and we'll be presenting together. So we're here today to share information about the adoption tracking tool, which is one of the initiatives through the Kansas Strong for Children and Families project that is run through the KU School of Social Welfare, along with the Supreme Court Task Force on Permanency Planning. And Kansas Strong, for short, is a federal grant that was awarded in 2018 and runs through September 2023, though we do anticipate potentially having a one-year extension beyond that and run through September 2024. Kansas Strong for Children and Families is a public-private university collaboration, and it's a 5-year project, as I mentioned, funded by the Children's Bureau, and we are one of 5 grantees nationwide intended to strengthen the child welfare system in our jurisdictions. So this is a collaborative, data-driven approach, and our goal is to achieve positive outcomes for children and families. We have several collaborators on this project. So the School of Social Welfare, as I mentioned, Kansas Department for Children and Families, the Kansas Court Improvement Program, and the Office of Judicial Administration, the Supreme Court Task Force on Permanency Planning, the private foster care providers around the state. All of them are in our collaborative, and as well as the Children's Alliance of Kansas and the Kansas Family Advisory Network. So the first year of this project was spent really engaging in a planning period along with this vast partnership to understand what were the needs around the state and what were the initiatives that needed to be put into place in order to address those needs. So that first year was spent developing a comprehensive plan together collaboratively with the partners. And the purpose of the project, as I previously said, is to establish a collaborative that effectively develops, implements, and evaluates these different strategies to improve safety, permanency, and well-being outcomes by enhancing agency practices, court and legal practices, and by reducing systemic barriers that, that impact child well-being. So I will turn it to Lana to talk about the adoption tracking tool specifically and how and why it was developed.
Thank you so much, Dr. Byers. Can everyone hear me? Great, thank you.
We can, but it could be better. Hang on just a sec. Okay, try again.
Can you hear me now?
Yes, that's much better. Okay. Thank you.
Thank you so much. And thank you, Madam Chairperson, for having me, and to the committee members. I am Lana Getz with the Kansas Office of Judicial Administration. And as Dr. Byers said, the adoption tracking tool, or the ATT as we call it, was identified as one of Kansas Strong's key strategies during that 2018 planning year. It came out of an event, a two-day planning event that KU helped to organize with the National Center for Courts, with the Kansas Department of Children and Families, the Kansas Office of Judicial Administration, some judges, county attorneys, court-appointed special advocates, and guardian ad litems. We all got together and discussed the various factors impacting adoption at that time. And this tool came out as a result of that two-day planning event. At that event, the National Center for Courts actually shared with us some Kansas adoption and foster care data. And one key piece of information that they shared was, at that time, Kansas ranked 7th worst in the nation on adoption timeliness. So KU took that information and did an analysis of Kansas's facts data, which showed that adoption timeliness was worsening. And one of the things that they found when they looked at that facts data was that from 2015 to 2019, the time to adoption increased from 33 months to 39 months. When KU went back and looked at the state fiscal year 2021 adoption data in the FACS system, it had actually increased up to 40 months. So what is this adoption tracking tool that I'm talking about? Essentially, it's a standardized tool. So it is a standardized tool. It's used statewide. It went into full statewide effect in July 2021. It is actually required now by DCF's Policy and Procedural Manual. And basically what it does is it tracks key adoption benchmarks along with the timeframes for about when those benchmarks should be met. That comes into play when a child has been determined legally free. All right, so when a child has been determined legally free, the caseworker on the case through one of the case management providers, and I should say too that the case management providers did have opportunity to comment on this tool and to provide feedback on this tool before it went into effect across the state. But it comes into effect when a child has been determined legally free. And what they do is the case managers actually submit or file that with the court. And that way, all the attorneys, all the parties on the case can see where are we at in the adoption process? What is still missing? What's been done? What do we need another of, et cetera. And it serves as a communication tool, if you will, to keep everyone on track and to hopefully keep adoptions moving quicker and helping those kiddos achieve permanency more timely. It's actually organized into 11 different sections. So it's fairly lengthy. The sections are as follows. They start with legal history, what adoptive resources are out there, was the best interest staffing done, what were some results of that, do you have the child's consent, the adoption subsidy, how that would or would not come into play, DCF's consent to adopt, so supplemental security income, or that SSI that Ms. Monsauer was referencing, whether or not the interstate compact on the placement of children is in effect, the Indian Child Welfare Act, and whether or not that child is a member or could be a member of the tribe, the adoption hearing information, and then any other information that's requested by the court. And the purpose of the AT&T, as shown there in figure 2 on page 3 of your testimony. So the purpose and the process were that, first of all, is that caseworkers, again, they complete that as soon as the child's been determined legally free for adoption. And then judges, court personnel, caseworkers, et cetera, use it in every subsequent court hearing to talk about what still needs to be done, what are the barriers, what has been accomplished, what hasn't been accomplished, and moving to, again, with the goal of moving towards adoption as quickly as possible. That, like I said, did not go into effect statewide until July 2021. That's it for my piece of this.
Okay, thank you, Lana. So I'll now walk us through just a little bit of the process of launching the adoption tracking tool and where we are with it currently in terms of our implementation. So when this was developed in 2021, we launched a pilot, in 2020, we launched a pilot in July of 2020 in in 6 counties, and that was in Allen, Douglas, Franklin, Norton, Reno, and Shawnee counties. And so we launched it in these 3 counties so that we could understand, did it work the way that we anticipated? What were the responses both among agency personnel and among court and legal personnel? We received largely positive responses to that pilot test across those 6 regions. We conducted a series of focus groups and surveyed participants, or each of those key stakeholder groups in the pilot counties, and understood that they were finding value in the tool in terms of serving as a form of communication, in terms of, particularly we heard from agencies, the importance of when there is turnover in casework staff, that it was particularly helpful in sharing information between workers when it moves between, so that they can really understand quickly where the case is in the process of adoption and not spend time trying to figure that out. So after the first initial success of the pilot, we did expand to 3 additional counties during this initial launch, and those were Chase, Lyon, and Wyandotte. And then through that period, we shared the results of our successful pilot with the Supreme Court Task Force for Permanency Planning, and they recommended uptake of this tool formally. And so at that point, they recommended to DCF that it be adopted as a requirement. It has now been added to the DCF Policy and Procedure Manual on July 1st, 2021. So as Lana stated, it is now a required tool that is in DCF's policy for use when a child is legally free for adoption. We are continuing to evaluate this. When we launched it statewide in July 2021, we held a series of webinars to introduce the tool to court and legal personnel, as well as to agency staff, so that they were well aware of it, understood how it worked and what its intent was. We most recently have conducted a case read in partnership with DCF to understand, is that tool being used in these cases? In our case read, we asked 2 questions. In the cases that were eligible, so for legally free for adoption, was the tool even there? Was it present in the case? Because it's turned in with the court report. And the second question was, if it was there, was it appropriately completed? And what we found is that of the cases that were reviewed, 58 were legally free for adoption, And of those, only about 40% had the tool present in the case. Now, this was, of course, reviewing cases from the very beginning of the statewide launch over the course of that first year, so that may have taken some time to get into place. But we were seeing relatively low uptake at 40%. But what we did see with the second question is when the tool was there, it was completed. It was completed to the degree it was expected, and all the information was there. So while we still have some issue with uptake and need to support that to make sure that everybody knows that the tool is there, that it's required, and how to use it, when it is being used, it's being used with high fidelity. So we are hearing that it is being completed so that it is a tool for those hearings. We do have some additional plans to continue evaluating this, so we will do a more extensive case read, hoping to develop some more extensive questions to ask beyond just, is it there and is it complete? We are also planning to conduct follow-up focus groups with key personnel, but importantly, we want to survey court and legal personnel to understand their perspective of the implementation. The focus groups that we did in the pilot year, we did 20 focus groups and interviews that were held with court and legal personnel, DCF, case management provider staff, and then the follow-up interviews were just with agency staff. And what we heard, what were the benefits of the tool, but also that there were inconsistencies in court, which we've already heard today, that because every court does things differently, there may be different requests in how the tool gets introduced or whether it gets introduced at all. So there's additional work that I think that we can do to support the use of the tool, but it is a tool intended to speed the timeline to adoption, and is something that we're monitoring closely as it scales up across the state. Thank you for your time and attention, and I'll take any questions.
Okay, thanks. Thanks for being here. We'll start off with Senator Faustigedo.
Thank you, Madam Chair. Thank you for this wonderful, informative presentation. So how longer will you have the strong pilot program to continue your studies? And I think you're such a neutral entity in this room today. So I want to ask this. So with your studies and the information that you've gathered from the sources, did you find, because I hear this all the time, I'm sure some of us have, is that, or how did you find that DCF it wasn't a conflict of interest with them, with the adoption and foster care and all the other services under their umbrella. Did you find, how did you, thank you.
Sure. So in terms of the timeline, we do anticipate, I mentioned this is our 5th year of this project, but we do anticipate having a 6th year. So we will continue to evaluate this throughout and hope to have some final outcomes at that time so that we can really definitively say what the findings are in terms of the effectiveness of the tool. We do expect, we mentioned that the time to adoption is still continuing to trend up. We expect that may still continue to be the case. There are a lot of factors at play there, but we do have some other more proximal outcomes that we can look at to understand, specifically looking at the tool itself, you know, and the timeline between those benchmarks. Are they getting shorter over time as people have the same information directly in front of them in a very simple format? So, so that's the hope, that it will be sustained beyond the life, that we'll be able to say it's effective, and then because it's part of policy, there's no cost to the tool, it will be sustained beyond this project. And then in terms of the conflict of interest, that wasn't really part of the conversation because it really is simply a tool to document the process. All of the information that goes in the tool should already be in the court report in narrative form. And so this just really boils it down into sort of a top sheet so that everybody can see if there's a barrier, if the best interest staffing hasn't been held, why hasn't it been held, what's the holdup? And it's intended to be a point of question for the judges, not a punitive tool for agencies. And that's a question that we've asked specifically, is that it not be used punitively, but to be used to move the case forward.
Representative Esau.
Thank you, Madam Chair, and thank you for this information. So it's required to be used for this adoption tracking tool, but if they don't use it, what happens? Is there any consequences for not using it, or can the judge say, well, since you didn't follow all the steps, you have to? I mean, I'm kind of lost on that part.
So at this time, there really is not an accountability mechanism for the agencies in terms of using it. That mechanism would be, I suppose, if the judge were to ask for it. But as I mentioned, that's a little bit spotty in terms of the implementation about whether judges prefer it, whether they want to see it, whether they're interested in it. So we've heard from many judges that they love it and that it's very informative. And then others that are like, if that's helpful to the agency, that's great. I want to see the court report. Or their court reports look different across jurisdictions. And so that's where it's a little bit uneven. And so I think we have some more work to do in terms of supporting both the agencies and court and legal personnel in terms of understanding the tool and how to use it so that it is taken up at a higher rate.
Senator Gossage.
Thank you, Madam Chair. Thank you for being here. I'm assuming that this was designed to make the adoption process more efficient. Oftentimes, however, some people would look at that as it's just adding time to my day of things I have to record, which actually, if I could be focusing on this and not doing that, I can make it more efficient, right? So I'm just curious, can we actually see the tool, not the results within the tool, but just the tool itself? Is there any way we could see that?
I don't have the tool with me today, but we can certainly forward that on after the fact, and I'm happy to do so. So we can provide that to you. It's 2 pages. What you have in your testimony, these 11 sections are exactly what's there, and there's a little section for each one. And we were very mindful of that because that is something we know is a problem. That administrative burden on casework staff is a problem, and we certainly don't want to add to that. So that was part of our focus group and interview process, was understanding what is the burden versus the benefit to agency staff. And we really heard overwhelmingly, this is information I already have anyway, and this puts it in one simple place. So we really haven't had any critique of it being burdensome at that level. It is a pretty simple tool.
And what would the cost be? Because if they're required to do it, is there a cost to keep this updated? You said they're going to be 1 more year to kind of look at it, see how things are going. Would there be an ongoing cost at all?
Not unless there was some initiative to overhaul it for some reason. But the tool is developed, it's aligned very closely to this process, and it's freely available in the manual, so they can access that and just complete it.
Thank you. Thank you, Madam Chair.
Any further questions? Let's see, Lana, are you still with us?
I am.
So, okay, not to do with this, but we've had a couple of questions come up that we thought you might be able to respond to. And one is the funding for the payment for the GALs. We were discussing how much they're paid and that it's county by county.
That is correct, Madam Chair. It is county by county. They are not judicial branch personnel.
So they are paid by the county?
Yes, ma'am.
Okay. Seems like there were a couple of other questions that had to do with judicial branch. Does anybody recall? Okay. Sibling split. We were discussing the authority for the sibling split. Are you familiar with that?
You know, I heard there may be some questions related to that. And so Marisa Bayless of our office, she is with the special counsel's office. She may be able to provide you with more information.
Yeah. Hi, welcome back.
Hello, Marisa Bayless, Deputy Special Counsel. We had watched testimony yesterday and today, so I knew we had a couple of questions. I don't know if I can give you that direct answer. It is potentially a legal question that would be, as Megan said, it's maybe an undecided question since it doesn't say specifically in statute about sibling splits and is a term of art used in that. area. But I will say, I talked to Natalie, for your next quarterly meeting, we can really work on getting a judge who has a sync docket to be able to at least present through WebEx or potentially come in person. They just need a little lead time for that to get it on their schedule. So whenever you guys decide your next committee meeting, we can sure try and work that out if that's amenable.
Okay.
But
yeah.
I took extensive notes today on different questions you had, so hopefully we can have a pretty robust discussion for when
Okay.
they would potentially appear.
Were there any others that you wanted to address today?
I mean, the GAL question, they are not judicial branch employees, so they would be subject to just if disciplinary, Office of Disciplinary Administration, like any other attorney working in any other area through that, if that is a question on their zealously advocating for their client.
Mm-hmm.
So,
okay.
yeah.
Any other questions? All right. Well, thank you.
Yeah, no problem.
For having a heads up and responding to us. And thank you, Caleb. We kind of ran you off. I'm sorry about that. But yeah, thank you for being here and sharing the pilot program. So next up, we have Dr. Rick Gaskell from WSU. Good morning. I think it's still morning. Yeah, good morning. Welcome to committee.
Oh, now you can hear me. I got up this morning and drove up here and like probably a neophyte just assumed that I would go right at 11 and then I got in here and I go, you know, I kind of remember these things don't go this way. So, okay, so there we go. I put a brief description of my experience on the slide for you, which I'm not going to go over particularly, other than I am currently at Wichita State University as adjunct faculty, and I've been there for 27 years on adjunct faculty. In my real life, I was a community mental health center psychologist, counselor, children's director, clinical director, and ultimately executive director, and retired 1 year ago. So, so this is my second life. A couple of opening just thoughts. I'm going to talk to you today primarily about attachment because I think there are some things about attachment that are critically important for you to keep in mind as they might apply to adoptive parents, adoptive decisions, weighing the benefit of one adoptive family over another, or whether they would be adopted in some kind of a kinship placement, whether you keep siblings together, a lot of the things that you've been talking about. So I'm hoping that I can be of some help with that. On a personal note, I put in here, after 47 years in community mental health, and I don't have any idea how many children I've seen, but it's in the thousands. Most of them were children who were being referred by the court, many of them foster children, adoption children. After writing reports, conferencing with everybody under the sun about these cases, I don't think there are any pat answers, and sitting here this morning for the last hour, it's pretty clear to me that you're getting to the meat of a lot of the relevant issues. But I hope that I can offer some insights for you. The first thing, to give you a little background, I have been very fortunate in my professional career to work with one of the most well-known traumatologists in the world, Dr. Bruce Perry. And so some of these slides belong to him that he has allowed me to use in some of the work that we have done. So when we talk about attachment, we often talk about that as if it is an emotional thing, that it is something that happens, but we don't stop and think about the fact that it is actually a neurological process. So the brain develops, organizes in reflection to the developmental experience, organizing in response to the pattern, intensity, and the nature of sensory professional experience. What all of that means is that this attachment process is being created by neurons that are connecting together in certain patterns, and that these patterns are lifelong. So not to overstate the case, but a lot of these decisions you are making are going to determine how this brain is going to knit itself together, and what perceptions, what possibilities are available to this child and then to future generations as well. So the human brain allows us to absorb the accumulated knowledge of thousands of previous generations into a single lifetime. If that weren't true, there'd be no point for grade school, high school, colleges, books. We are able to transmit information from one generation to another. So the quality of the learning of the children that we are working with becomes critically important, because that's information that they will either knowingly or unknowingly transmit to their own children and others. So probably this is a bit elemental, but just in case, I want to emphasize that attachment is the active, reciprocal, social, emotional relationship between parent and child, and these innate behaviors maximize our survival. And I use this picture on purpose because if you look closely, you realize that the little girl has Down syndrome. And my point in using that is whether this child has that syndrome or not, or whether she's perfectly healthy, attachment is still important. So any child who is able to form an ongoing attachment with an adult is going to be much better off. Attachment is the single most defining milestone in human social development. Attachment will predict many things in our lives. It predicts success on the job. It predicts successful relationships with other people. It predicts criminal behavior. Now that might sound kind of far-fetched, but if you think about it, all of those things have to do with relationships. And your ability to form healthy relationships are going to define how you get along with other people, whether it's in your home, in your workplace, or criminal behavior. I often joke that the proof of this is most people will tell you that the most difficult thing in their job is getting along with some of the people at their job. It's not necessarily the work that we do. So the sequence of attachment actually, and this is, I think, a pretty important point, it requires about 4 or 5 years from birth to be firmly in place. And the reason for that is that the brain has to grow and develop and be capable of creating permanent conscious memories of those things in order for them to carry out that same attachment process with their own offspring and other people. So the neural social developmental process is tied to the maturation of the human brain, because the process and the human brain are wired to recognize, seek out, and crave human attention. That part is innate. But then once we make those connections, then we start learning about the relationships with the people that we have. The human primate brain is biologically designed to organize through social experience, especially in the first couple of years of life. Those are absolutely critical. So I put that in there, not because I'm trying to scare anybody, but I just want to make sure you understand the gravity of the things that we're talking about, that these are going to have lasting impacts on Kansas, if you will, for many, many years, and not to be taken lightly. The picture here on the right is actually not, that's photoshopped. When I first got that picture, I thought, wow, the infant and the child are lighting up their brains in exactly the same place. The lady, the neuroscientist that did that, said that was photoshopped in later. So that it still is a nice graphic. And yes, those are the areas that we would expect to light up, but that actually wasn't on the MRI. But we do notice here some things that happen when children and parents are in close proximity to each other, and that is that their brains begin to synchronize, and usually that happens through eye-to-eye gaze, face-to-face contact with people. The neural activity begins to synchronize. The EEGs actually begin to look like dolphins swimming through the water. They're patterning after each other. Heart rates synchronize, hormonal systems synchronize, and all of that is critical to later self-regulation. But we are, first in our life, we are regulated by others through somatosensory contact with other people. And as our brain learns from those experiences, then they become permanent in the child. So the child who doesn't experience is going to have trouble with healthy attachments later in their life. So the attachment sequence is completed and represents a consolidated, effective, representational model of life for the child moving forward. And I told you the attachment becomes progressively stable and is pretty resistant to change. The pattern, not necessarily being attached to other people by age 5. So we really have a fairly limited window for this early form of attachment. I'm not going to go over this, but I put this in case you're interested. This is a fairly common attachment category graphic, and shows that about 60 to 70% of the population are well attached. About 10 to 15% show anxious attachment, and 15 to 20% avoidant attachment and disorganized, 5 to 10%. Children who do not have firm attachments are much more likely to show up in the anxious, avoidant, and disorganized, with the most serious being children who suffer from disorganized attachment. Many of the problem children that you have been hearing testimony about would fall into those last 3 categories. And because of the fact that the programming in the brain is forever, it makes it very difficult, not impossible, but it makes it very difficult to make changes. And consequently, then you find a lot of these children in multiple foster homes, or they're in residential care, and it's enormously expensive and takes a very, very long time to make improvements. So what's the impact of adoption? Well, one of the comments that I think that is probably really relevant, and it's not on this slide, but it fits here, and that is that adoption is a process that lasts for an entire lifetime. You aren't adopted and then it's over. That people keep revisiting the process of being adopted over their entire lifetime, and that's true of the adoptee, the birth parents, the extended family, the adoptive parents. Everybody who's connected with that at various times will go through many issues, including loss, rejection, grief, identity, intimacy, mastery and control problems. So obviously, while adoption may be very, very helpful, it's not without ongoing issues that need to be dealt with. Historically, most of the research on adoption has been done on infancy and childhood adjustment. And the research indicates that children are pretty capable of reorganizing and adopting to new caregivers, which may sound like a contradiction to what I just said. But one of the things that we find is that the children tend to, if you will, compartmentalize their adoption experience with their new adoptive parents as being different from the adoptive experience of maybe their family of origin. So early experiences in adoption relationship do not single-handedly determine later adoption problems. So that is good. Attachment patterns among adults, one of the things, and this was the slide I was telling you about earlier, what appears is that the individuals construct their own representational model of the new attachment problem relationship as opposed to the original one. So really it's kind of simply like they form this is now and this was then. So they have two models that they work with. So some conclusions: genetic contributions to attachment certainly can't be ruled out, but there is not an extensive amount of literature that is suggesting that attachment is purely a genetic component. Environmental experiences seem to explain a lot of the inconsistencies we see in adoptive parent-infant pairs. Adoptive parents' attachment representation shapes attachment patterns of adoptive children as it does with biological children, so the same kind of process takes place. The patterns are contributory to recovery for attachment quality of children. It's not like we're out of the game if the child has had some problems. If they are in a home with a good attachment pattern, then the parents are going to have considerable impact on them. Children adopted from foster care experience more negative outcomes than children adopted privately or internationally, and that was kind of startling to me. But the explanation was that the higher rates of mental illness and the higher problem behaviors probably have to do with the fact that the adopted children had experienced considerably more difficulty in their life than some of the children that were adopted from birth. They had increased positive when the kids were adopted, what we found is the problem rates came down and the cognitive processing of the children improved. So when you put children in a warm parental environment with family cohesiveness, children tend to improve. So adoption attachment relationship study for adult adoptees. We find that adoption may be a risk factor for relational difficulties later in life. That certainly is a possibility, although the effect size on that in this particular study was relatively small. When attachment is used as a predictor of the adoptive status, then you find that that the adoption is no longer predictive. So what we're talking about is relationship, relationship, relationship. And I heard earlier in testimony that the discussion about the importance of attachment, and that's really what we're talking about here. Other factors impacted the adoptee's sense of security, relationship with adoptive parents, and reunions with birth mothers, that even though they may have a firm attachment to the adoptive family, it's not uncommon for them to want to revisit the relationship that they had in the past. Most adoptive studies show that the adoptive kids are relatively well adjusted, and practitioners should not assume that adoptees are irrevocably harmed by adjustment problems. The study points to the importance of family relationships with influence and adjustment, and relationships with adopted parents are clearly very important. And here is the comment about adoption tends to be a lifelong process. So some things to think about, I think, from my experience with adoptive children is that we want to look at the relationship abilities of the individuals involved. I think if you have a clear adoption option, that's one of them that you should consider first. You can add in opportunities for the best interest of the child that may build on that in terms of, are the biological parents capable of involving themselves in an open adoption? Can the sibling also be adopted in the adopted family? Are siblings going to be involved for visitation so that we can try to maintain relationships? What is the best sequence of options for this particular child? What services do they need to ensure the best chance of success with each of the options that we might choose? And how do we build supports for the child and the family through the years? And I think a lot of the testimony I've heard, you've already been talking about a lot of those. So that is a lightning review. If you have any questions, I'd be happy to try to answer those. Otherwise, I'm content to be done.
We usually have questions. Committee, do we have questions? Senator Gossage.
Very quick one. We received an email asking about, a former employee within the department was asking about failed adoptions. And we don't hear about this much, a parent relinquishing the child back into the state. Mm-hmm. Have you heard much about this, and what is your response?
Failed adoptions do occur. I've personally experienced those in my work. Although when they fail, usually there were other problems around the adoption that I think were kind of a poison pill, that it was destined not to work well. Adoptions, from what I have read historically, adoptions tend to fail less often than reunions with families that have not completed whatever rehabilitation they need. But yeah, it's always a risk.
Sorry. Madam Chair, thank you. Would you mind repeating what you just said about the family? Did you say it fails most often if they're with family, or less often?
If you place a child back with a family that has had severe problems, there's a higher rate of failure there, from what I've read historically, than adoption to an adopted family.
Thank you. Mm-hmm. Thank you, Madam Chair.
Mm-hmm.
Representative Ousley.
Thank you, Madam Chair. And I would go back to slide 5. It says the attachment process develops, well, and congratulations on retirement.
Thank you.
And thank you for being here, taking the time to be here with us. But the attachment sequence, it says process develops gradually over the first 4 to 5 years. Is that first, as we're discussing here today, is that first 4 to 5 years of from birth or from
birth.
Placement?
From birth, yeah.
So then that supports the on slide 10, the attachment process becomes progressively stable and more resistant to change by age 5.
Correct.
Okay. I just want to make sure I was understanding that. And then I made note, slide 13, research indicates young children are capable of reorganizing and adapting to new caregivers after early disruptions. Is that age specific? Is that
no
5 years of age? Okay.
No. Obviously, the variable that you have to take into account is how much difficulty has the child had prior to, the permanent placement, And so the difficulties you're going to have are going to be proportionate to the difficulties the child had. But generally, we would expect them to make progress.
Well, I appreciate you bringing this to us, and thank you again. Thank you, Madam Chair.
Representative Johnson.
Thank you, Madam Chair. Can I get a certificate of attendance for my continuing ed license?
Absolutely.
Thank you. Thank you, Madam Chair.
Representative Ruiz.
It's very clever. I wish I could get one. I was wondering about, we've been speaking a lot about sibling splits, and in one of our earlier sessions, there was a person who spoke up about the fact that she was separated from her sibling. She's now an adult.
Yeah.
And this lifelong seeking of those siblings and wondering why were we separated. And I can't let that go. It's one of my concerns about this sibling splits, and I understand that we should look what's at the best interest of each child individually. So, but I know there's research out there that talks about, and you mentioned in your presentation about this adoption is a lifelong thing, and trying to, seek your previous family. If you were adopted as a baby and maybe you had no way of knowing who your parents were, because it was a secret adoption, or was it a closed adoption? And partly why all these DNA ancestry and everybody, was it 23, and those are all so popular, because people are trying to connect with each other because our brain is wired that way. What is there anything you could shed light on that as we look at the sibling splits and the advantages and disadvantages of that, and then them later on in their life looking for their siblings if they don't know them? Is there anything you can shed light on as we really probably have to make some decisions about that?
There is nothing I'm going to say that's going to make that easy. And the reason that I suggest that you, with a particular child that you're focused on, that you go with the best attachment option you have for that child, is that no matter what you do, there are going to be issues for these children. And I have personally in my clinical practice over the years helped children reunite with siblings, reunite at least temporarily with parents. Sometimes it goes well, sometimes it doesn't. But the gravity of what we're doing is we may make the best decision we can today, but there will be other issues down the road. And I guess the best advice is to think carefully and make the very best decision you can, because there's going to be baggage. This is a personal friend of mine that went through this experience. She found out, she knew she was adopted and she knew she was a twin, but she didn't know that she was Canadian by birth. And so she goes back to Canada and she finds her mother, who did not know she had given birth to twins. I don't quite know how all that happened. Obviously, she was not totally conscious. And she found out that she spoke English and her mother did not. Her mother spoke some Canadian, I think it was French. And while they had a great deal of interest in reconnecting, I think it was more about closing that chapter in their life. And it took time now, to the extent to which the state can facilitate that for every child. I don't know, probably can't, but I think we need to keep in mind that the decisions we make may have resolutions way downstream. Yeah.
Representative Humphreys.
Thank you, Madam Chair. Thank you so much for your presentation. And, several of us have been, talking about adoption for a long time. And I can't believe you're at Wichita State, and we didn't know that. So really appreciate your presentation. I want to make sure that I am catching what you're saying. So the importance of attachment and adoption. So when we adopt children, we look them deep in the eye and we attach and all of that. Now, did you speak to, and maybe I missed it, or could you speak to when children have made an attachment with a family, either biological family or it could be a foster family, and it's gone, it's in those early years, birth through 3, birth through 4. What can you speak to the trauma of, how if they have been able to attach, can they reattach, or what is the trauma to breaking that attachment and putting them with someone that they don't know, even if they're blood? Or could you speak to that just a little bit?
Yeah, sort of. That's the crux of the problem right there, is that children may be attached to either foster parents that maybe are a good match for them, or biological parents that maybe weren't, where there are sufficient problems they can't stay. But yeah, people can reattach. The problem is you're not necessarily going to get rid of the other attachment. You can't erase it. And I think that's part of the lifelong struggle is, this is not exactly what you're asking, but it's the flip side of it. I had an uncle who was adopted, who told me that he never had any interest in finding his adoptive or his birth parents because he had grown up with his adoptive parents and loved them and was perfectly happy. On the other hand, I've talked with people who have wondered, where did I come from? Why am I the way I am? Is this because of there isn't any way to avoid that. And I suppose you said when we look into the child's eyes, the other thing I think is we have to look into our own heart and ask, what mistake are we most willing to make? Because there probably are going to be consequences no matter what we do. Now you might get lucky like my uncle, and he was adopted and he said, that's fine, no, I don't have any interest. But more of them that I have met want to know where they came from.
So, Madam Chair, so interestingly, we have 2 adopted children. One really is interested in the heritage, and then the other one says, I could care less. Yeah. So, definitely, even in the same family, you're going to have differences. And both of our kiddos, we got at 1 month and 3 months. And so, I appreciate that fact that it's all different. I've heard people say, like, attachments, like a piece of Scotch tape you put on a table, and sometimes you pull it off and it'll stick somewhere else. But if you keep pulling it off, then it has trouble sticking more. would you?
That's true.
Yeah, okay. All right, thank you. I really appreciate being here. Mm-hmm.
Further questions? Representative Esau.
Thank you, Madam Chair, and thank you for being here. Almost 40 years ago, I got kind of interested in all of this and studied it on my own. So I really do appreciate getting the science to back up everything that I had learned just as a person reading everything I could find on it, and some of the involvement I had in helping young moms. So one of the things you shared brought up something that I recall, that moms who sleep with their children, I'm not talking about the safety aspect of it, I'm talking about being together, whether they're in the same room or right next to each other, that they soon develop sleeping patterns, and the brain rhythm and everything matches up. And so mom tends to wake up about the same time the new baby wakes up and is hungry. And
that happens when your pet dog too. Yeah.
I won't go there. That's interesting. Okay. So anyway, it's just, it's,
Well, it has to do with the mirror neuron system in the brain, and that is one of the major ways we learn social emotional information. And when those brains begin patterning with each other, then, yeah, we create permanent memories, and then we start noticing the things you're talking about, yeah.
right, okay. So yeah, this is really good to know, and I don't know how we use this legislatively and with policy exactly to get the best outcome we can for each child, but I like what you said about when you have a child who's in crisis for whatever reason because of their family situation, hopefully we make the best choice we can of bad choices, because if we're going to have someone's attachment disrupted, it's going to have an impact. So I'm glad that we're able to consider this and have some science behind it. So thank you.
Further questions? Okay, thank you.
Thank you.
Great presentation. So lunch is here. We are going to pause now before the next presentation and grab lunch. So I forgot to mention, yesterday's lunch was provided by Steve Green. Today's lunch is provided by DECA, and there are lunches for everybody, for those in the audience too. So if you, not staff, you guys don't get to eat. Just kidding, just kidding. We want you guys to go first. Yeah, if you just let the committee grab lunch so that we can get back in here, and let's try to get back started at 12:30. Just take a quick 10-minute break. We are going to get started. So next up, we have Foster Adopt Connect with Crystal Hedrick. Oh, and there you are, ready to go. Thank you for being here.
Very good. So yesterday I was really inspired by Senator Faustido, who, her head pops up, who mentioned that part of what we're missing here is the human element. We're not staffing cases, but we are talking about people's lives here. And the professionals that come to the table are no different. There's a human component to that as well. So inspired me to just share a little bit about myself. I have been a social worker for about 15 or 16 years. I'm not really sure what called me to do that. I just kind of landed in my lap. But it proved to be a good fit for me, and I've held a lot of different capacities in child welfare in Kansas over those times. I did some family preservation work. I was an adoption case manager. I was a reintegration case manager. I provided supervision and support to those roles. I was a director of adoption services for many years, and somewhere along the way, also felt compelled to become a foster parent, and really aimed at reintegration and supporting biological families. And along that path, my family grew exponentially through adoption. Not only has our family grown through the children that we've adopted, but their families are a part of our family too. And holidays are kind of a wild ride at our house. So I just wanted to share some of that and know that that's what brings me here, and that's my why. And I, over the course of those years, I've really had the opportunity to work with a lot of really cool people who are really smart and really passionate about that. And in this committee and in this room, I feel that same feeling where we all really have some common purpose in the work that we do, and finding that common ground is really going to move us forward. So I'm very grateful to this committee for having that intention moving forward. In July 1st, 2021, we began supporting a couple of programs through grant funding and through DCF. Those are the Kansas Adoption Exchange, Adopt Kansas Kids, and K-Park, which is post-adoption support for families. So I'll start with Adopt Kansas Kids and just provide some, you can refer to my written testimony to see some of our practices and policies and the ways that we communicate with the foster care teams to do that. But in general, just a few points that Adopt Kansas Kids focused on. Number one is recruitment. How do we recruit families for kids that are able to meet their needs, and how do we bring them to the table? The other is public awareness and education. There's some misconceptions about adoption, and if you've been following Adopt Kansas Kids on Facebook and other social media outlets this month, you've seen that we're kind of doing some myth busting around maybe some not negative connotations to adoption from foster care, and trying to work through some of that. We also provide education and support to families that are interested in adoption from foster care, and we have a team of 5 folks who do that work. And we also provide best practice support and consultation. We weigh in on policy development with our partners at the case management teams, the child placing agencies, DCF, and facilitate some conversations around that and our statewide diligent recruitment practices. Over the past 17 months since we've been doing this, we've finalized, in partnership with the foster care teams, 84 adoptions for kids that have been referred to the adoption exchange. So I think it's important to have some context around the kids that we are recruiting for through Adopt Kansas Kids. So I just have a few data points around that. 55% of the kids that are enrolled in the adoption exchange are ages 11 to 15 years old. 25% 6 to 10 years old, and 15% are 16 and older. So 59% of the kids that have been referred to us for recruitment belong to a sibling group and are being recruited for in with a sibling group. So right now, there are 459 kids that have been referred to the exchange. 156 of those have active open cases. And so what that means is we're working with case teams, working with child placing agencies, working with the kids themselves to determine what are the best ways to recruit for them. And that really looks different for every child. We partner with the case management teams to have an individualized adoption plan, an individualized recruitment plan for them. And that ebbs and flows depending on where the kids are at. And so those remaining 303 kids we reference them as being on hold. There's a lot of reasons why kids might be on hold. It might be that they've decided to take a step back from recruitment. Maybe they have some worries about what adoption means for them or their family, or what they might want in an adoptive family. So our team works with the case management providers to work through that with kids, and really help prepare them so that when we do have a family that's the right match, that they're comfortable transitioning. And so also kids that might be on hold because they've been matched with a family, or family's been matched with them, and they're transitioning through the adoption process. So, yeah.
Senator Vascato.
Madam Chair, thank you. So just for the record, if you would state again how you get the referrals. So many times over the years, individuals have said, oh, DCF is taking our children so that they can adopt them out to someone else. But if you could clarify how you get your referrals, and if some of them, years and years ago, young moms or unwed moms would give their child up for adoption because they felt they couldn't care for their child and they were giving their child a better home. So do you get many of those cases where just the mom decides to contact you for your help with adoption? And just to clarify who you get your referrals from. Thank you, Madam Chair.
Our referrals are from the case management providers, specifically for children in foster care. So if a biological mom reached out to us in support of a private adoption, we would help connect her to an agency that was more appropriately suited to do that work.
Sure. Senator Baumgardner.
Thank you, Madam Chair. So you have the contract with Adopt Kansas Kids, correct?
Yes, yes.
So who's responsible for what's published on their website and on social media?
We do that work in partnership with the case management teams and DCF.
So I guess that's where I'm a little concerned about. So who does the double checking that it really is accurate? Because I just went really quickly onto the site and I did a quick search. And I searched for kids under the age of 5, and it shows a picture of a little boy, and it says that the little boy and 2 others are a strongly bonded and loving trio. They are waiting for a family that can support them together and love and engage them individually as well. And that just seemed very reminiscent of a post that we saw that said, say hi to, and it lists the 4 names. They have a really close relationship and all wish to be adopted together into a family. And we know for a fact, because we've heard about those 4 kids, that those 4 kids didn't ever want to be adopted together. So when I see a similar post that's up right now, it just makes me wonder, and I have a background in advertising and marketing, so where's the reality? Because if we are wanting families to know and understand what they're getting into so that they have accurate expectations, So who does the fact check?
Sure. So if it's okay with the committee, I'd actually like to invite our Adopt Kansas Kids program manager to the podium to provide some feedback about that. She's our true expert in our day-to-day practices. So this is Corey Donnelly, and she supports that work and communicating with the CMPs. Just as a bit of an introduction, there are, we really work with federal partners around public sharing of profiles and what's appropriate to share, what's not appropriate to share, and follow the guidelines that are laid out for us by the Children's Bureau, National Adoption Association, NACAC, Adopt US Kids. Just earlier this week, I spent some time in DC working with those folks specifically around celebrating National Adoption Month, but also thinking about where we're headed in terms of public profile sharing and photo sharing and how we do that in social media. And I do think that, we've been doing this for a long time, and it may be time to take a look at the ways in which we are recruiting and really marketing our, and I think we've had some conversations too about typically, when a family inquires about a specific child that they see, that's not the child that they end up matched with. And a lot of that is because of some of that general information that you find on the website. Those are all really high-level, kind of surface-level information. We call it a strengths-based narrative because we don't want to overshare information about a child's story with just any family. So I'm going to let Corey talk just a little bit about our information sharing continuum and how that works.
Thank you for having me. My name is Corey Donnelly. I am the program manager for the Kansas Adoption Exchange. To answer your question, when photo listing children and writing those narratives that you were referring to, that you were reviewing, we receive a referral for children legally available for adoption that do not have an adoptive resource. So post-termination, if the children do not have an identified resource, the case management provider fills out a referral of information regarding the child's strengths and needs and provides that to us to initiate recruitment services for that child. And sometimes that recruitment plan does include public photo listing if appropriate and in that child's best interest, and if they are of age, the child's providing consent to be photo listed. We usually work in collaboration with the placement provider for the child and the case management team to write a public narrative for the child. Of course, consulting with the child when age and developmentally appropriate. We have a team of child specialists that write those narratives. And specific to siblings, when you refer to that, we take the lead of the case management provider, and they provide us recommendations on siblings being recruited for together or individually. And so when we get referrals, there's an indication on that referral and a discussion with the case team if a sibling split has not been pursued or approved. Then we recruit for those siblings together to locate a permanency resource for those children. As Crystal mentioned, we do follow guidelines and best practice standards set nationally by the Children's Bureau and Adopt US Kids. We follow those guidelines and do specific trainings with our staff surrounding writing narratives for children. Of course, our public photo listings are only information that is strength-based and specific to the child's interest in order to help families feel an attachment and a connection to the child that they might be interested in order to inquire on that child and learn more about the adoption process, learn more about adoption from foster care, and learn more about that specific child's needs. So we share information with inquiring families on an information sharing continuum. So any photo listed children only receive strength-based information about a child's specific needs. So it might say something like, Johnny loves soccer and he really loves his math class and his favorite subject in school is math, and he's seeking an adoptive family that can meet his needs. And if a family reads that and feels compelled to inquire, when they inquire, our team of family specialists works with that family to make sure that they meet adoption requirements. So linking them to resources to get started with trainings, make sure that they get a home study and get connected to a CPA agency to sponsor that family. And so we're connecting them to resources, helping them through the adoption processes, training, educating, supporting. If a family does inquire on a child and they meet all of the criteria, meaning they've been trained, they have a sponsoring agency and are ready to be considered for adoption, and that at that point is when we share additional information with the family that is a little bit more protected. Of course, we are always maintaining confidentiality and respecting that individual child or sibling group's dignity and confidentiality. But at that point, we'll share some additional information about the child's needs, their case history, and determine if the family could potentially meet that child's needs. So initially, families receive just strength-based information about the child, and then after they inquire is when they'll receive additional information about the child's level of need to determine if they could potentially be a match. That's my spiel. I'll hand it back over to Crystal unless you have any specific questions for me.
Senator Baumgardner. Oh.
I don't really have any questions, but I think that you kind of couched it correctly. It is a spiel. And I think when we advertise and publish, when we publish that this group of siblings are really close and they want to be adopted together, when that's not true, that isn't strength-based sharing. That's false information that's being published. And I think that becomes a very slippery slope. And I think that our children deserve better than to have their relationships so grossly misportrayed.
Yeah.
I'm not saying that we have to put, that they're 2 years behind in school. They're 8 years old and still can't read. I don't think we have to include that. But there are certain things about honesty and honest representation. And I'm not seeing where, even if you're following guidelines that are set federally, where that truth or accuracy check ever occurs. So just because someone told you that, who do you verify? I mean, in journalism, you don't publish unless you have at least two sources that can verify something.
Mm-hmm.
That's a long-standing standard.
Mm-hmm.
So I'm not sensing that there is that standard.
Yeah, and just to explain a little bit about our process, I don't know that I fully touched on that. And if you're referring to anything case-specific, I'd love an opportunity to speak with you about that if there's a specific case-specific in mind that you might be referencing. But as far as the information that we receive it from the case management provider in a referral, and we staff that with them, and in collaboration with them and the child and the placement provider is how we draft that narrative. And so, of course, sibling relationships, that consultation is done between our team as well as the placement provider, which is the foster parent for the child, and sometimes the child when age and developmentally appropriate. But the information about recruiting for siblings together comes directly from the case management provider for the children that is working that individual child's case or sibling group's case. And of course, we don't do that case management work. So we are doing that in collaboration with them and relying that they're sharing accurate information about if the siblings should be recruited for together or individually.
Do just want to add, I think in regards to, we can just acknowledge that there's some case-specific narrative that could happen in another setting. But in general, our staff have do some systems of checks and balances to communicate with current caregivers. And I think that really has been the context the last couple of days, right, is how do we include caregivers into the conversation? And I think that that's something that we can definitely take back and think about if we're doing that on every single referral, or if that's situations where we're contacting older youth for scheduling and things like that. So I appreciate that feedback.
Senator Fascido.
Thank you, Madam Chair. Just speaking in general to your statement of, so all of the children that come into your contact are that need your services. So have all of them been, so their parental rights have been severed, and do you automatically put their information out there for someone to consider adopting them, or do you also allow perhaps that foster parent that consideration first?
Yes, great question. Yes, all of the children referred to us, parental rights have been terminated or relinquished, so they are legally available for adoption. And when referred to us, policy is that they're referred to us if they do not have an existing adoptive resource. So we recruit for children if they do not have a current standing adoptive resource. So and as far as putting their information out there, we have other means of recruitment other than just public photo listing, which I think Crystal might have planned to touch base on that in her presentation. But we have other means of recruitment, including private recruitment as well. As one of our forms of recruitment, we have a child-to-family match and a family-to-child matching system. But yes, they're only referred to us, and I think
But my point, just clarification, is so these are children that are not, when you say they have no one seeking to adopt them at that time, those are the children that come to your services that are referred to you. So none of them are those that have been foster parents and they wanted to adopt. I mean, so where does the foster parent come in there or not?
Go ahead. So we really, to Senator Baumgartner's point, we rely on the information that the case management teams and the foster care teams provide to us in that regard.
Representative Carlson.
Thank you, Madam Chair, and thank you very much. I have a couple of questions just to clarification. So if I have not been in the process of anything, adoption or anything, I can contact you and tell you that I'm interested and request information. Is that correct?
I'll let Corey speak more to information sharing and how that process works.
I mean, I don't have anything specific in mind. I'm just saying, well, you know, my husband and I are interested in possibly adoption.
Yes, we get requests like that every day. We have tons of information on our website, adoptkansaskids.org, information on how to get started with the process, information about the process in general. When a family comes to us and asks for information about adoption, we have several resources that we provide to them, including training and helping them get started in taking TIPS MAP courses, which are required to be a foster or adoptive parent in Kansas. We help provide them information on child placing agencies in the state of Kansas. So if a family comes to us and has no prior knowledge of adoption or how to get started, that is when we'll connect them to those resources and walk them through their steps of being able to become a foster or adoptive parent. If they come to us already having some of that information is when we'll start working with them on matching them with a child for adoption.
Okay, and then the other place I'm a little confused is, say I have a foster child and it's been terminated. So I am so sorry. I have a new something and I can't figure it out. So anyway, so if I'm already on, I'm a foster care parent. So apparently I'm working with an agency or something. Can I still come to you if I feel like there's difficulties or I have questions and I don't know where else to go? And maybe I'm afraid of this retaliation things that we hear about? Because you talked about if they don't have another, the adoption, if they didn't have another agency or another something. So my question, I guess, is if I'm already with someone, I have a caseworker and all these things, and I'm feeling like I'm not being listened to or paid attention to, and I want to adopt, can I come to you then for help?
Absolutely. So I was going to talk a little bit about Foster Adopt Connect's advocacy services towards the end of my testimony.
That's great.
I'm happy to answer your question now, but I think it may take us in a different direction.
Nope, that's fine. Thank you. Thank you, Madam Chair.
Yeah, that was going to be my question to you was, did you get through your testimony? So why don't you go ahead and we'll wait for you to finish. Sure.
So we also do some support for families that connect with us, primarily through their child placing agencies. There are families that say, listen, fostering isn't for me. I'm not sure that my heart can handle giving them back and supporting them returning to their families. I think that those families sometimes, I think that our child welfare staff who really focus on reintegration, like that's what we call them to do, right? Focus on reintegration and safely return children to their families. I think there's some reservation sometimes when families come to us specifically for purposes of adoption and say, I'm not sure I can support that. I can understand that, walking in the shoes of a case manager at one point in my life, but I also think that there's value to people who know their skill set and what their family can and can't support. So we do have youth in Kansas that need to be adopted, and I think that those families are a great resource for them. So those families may work with other child placing agencies, similarly to DECA. We work with DECA quite a bit for families that they might be supporting that know that they're interested in adoption. So they can register them with our website, and we complete a profile for them, and we can use our technology systems to match them to youth in care that might be a good fit, and facilitate conversations between the professionals supporting the kids and the professionals supporting the family to determine if that's a conversation that we should move forward with and present additional information about the needs of of specific children to those families. So some of that behind the scenes matching that happens, we support families through that as well. So if there aren't any other questions about Adopt Kansas Kids, I kind of wanted to shift to post-adoption support for families. Our K-Park program is a team of 4 advocates who, with intention, have all...
Sorry, did you have a question? Wait, okay. Okay.
So K-Park, as I was saying, is a team of 4 advocates. They have all provided care to children in foster care at some point in their life. One of our advocates was a kinship caregiver who ended up adopting, another a foster parent who adopted, and another was an adopt-only parent. So a good variety of experience there, but it's with intention that they have lived experience caring for kids not born to them and can really be empathetic to the needs of our families who have chosen to adopt from foster care. K-Park is really a high-level post-adoption support, so you won't see our advocates going into the home unless a family lives very close to us in Kansas City, but we serve families across the state who come to us, and they're experiencing challenges as it relates to adoption. So some of them may be families who are foster families, and they're saying, I want to adopt, but I'm struggling. I don't know where to go from here. We may support them. We might support families who adopted 10 or 15 years ago from another country. We might support foster parents who are in the process but struggling to navigate the adoption subsidy process. We may support families that their child is now a teen, and there are specific strategies around supporting those families who have been impacted by trauma and supporting kids who have been impacted by trauma. So the scope there for families is that we connect them to other people, other professionals who have adoption competent services to offer them. We can provide that peer-to-peer support for them and really helping remind them why they signed up to do what they do, and when times were good, bringing that back to the surface and hopefully preventing disruption for some of those families. So we serve about, I would say, 35 to 40 families every quarter reach out to us in one way, shape, or form. We accept referrals in any way, email, text, phone call. Sometimes court professionals will reach out to us and say, I think this family needs some support. Sometimes DCF will invite us to participate in a team decision-making meeting. Really, in any way that we can help support a family, we will reach back out to them and do so. And we offer 25 to 30 trainings every quarter for families that they can participate in. They're all trauma-informed care, all have a level of adoption competency to them. All of our trainings are offered by someone with lived experience as someone who has adopted from foster care. So that's an excellent component too. We offer retreats for families. We just transitioned those back to being in person. Did one down in Pittsburgh and had a full room full of families. And they had free hotel stay, childcare stipends, and walked away with really some tools to help support them and improving their parenting skills in their home, but also just having an opportunity to connect with one another. Sometimes our families feel like they're out on an island by themselves and no one understands them. So by connecting them to one another, it really normalizes their experiences and the challenges that they're having. So that's a brief summary of K-Park. Any questions about post-adoption support?
Representative Johnson, did you have a question that you wanted to ask now?
Sure. Thank you,
Okay.
Madam Chair. Just looking through your information on KC 1021 radio, I'm just curious how you partnered up with the radio station and information. Do you know?
Corey, do you want to speak to that? I had walked back thinking, no, that's okay. Yeah, we have community partnerships with news stations and radio stations. I actually think that one of our marketing and development people at Foster Adopt Connect is who connected us to the radio station to have that opportunity to work with them.
Do they charge? Do you have to pay a fee to be on the website, or do you know?
That I don't know. I think they had donated that to us, but to be honest, I'm not sure.
Just curious, do you get much feedback on, or if you know, do you get feedback or contacts? Because I've read through the 2 pages.
We have when families come to our website and create an account and register, we have a "How did you hear about us" section where they choose, and radio and news usually falls between the 15 and 12% range as far as how they heard about us. Normally, they're hearing about us from social media or from a Google search. So.
Thank you. I just found it interesting.
Yeah. Thank you for your question.
Okay, other questions? Okay.
So I did want to talk a little bit about our advocacy services at Foster Adopt Connect. So advocacy really is the root of our agency. We were founded by a group of foster parents who supported one another and felt like they could offer that to other families who are experiencing some of the same challenges navigating caring for kids not born to them. So it's with purpose and intention that we have integrated advocacy into all of our programs, and it really is the bedrock for us and something that I feel pretty passionately about and have found myself here with Foster Adopt Connect. 40% of our staff members have some sort of lived experience as it relates to foster care and adoption across both Kansas and Missouri. So 20 years ago, we started with 5 employees, and now we have about 300, just sticking with that philosophy and approach in supporting families who are in need of advocacy. Advocacy can look a lot of different ways, but I talked a little bit earlier about how families can connect with us and how we get referrals. That really applies to all circumstances. There are times when someone will text us. I have, relationships with other professionals that text and say, here's the family's name. I talked to them today. They're struggling. Can someone call them? Absolutely. We do have a place on our website where families can access advocacy services. It's really client-driven or family-focused, and so you won't see a space in there for professionals to say, hey, I'm a professional. There's not like a text specifically for professionals to say, I'm referring this family, because we want it to be family-led and family-driven. But if professionals want to go that route, there is kind of a any additional information that would be helpful. And so we just encourage professionals to put their contact information in there and why they might be referring families to us. But I feel like I've rewritten this testimony so many times over the past 2 days because there's been so much helpful information presented to the committee. And so I did just want to talk a little bit about how we handle advocacy cases when folks come to us for support, and also just weigh in on some of the conversation if the committee would be interested. But so advocacy cases, when someone reaches out to us, the first thing that we do is contact that family and just listen. Sometimes it might be a 5-minute phone call, my medical card's not working and I don't know what to do. Simple solution, right? We make some phone calls and we walk alongside the family to get that issue resolved. Other times, it's a 2-hour commitment. We're sitting and we're listening to families like you've heard from throughout the life of this committee, and we listen to their stories and really try to just hear them out and understand what they've been through. And our staff have that experience and have probably experienced something similar before. So we do that. Then we touch base with the professionals on the case or the other folks involved. We have a release of information that the family has allowed us to reach out to them. Just being frank, sometimes we have a warm reception from other professionals and sometimes we don't. I think it just depends on the circumstances around the case and oftentimes the experience of the workers that we're communicating with. So we have contact information for most of the agencies across the state and personal relationships with them where if we're not getting what we need from case managers, we have opportunities to reach out to supervisors and directors and vice presidents and sometimes the people in this room to help clarify things for families. But so second step is we gather all of that information and then we want to facilitate communication. We want to empower families to be their own advocates with us in the corner, helping support them in that. So we facilitate communication and really just do some mediation between the family and the professionals and helping them find the common ground because they do have common ground, right? We're all here because we want what's best for kids and their families. And so helping them find that. And a lot of times it's just understanding the perspective of the person they're communicating with. I personally understand what it's like to be a case manager with the responsibilities. You're caring for how many of our kids on your caseload, and you're responsible for educational records, making sure that those, being an expert in IEPs, right, and advocating for your kids' needs to be met in that way. You're responsible for making sure that records get from one school to another when placements change. You're responsible for helping find appropriate placements, doing mental health referrals, communicating with foster parents and caregivers about what kind of information do I need to complete that mental health referral, being an expert in IDD, being an expert in court systems and processes and medication management. What meds should this child be on? What meds should they not be on? Guiding therapists to have appropriate conversations depending on where the case is at. So all of those things our case managers are juggling. And so it's being respectful of that, understanding the responsibilities that they have and helping support them, but also helping our families understand some of that, and then vice versa, right? Helping case managers who oftentimes don't have kids, like you've heard today, helping them understand the challenges that the foster parents might be experiencing in their home and the challenges that they have caring for multiple kids with different needs, managing school supports, managing IEPs. They're doing a lot of the same things, right? Just in different capacities. And so we try to help facilitate that communication, help them understand the challenges that each of them are having, and then come together to make some shared agreements on how to move forward. We do that by chunking off small tasks, right? Building trust and relationships between those folks. So if foster parents request a meeting, we're going to behind the scenes make sure that that case manager gets that meeting set and that the foster parents are there to participate in that meeting. And oftentimes it's not an intentional move. Sometimes it may be, but most of the time it's not intentional that somebody gets left off of an email invite. I myself have been waiting to get a meeting scheduled tomorrow afternoon. I just got the invite today and I got it forwarded from another professional. They're like, hey, oops, saw that you weren't on there. So with all of the things and the moving parts, I think that there's miscommunication that happens, and we feel that that's intentional sometimes, right? We feel like there's intent and purpose behind every action, and sometimes it's just an accident. It's a mistake, and so we try to help work through those. I also just want to talk a little bit about initiatives. We as a state are really, really assertive in trying to find the best ways to serve our kids and families. We continue to add responsibilities to our case managers, and it feels like nothing really ever falls away. And we have great ideas. Years ago, we did the rapid permanency reviews, where we would take several cases that fit a certain criteria, adoption cases specifically, and we would go through those step by step and check every step and every date in the process to identify what are the bottlenecks in our process. Right? And our case managers spent a significant amount of time, and our leaders spent a significant amount of time partnering with Casey Family Programs to bring this opportunity to Kansas to really figure out where are our bottlenecks as it relates to adoption. And in that planning phase, case managers spent hours preparing information for these committees. They came to these teams of people who were conducting these reviews. They had to have all of their ducks in a row, all of this information, and that was in addition to the responsibilities that they had day to day, communicating with caregivers and supporting these kids. So all of those things come at a cost, right? It's above and beyond the task that we've asked them to do. It's for a good cause. It has good intent and good purpose, but those sometimes take away from their opportunities to have conversations with foster parents. So when I think about the last couple of days, how we need to be thinking about a shift in allowing foster parents to do the job that we've asked of them. I keep saying foster parents, but it's kinship caregivers, it's teachers who have stepped up to provide care. So how do we empower them to do the tasks that have been assigned to them? And we're making progress. Recently, we just had a policy change that allows foster parents to sign, to take kids to mental health practitioners independently and on their own without requiring signatures of case managers. So, and really normalizing that our kids need access to mental health services similar as they do to go to the doctor to get their teeth cleaned. So let's empower our caregivers to do some of that. So I think we're headed in the right direction, but an ongoing conversation about what is redundant for our staff that takes away from their ability to connect with these caregivers and to make them feel heard and build those relationships, which I believe will have positive outcomes for kids. To touch a bit on guardian ad litems, and I would be remiss to not just share some of my experiences. I have worked in all of the counties east of Wichita at some point and another in my career with multiple guardian ad litems in each of those counties. Throughout that work, I have met one guardian ad litem who consistently, without fail, went to every child's placement on her caseload and met with them every month religiously. Had it not been for my experience as a foster parent, I would have never probably met her. But the day that she called me to say, hey, I want to schedule a time to come see the kids, I was like, uh-oh, what did I do wrong? Why are you coming to see me? And she just said, no, I do that. So shout out to Kim Robinson if she's watching today. Unfortunately, she's no longer a guardian ad litem, but I think it's important to raise up the good work that some of our staff do and some of our helpers do. And so there was some conversation around conflicting interests. I think that those conflicting interests for guardian ad litems are no different than our case managers, right? Our case managers are tasked with making decisions about kids who have very different needs, but also have shared goals and shared families. So I do think that there is some value to that, but I think that that's the same challenge that a lot of our case managers and foster care workers experience as well. I would also just point out that I think the guardian ad litems have 6 hours of continuing education that they have to do specifically related to child in need of care related issues. guardian ad litems are given a big seat at the table to have an opinion about the best interest staffing and what's in the best interest of a child that they may or may not know, they may or may not recognize. I've been in court sitting beside Johnny where the guardian ad litem walks up and says, "Hey, is Johnny here today?" Meet Johnny. And conversations with a kid for 5 minutes at court prior to a hearing is not enough to be able to make decisions about what's in the best interest of a child. And that's where we can raise up the voice of our caregivers, I think, too. We talked also about CASA yesterday. CASA is great. I've experienced really great relationships with advocates for kids who otherwise didn't have anyone. I see the work that they do. I do just want to point out that the reports that they provide to the court are often lifted up and their voice is heard. CASAs go through 16 hours of training, I believe, in person. They commit 5 to 8 hours, through the testimony yesterday, they commit 5 to 8 hours a month serving those kids, spending time with those kids. Our foster families do 30 in-person hours of training before they can take a placement. They are with our kids 24/7. Their voice should be at the table in every conversation that we have. I think that that's an important piece, and having relationships with them. I won't lie that there have been advocacy cases that I myself have had where I've had to say to a foster parent, we need to take a step back here and really think about what's in the best interest of this child. And it's hard. It's hard. I've been there to send kids home. I've been there to send kids to relatives. It's not easy, and our hearts get in the way because we're just human. My team is really, really great at having those conversations with foster families and other caregivers because we've been there. We can sometimes say things to families that case managers can't get away with, like, you're being a little emotional right now. We've got different ways to say that, but we can say that to families, like, we need to step back and think through all of the things that are happening here. So we are a resource for all of you who interact with your constituents and are hearing these stories and these struggles. We have in the past in Missouri had legislators reach out to us about concerns. Just take a look, see if there's a way that we can support this family, and then let us know how you and the family are working together. So that's no different here. Part of what I heard yesterday was we heard the Briscoe family say, I didn't know what else to do. And I think we have resources to help them. Our agency is a support. KFAN, I saw representatives from KFAN here yesterday. They do an excellent job working with kinship families and having relationships with them. They also develop good relationships with biological families. So there are some resources here who have DCF funding, but really do have a third-party approach to, we are not a child placing agency, we are not a case management provider, and we can help these families navigate some of these situations. I think the last thing that I just wanted to touch on is ICPCs for relative and kinship caregivers. The question for me is not if we should be doing ICPCs or if we should be exploring relatives, but when. And this is a conversation we've been having for years, that we don't do it when we're supposed to. And I think that we all have looked at one another at certain times and said, if we would have just submitted that request and started building that relationship with those caregivers early on in the case, we would not be looking at this right now when it's time for adoption. And it's probably a little complex of a statement, but adoption work starts at the beginning, right? We cannot wait until some of our CMPs have reintegration teams and they have adoption teams. We cannot wait until these children get in the hands of an adoption case manager to start exploring relatives. It's required that we explore relatives and kinship caregivers before we can ever move towards an adoption. That's part of the process. It's part of the statute. It's about when we do it. And that's the challenge. When we do it should not be when a child's 4 years old and has been in the same placement. And that's why we get in the sticky situations we're in. So I believe that the resources are there. The policy is there. I think the practice is where we need to continue working and educating. And if we can reduce some of the redundancies and busy work that we're asking of our staff, hopefully they would have time to reallocate that to places like that where it's really needed. So I'll stand for questions. I've talked long enough. Thank you.
Well, great, and thank you for addressing some of the things we've talked about in the last couple of days. Questions? Well, goodness, you must have just told us everything. We don't have questions. Thank you.
Very good. Thank you.
Okay, next up, we've got Kathy Armstrong with Prevention and Protection Services of DCF. So, hi, Kathy.
Hello.
Hi.
Chair Kincannon and members of the committee, want to thank you for the opportunity for me to be able to be here and testify. We had received a specific request that we're focused on, and if you'll excuse me, I hope you'll be patient. I'm about to lose my voice here the last couple of days. So that specific request was around adoption data, best interest staffing, sibling split process, and DCF adoptive relative. So I'm going to first just indicate that I am Kathy Armstrong. I'm Assistant General Counsel at DCF, and my primary focus is with Prevention and Protection Services Division. Prior to joining DCF about 10 years ago, I was in private practice for approximately 22, 23 years, and with, again, primary focus on family and adoption law, probably the last 20 of that. So I've appreciated coming from a private practice lens and then having the opportunity to work with the agency. So I'm going to go through a PowerPoint, and I didn't know if that was going to be, is that just being provided to you all, or how best do I need to do that? Thank you very much. Okay, and just on the right to advance? Okay, thank you so much. So, trying to see where I can see this the best. Adoption data, there are basically federal outcomes, and we kind of align those also with state outcomes that must be tracked and must be reported to our federal partners. And those generally align with best practice based on research, statutes, both on the state and the federal level. And so I'm going to go through there. In your attachments, I will go through that subsequently on everything that's been provided to you. When a child is placed by the court into the custody of the secretary, then the child welfare case management providers, which you'll hear those referred to as providers. I think folks that have been around for some time used to refer to them as contractors. Now those are pursuant to grants, so we often say grantees, CMPs, but essentially those are the agencies, and therefore major agencies that act on our behalf to deliver foster care and adoption services. And so they work with the child's family, and the networks of support to address and resolve concerns so children can be safely returned to their home. In the vast majority of cases, reintegration, reunification is always going to be the first case plan goal. And 56% of our children will return to their homes. And so that's always the first efforts. When it is not possible for a child to return to their home, parental rights may be voluntarily relinquished or terminated by the court, and the child is then available for adoption. Once all those reunification efforts have been exhausted, then relative and foster families are often the ones that we look to adopt the children. The adoptions increased in state fiscal year 2019 and averaged about 1,000 annually over the past 3 years. The average age of the child, 7 years, and about 2/3 of the adoption of children adopted are 8 or younger. The average length of time in care is 40 months, and over half of the children are adopted as a part of a sibling group. and it's noted at the bottom of this, there are various practice enhancements, and it names a few. I know Crystal mentioned this in her testimony previously, rapid permanency review tools, addition of non-carrying case adoption accelerator positions, which are those that can help assist as kids are prepared to go toward adoption, with the case management, providers agency, and development of the BIS waiver. This shows just a graph, and we're talking about the same numbers. This is part of your package, and so I won't spend a lot of time on that, but it just is another way of displaying the data. In state fiscal year 22, nearly all adoptions are finalized with a relative or foster parent. State fiscal year 22, 48.7 were with a foster family, and 48.3% were with a relative. The prospective adoptive parents, who are the current placement providers, their child placing agency, which that's the sponsor of their home, assists them in completing the necessary items to proceed with an adoption. These tasks include completion or updates to their home study assessment, and the assessment that we would be doing as an agency, it aligns with what is required by acronym CARA, but the Kansas Adoption and Relinquishment Act. Their KSA 592132 is very specific in who can do an assessment and what needs to be included in that assessment. And so that's what is put into the assessment, because we need to have the case prepared for the child to be able to proceed to the adoption case. There are also certain background checks that are required and various supporting documents. On this slide, again, there's more data that just sets out, and it's another way, again, of displaying what I have already indicated, is that during that state fiscal year 22, there were 48.7% were adopted by foster parents, and then 48.3 were by relatives. The best interest staffing, I know there's a lot of discussion around this in the time that I've been with the agency. Those policies have been updated numerous times, always trying to improve that practice, to strengthen it, to clarify it. It is not a process that is set forth in statute. And usually the way I describe it is that I think it is a methodical process that was developed by the agency to ensure that there is some consistency in how selection of adoptive resources are made. Because without that, everyone would be kind of starting at a very starting points. And so the best interest staffing really allows for that structure. Once that child is legally free, so all appeals have been resolved, they're not moving forward in that way, there's been a TPR and or a relinquishment, then a best interest staffing is considered for scheduling to select the adoptive family that can best meet the needs of the child, which is always paramount. The best interest of the child is set forth throughout in statute, and it's also woven throughout our policies. The policies that specifically relate to best interest staffings are, and it says PPM, that's a Policy and Procedures Manual, and it's 5339 through 5341, which are also attached to the package that you had. Just within the last 2 to 3 years, there was a process changed, and policy now allows for a BIS to be waived if certain criteria are met. And I apologize, I'm going to advance that. I'm looking at my own notes here. Thank you. First of all, the child must be legally free for adoption. There is just one potential identified adoptive resource who is a relative, non-related kin, or foster family. And if the child is not placed with a relative, concerted efforts were made to identify a relative. The child has been placed with that one identified resource for a minimum of 6 months. So it was decided that given the complexity of the BISs, the time that's required, resources, that it really didn't make sense to be convening those when there was only one adoptive resource, and this other criteria was met. And so that waiver is now part of policy. If the criteria are met, the case management provider is to send notice and information to all of the required BIS participants per policy to ask if there's any objection. If one person that would be invited to that BIS staffing otherwise objects to it moving forward in that way, then a BIS will be convened, because it was determined that we did not want that to not occur even if there was one participant that opposed that. When any BIS is scheduled, the case manager will send a packet, including but not limited to the home study or assessment that was referred to, for each potential adoptive family or individual that are being considered to require all the BIS participants. Information is presented and considered. The policy was updated in October 2019 to reflect a consensus rather than a vote. Prior to that, there was a vote taken at BISs, and it was determined that it would be better practice for there to be discussion, sharing of all relevant information, and that there would be a consensus reached. The participants are listed on this slide, and they're also set out in the attached policy that you all have. Youth ages 14 and older, their current case manager, support worker, the guardian ad litem, the therapist or service provider, assuming there is one, and there often are in these cases, court-appointed special advocate, their CASA, if there is one, a court services officer, if one is involved, and any other supports that might exist for that child. Once a decision is made, then policy requires that within 5 days, notification must go to the families. The families that are not selected are also to receive notification. And they can ask for a review of that decision if they want. That will go back to the case management providers, and it must be a completely independent reviewer that has no potential conflict of interest and was not part of that decision-making process. On this graph, it breaks down, we basically have 6 regions for DCF, but there are 8 what we call catchment or service areas. So this breaks down in each area where there were requests made for a review, and then what the, basically, there's a statewide percentage indicated. So those numbers would show you where people were not happy with a decision and asked for a review of same. There is no appeal of a BIS decision because it is not in statute, and it's not one of the appealable orders in the sync code. So it will often be at that juncture that if somebody is not happy with a decision, that you may see them then go to the court and submit a motion for direct placement, which could be considered by the court. And I don't have data on that today, but I can tell you it's generally a fairly small percentage of our cases that would ever have direct placements made, but it does occur, and it can occur. There are certain losses of benefits if the case does proceed in that way, from the medical card to adoption subsidy, but it is something that the judges can consider. Lastly, we were asked to cover information regarding the sibling split process. The importance of sibling connections may vary for each individual. And obviously, as an attorney, I would say you always must look at the fact situation of each individual case and determine, really based on those facts, how you need to proceed. However, generally, sibling connections, and our federal partners talk a lot about this. A most recent federal legislation, it really clearly established that even siblings that had been previously adopted would be included as siblings. And those connections provide a sense of community through childhood. And this connection is often one of the longest relationships some of the children will have throughout their individual life. The connection may be intensified in families who have experienced abuse or neglect or trauma, as siblings may be the ones that provide support and nurturing to each other when parents are unable, unfortunately, to fulfill that role. The siblings who are placed together in foster care may have greater chances of reintegration, are more likely to reach other forms of permanency, such as adoption and custodianship. I know we are focused on adoption discussion today, but permanent custodianship is also an option in the SYNC code. They will often have fewer disruptions and experience generally better outcomes than siblings who are not placed together. And again, I'm speaking in terms of generalities regarding that issue. Adoption policy. We're going to talk briefly about relatives, including siblings. And our definition of relative in the SYNC code is related by blood, marriage, or adoption. It's quite broad, and that's summarily. There is also a definition for kinship placement, which essentially relates to when we say "and our kin," those with whom the child or the child's parent has a close emotional tie. These next few slides, again, I know Crystal referred to the rapid permanency review process. This document was really the original, was prepared with Casey Family Foundation, and it used our statutes, OJA, and DCF legal program staff. We jointly collaborated with Casey to prepare this. It's been somewhat updated to include any changes that have been made the last few years. But that gives you a very good process kind of flow chart from the time there's a termination of parental rights and how that will flow to eventually reach a finalized adoption. So because you have access to this, I won't read through all of this, but please feel free to ask any questions if you have regarding that flow chart. On this slide, which is toward the end of this, I did want to emphasize that once that adoption family is selected, we used to say that they may read the child's file. There will still be families that sometimes say, oh, I don't think we need to do that. But I can tell you in policy now, we require that the workers tell the family they need to read the child's file. There is a lot of information in there. It will really help them in preparing for how to meet that child's needs. It will help them understand more about the trauma of that family and just the general outlay of all that they have experienced. And so it can be very beneficial. There is an adoption assistance packet that is prepared, which has to do with a subsidy. There's an adoption placement agreement that is prepared. And eventually, there is a packet that will go from our agency to whoever the attorney is that's going to handle the actual adoption. Adoption is handled under a totally separate chapter of the Kansas statutes annotated. It's chapter 59, 2111 at SEC. The sync code is in Chapter 38. A number of the sync judges will hold on to the adoption cases because they've presided over those cases and they want to see it come to a positive outcome of completing an adoption. Others do not. They will have totally separate courts, but it is a separate filing, separate case number. And I am now going to quickly go through with you, and I do appreciate your patience because my voice is not in its finest form today. I do want to just kind of go through quickly. These have all been labeled as appendixes, and then if it's okay, I'll stand for questions right after that. The first documents that you will have that are noted as being Appendix A through D, those are reports that are posted on our public website. They align with federal outcomes tied to adoption. And so you can go through and look at those data reports. You can also access those on our public website. Appendix E is a checklist for request for consent to adopt. That checklist is everything that our agency needs to ensure we have put together in a packet so that when it goes to the adoption attorney, they're going to have everything that they need. And that checklist is pretty much, again, devised by looking at Chapter 59 to see what all is an adoption attorney going to need to successfully process that case. Appendix F is the flow chart that I had just briefly gone through. And so if you have any questions on that later, please feel free to ask. I know that Dr. Byers and Lana Getz with OJA had talked with you about the adoption tracking tool. I did attach Appendix G is the instructions for use of that tool, and Appendix H is the actual adoption tracking tool. This was a very collaborative effort between OJA, DCF grantees, KU, and it was based on a project that courts and the agency and the University of Kansas School of Social Welfare identified as something that would be a helpful tool to develop. That went into statewide implementation July 1 of 2021. As with any new form, it is a transition period for everyone to be using it consistently. But we are really working with the courts. We have a very good, robust collaboration with OJA. So we are really trying to work to message both to our grantees and to the courts that once a child is legally free for adoption, this document should be attached to the court report. And again, it will help the court and the worker identify, where are we in this case and what is it that we're missing? Is it ICPC that's delayed? Are there ICWA issues? Has there been, what are the barriers in everything that we need to be doing to move this case toward adoption, trying to help identify that. On Appendix I through, I'm going to quickly look at the last one, through N, we have attached various policies that are out of the PPS Policy and Procedures Manual. I will say that I am on our policy work group. We have many groups that feed into that with input. A lot of the policies are based on statutes, both federal and state. And I often say, when you look at the sync code, you can't tell what we have imported to ensure that we're in compliance with federal child welfare law. But there is a lot in our sync code that aligns with federal legislation. So policies should be ideally based on statute and best practice. But that does not mean that they are not constantly subject to review and improvement. They usually are reviewed on a 6-month rotating cycle. So new posting is generally done July 1 and January 1. Now, I am going to end with just stating that you do have an attachment that again came from we will refer to them as federal partners, but we work closely with ACF and Children's Bureau, and the Sibling Issues in Foster Care and Adoption is a handout that was prepared by them, and so we have attached that as well. Now, I will be glad to stand for questions. I thank you very much for your attention.
Well, thank you for powering through with your voice.
Yes, thank you.
It sounds strained. Representative Humphreys, the question.
Thank you, Madam Chair. I do have several questions. So thanks for being here. It's good to see you in person.
Thank you. You too.
We see each other on Zoom meetings sometimes, so it's good to see you in person. So several questions. One that I've asked today before, and just in your opinion, it's about the authority. Does a judge have the authority to not follow placement recommendations by agencies? Does he have discretion to not follow the recommendations of the agency or the grantee?
In general, are you talking about placement or selection of adoptive resource?
I mean, both. I mean, placement, okay. but especially, adoption resource. But
okay. Well, I think
placement.
To answer that, and I'm going to give you my opinion from my role, but custody is defined in the SYNC code, and it basically says, whether temporary, permanent, that it means that when you vest authority in a custodian, which if the judge appoints DCF as a legal custodian, the secretary, then the right to physical custody and the right to determine placement of the child rest with that agency. There is a qualifier in the statute which says subject to restrictions placed by the court. Now, that does not generally happen because generally the courts do. They recognize that by placing, legal custodianship with the secretary, that they are also granting the authority for placement. But are there occasions where the judge, and judges go about it differently. Some may have some opinions and say, I would like the grantee to be looking at these options or help me understand why that option was not considered. Or so it's sort of a guiding, but it's not ordering, because I think generally the courts recognize that they've granted authority. The restrictions, they may say, it's up to you, but I'm going to restrict placement in this one placement just because of my history with that placement. I'm going to be asked that they're not. And there was a judge that did that in a couple of cases. So I think generally the courts look to DCF as a custodian. I think they have statutory authority to place, and they look to them for that. In terms of the adoption, I think that, again, in 382270, when the court grants the authority for adoption to DCF, that generally they are allowing DCF to make that selection. And the option, which is in 2 of that statute, is an order granting custody to be directly placed with an adoptive family, which is what we call direct placement, although it's not described in that way.
Yeah.
So is it possible? I would never say nothing's possible for the courts to do, and I think generally the courts are charged with overseeing best interest of children. But I think also most of them practice in a way that they do grant DCF the authority to place.
I appreciate that. You've answered that question more clearly than we've heard so far, so I do appreciate that. Sometimes I wonder why we keep having hearings, though, if really the court can't do anything or won't. But anyway, that's beside the point. So, okay, my next question has to do with, and this is, we implemented Family First, and so we're trying to do a lot of things on the front end to keep kiddos from being removed from the home. And as we know, the number of foster children in Kansas has decreased. And I think in part because of the services that we're offering to families. And so when it is dire circumstances and children have been removed from the home, it's not neglect, as, now we've kind of changed those importance of when we take kiddos out of the home. But because now it's more dire circumstances, how has that affected the timelines in dealing with adoption? Because it seems like if we've already helped families, we've done things on the front end to help them, and it hasn't happened, so therefore we've removed kids from the home. It seems like the timelines would be shortened because we've already, the families have already been given lots of resources. So I'm just curious if your thought on that, or if we might see that in the future, or where that might lead.
So I would say that generally, theoretically, that is true, but even if you look at our map for Family First Services Prevention Act grants, there are not all services offered in all areas across the state. So though we would wish that all services were readily available for all families, I think that's what we're working toward, but that is not always the case. So I think it still can vary between families how many services they may have received prior to children coming into care. I think there are a number, I'm just going to go back, I think you need to look at facts, circumstances, and I think substance use is a factor in many of the cases for children that come into care, and that sometimes those treatments, recoveries, relapses do not always follow nice prescribed timelines. We do have timelines that are set forth by the federal government and that we are monitored for that are supposed to keep those within reasonable timelines, and they're specified in statute as well. So I think that generally we work toward that. Is it a perfect system? No. So I understand what you're saying, but I think we're still in the process of really shifting that to prevention and making sure that all needed services are really available statewide to all families.
Yeah, super. Okay, that makes sense, and maybe we'll see some improvement in that as we offer more services. And then my next question has to do with that, the subsidies and the loss of benefits with direct placement. I mean, I'm just going to say, hearing about it today, it seems like, is that punitive for people who go around the system, and so therefore they ask for direct placement, so then they don't get the subsidies? Today, it sounds like that might be true, but I would be curious of your opinion. And then who decides if they're going to get the subsidies or not? And so maybe my assumption is completely wrong, and that would be great. But if you would comment on that.
Okay, I understand, because I think I can understand how it could sound like that. So in giving some context to that, there is a federal adoption assistance and a lot of funding that goes with that. And so in order for that to occur, then there does need to be a process of adopting out of the foster care system. And so for those subsidies of people who go through that standard normal process, most of that funding is federal dollars. It's not state general funds. And in the small minority of cases, and I would generally say it's our admin, permanency admin, or even our leadership, that would need to decide if there is outside of that process where it's going to require state general funds. That's a very different, so there have been very, very few grantings of subsidies in very unique cases that ended up being state general funds because they did not go through a normal process. And it's my opinion, there's no way as a state that we could sustain that, because those federal dollars are really what allows us to pay those adoption subsidies and not have it come out of state general funds. So when we say there'll be a loss of subsidy, it's basically there's going to be a loss of that federal funding coming to those cases. So it's really not punitive to me. It's just a pragmatic reality.
Okay. Then my last question, thank you for that answer. My last question, Madam Chair. It's about siblings and the definition of siblings. And, you know, you gave us this, the sibling issues in foster care and adoption. And I pointed this out before, but on page 3, defining a sibling relationship. And, you know, siblings to children might be another foster child in the home where they've been for several years. And so just pointing out, you know, when we're talking about a sibling split, you know, if we're taking a child out of a home that they've been for 3 years with a foster sibling in the home, you know, either biological or maybe another foster child, and putting them with blood siblings, that's actually a sibling split too. And I don't know if the agency recognizes that, but I just would ask you to think about defining sibling relationship and decisions. And then the last thing is, you know, you in your testimony, you just talk about the, you know, foster siblings placed together have greater chances of reintegration, fewer disruptions, blah, blah, blah. Could we have hard data on that? I'd like to see that is actually, you know, those outcomes are, that we have data on that.
Okay. I have, just because of another, you know, committee that was serving on, I mean, have asked our, you know, Children's Bureau, ACF, and they were working to gather research that supports, you know, these outcomes and what we consider to be best practice around siblings. So I think if we could garner that, we'd be glad to share that with you. In terms of definitions, it doesn't strictly meet the definition. However, I fully understand what you're saying. It's about relationship and connection. And so what I would say, and I'm not prepared to talk about any individual case today, but that all of those facts and circumstances should be considered in terms of making decisions about placement, sibling splits, and what is in the best interest of that child and, you know, that sibling group, given the facts and circumstances of the case.
Yeah, great. Thank you. Thank you. I appreciate
Thank
the
you.
answers. Thank you, Madam Chair.
Other questions? Representative Johnson.
Thank you, Madam Chair. As I went through your presentation, it was very helpful to me on several things. Some follow-up questions. The BIS, behavioral assessment, requires a new one if requested by, as I think we said, one of the interested people of interested. How did that?
Yeah, that was a BIS waiver. So we used to require BISs in all cases. And then when we started looking at it more closely and the time and resources that were being expended when there was only the one adoptive resource. So what I was talking about is if that criteria for the waiver is met, then the information is to be sent out to all BIS participants. The people that would be invited to a BIS, you're supposed to send it out to them and say, this meets the criteria to waive a BIS. And so do you have any objection to that? If one, say the GAL or the CASA, say, yeah, I really think we should proceed in having a BIS, even though there's one identified resource only, I still think there would be information that would be good for us to discuss. Then there will be a BIS. So that's, is that, am I being clear?
That answers my question perfectly, because
thank you.
As we've been sitting here, I've been getting some contacts. We have an interested party in a particular case who has formally requested one, and has had no response yet. So what is the legal notice that's required? The request was sent by email. Do you require legal process, a formal notice of mail or certified mail? Is there restrictions?
There is not legal notice attached to the BIS because BIS is not in statute. And the beauty of that is it does give the agency the ability to continue to hopefully improve and revise that process. And the waiver is one example of that. That did not exist a few years ago, but now it does. So there is not a legal notice. I would say that probably most of that communication is, by mail and or email, but I certainly could go back and we could see if there might be a way of ensuring that you're sending to the most current address, but.
Correct, and I did look at the addresses, and they appear to be the same ones that have been in the flow. So, in the particular case I'm dealing with, I'm not going to use names or anything of that. A judge recently issued a stop or a hold on an adoption in which 4 siblings were originally going to be adopted out together. There's been a lawsuit filed. Okay. Now there are only 3 people, but now there's a lawsuit. Wouldn't that clearly indicate some issues that require a new BIS?
Well, again, I'm not prepared to talk about any individual case, but you do need to look at the fact situation, what's occurring, and what might be best practice in proceeding in that case. And I think you make a very important point. When there are cases that are open sink cases, and there is a judge that is presiding over that case, I think it especially becomes very important, because we will get calls sometimes, well, what do I do now? Refer back to policy, but I cannot give legal advice. So the advice is work with your attorney and work within the processes within the court. Because as long as there is an open case, then ultimately the judge is still presiding over that case.
And I agree with that. The last one, who can be present at a BIS, said teachers, other interested parties, et cetera, which leaves quite a bit of latitude. Am I correct? What is the process for filing to become one of those interested people? I'm interested personally, having done investigative work on this one case. Where do I send notice? How do I handle that legally?
Well, I would just say generally, if someone is interested in a case, has connection to a child or connection, that they need to be working with the child welfare case management provider, because that case management provider is the one that is going to be working to convene that. So you can look, 5339 sets out generally, and it is attached to your package.
Okay, good,
so
good.
that resource is in there. And but the CMP or CWCMP, they are responsible for convening that and notifying. So those are really the individuals that need to be contacted if somebody has a specific interest in a child. But again, those are not legal proceedings. They should be gatherings that are all focused on best interest of that child and the selection of the adoptive resource.
Give me 1 second here. If there are time frames involving movement of children within the next 7 days, how do we ensure that the proper hearing is done in a timely manner to accommodate that time period?
Well, again, I'm not familiar, I'm not able to talk about individual cases, but I would always go back to the sync code. There are statutes that talk about change of placement. There are statutes that talk about emergency change of placement. There are processes set out there. And so I think that's what I would always advise people, go back to the Child in Need of Care Code to determine what statutes, if any, would apply to the situation that you're referencing.
Did you have a number? And I really appreciate the new books. Thank you so much.
Yes, thank you.
Did you have a number in there I need to go to look that up?
I would say just work with an attorney that's involved, or I think just working within the sync code process, because there really are there's a lot of good information in there in terms of the sync process. So again, I'm not in a position where I can legally advise. I can talk about processes and talk about our policies, but I cannot advise.
You have been very helpful, and I appreciate it. Thank you, Madam Chair.
Thank you.
Representative Ruiz.
Thank you so much for your presentation.
Thank you.
In your opinion, when is it a good time to ask for an attachment study?
Again, that is such a difficult question because it really depends on facts and circumstances, I think, of the case. You just really need to look at what is the makeup of the family, what is the trajectory, what is the case plan goal, ages of the children, the parties that are involved, what relatives may be involved. I just think that and there are plenty of attorneys that are involved in the sync actions because you do have, not all states have attorney GALs for the kids. Kansas does, which is very impressive to a lot of other states, that we do have attorney GALs. So there are parents' attorneys, there are GALs, they're, the court, and you've got the state that's representing the sync action. So because the prosecutors are the ones that file those actions in Kansas, again, there are a lot of different people that are involved, and I would say, with respect to any particular case, I would be in touch with those folks that are familiar with the case.
Can I continue? Because I was just wondering about the BIS, and the role of that survey or that assessment, that the attachment assessment would have, and how influential that document would be in the BIS meeting. And then later, that it becomes a part of the tracking tool, the adoption tracking tool.
Well, the home study assessment is the family assessment that you're doing to prepare for the filing of an adoption case. And well-done home study assessments should be addressing those issues that you're talking about. I mean, that should contain, this is the attachment this family has with this child. And that should all be explored in those assessments if it's a well-written assessment.
Thank you very much. Thank you, Madam Chair.
Senator Faustido.
Thank you. I thought somebody else was already ahead of me. So you said that when a decision of placement has been made, and if in fact someone appeals that, you said that an independent group of people will review that case. Who are those?
Those would be someone within the child welfare management provider within that agency. And I can't, it's up to that agency who that will be. Policy says they may be independent. They must be. They shall not have any conflict, and they should not be a part of that, should not have been involved with that BIS staffing. But it's an independent reviewer within that case management provider agency. And it is a review. It is not a legal appeal but it is a review to make sure policy was followed, to make sure that there was no conflict of interest or biases exhibited in the process.
Sure. Thank you, Madam Chair.
Senator Baumgardner.
Thank you, Madam Chair, and thank you for being here today.
Thank you.
When we talk about the BIS, it can be waived if there is only one potential identified adoptive resource, and that is determined by whom?
Well, I will tell you, in most cases, that's quite clear. I think there are other outlier cases where that's not as clear. In other words, there are some children that have been placed with their placement for some time, and as we're looking, 48% adopted by foster parents and nearly that adopted by relatives. So in most of the cases, by the time you reach abyss, it is fairly clear, but there are other cases that I think, to be frank, that probably most of you hear about where it did not, it was not as clear. And so it would generally be the child welfare case management provider who is sending out the invitations, who should be making a determination, who has expressed interest, who has placement, who has connections, and have expressed an interest in adopting the child.
Well, yesterday, when we heard about the situation where the child was placed with a relative, but it was essentially ordered by the court that fast-tracking reunification, and that it was to occur, I think, was the time frame within 35 days? So would that be a situation where there was not a BIS? Because, and it seems clear that there was not any type of assessment instrument done to see about the attachment with the child, with the biological father, who the child had not been with. So how, am I right in surmising that there wasn't a BIS and that the court?
Well, I'm going to be very honest that I don't think I could answer that. I did not hear that testimony, and I can't answer on a specific case what happened or didn't happen.
But if the agency identifies here is a relative, it's the only relative, last man standing, essentially, they can waive having the BIS. And if we have a gal that's never met with the child or the parent, and you have a contractor that says, yep, we found this bio father, all of those things can occur without any type of a BIS.
Well, if the criteria is met for the BIS waiver, theoretically, a BIS could be waived.
Right.
So whether what happened in that particular case, I cannot answer for you.
Right, we're talking hypothetical now, since you can't be specific about a case. And none of us can be specific about that case, but it can be waived, and as long as no one is willing to speak up about, I think there might be a red flag, it can just move forward and go directly to the courts to finalize, correct?
Well, I think we always need to keep in mind that when it proceeds from the sync case and then it's filed as an adoption, because I did a lot of private adoptions, you have a whole new judge that is looking at the background checks, at the home study assessment. So that judge that's presiding over the adoption case still has the ability to approve or not approve an adoption, to ask questions. So there's really a separate process for the adoption itself. And there would have to be a home study done at that point for the adoption case. That has to be completed before the adoption could go forward.
And who would be doing the home study?
Often social workers do those. The statute in Chapter 59, it's 592132, it specifically says who can conduct those assessments or prepare them, complete them, and what needs to be contained in those.
Thank you.
Thank you.
Further questions? Representative Esau.
Thank you, Madam Chair. And forgive me if you addressed this when I had to be out of the room for a few minutes. I see the list of everyone here and it says shall be invited, which I get reminded often in a whole nother part of statute that shall means it must be done. There is no option. All of these various people that shall be invited and notified, I don't see on there where we ever include the foster care parents. Am I correct?
Well, if you look, it's going to be the current placement resource, unless their conflict, they are one of the families being considered, so that would be I. It's 3I and 5339. Now, if the foster parents, and again, I can't speak to those unfortunate situations where things have not gone smoothly or the way that we think they should have. But generally, if a foster parent has had placement and expresses interest in adopting the child, then they would, yeah, that would be a current placement.
Okay, so we don't name them, we call them current placement resource instead of foster care parents, if I'm understanding right.
Yeah, it can be different people. I understand your point, and that's certainly something that we could take back and talk about trying to better clarify that portion of the policy, because it sometimes helps to have people who have outside lenses look at a policy, and then we go, well, that probably could be strengthened or clarified a bit. So I appreciate your asking that, and I'm going to mark it as something for us to go back and look at.
So I have one other question because of something you said, and I'm hoping that thought comes back to me
Okay.
in half a second because it just escaped out of my head. Oh, the independent review. Am I understanding right, the independent review is done by the same agency that's doing the BIS? Or the same,
That's organizing it.
Contractor, whatever we're calling them?
That organizes it, yes, that is correct.
So it's being done by the same organization that's doing this. It's all answerable to the same person at the top. It's not really an outside person looking in and going, was this BIS done well? It's within the same agency or contractor. Okay, thank you. I just want to make sure I understood.
Currently, that is accurate.
Senator Gossage.
Thank you, Madam Chair. Thank you so much. One, I appreciate being able to see the checklist here as far as what was discussed earlier on the adoption tracker. Thank you for that copy of that tool. I'm just going to say it this way. When I received this information from the Kansas Legislative Research Department, which is excellent, about what is considered the best interest of the child, and definitions, et cetera. When I read that, and then when I read policies, a lot of the emails we've been receiving, complaints that we've had, concerns that have come before this committee, I can't see that any of those would have happened if all of this was followed. Does that make sense?
Yes.
So there's got to be an issue somewhere, and it seems like the task of this committee is to feel like, where did things fall through the cracks? And we're hoping that you, the departments, can help us figure that out, because I know we all want to do what's best for these children. The departments want to do the best, the attorneys, everybody seems to want to do the best, the foster parents who've spent so much time and energy put into these children. God bless them. So I hope that we can all come together and make some recommendations at the end of this day about what we can do to make sure that these policies, the best interest of the child, are followed. Thank you so much for being here.
Representative Johnson.
Thank you, Madam Chair. Real quick, on page 55 of our sync booklet, I had a chance to look through there, and I had asked about the legal notice. It does specify at least the responsibility on behalf of the state. It says notice, this is regards to The secretary shall give written notice of any plan to move the child to a different placement unless the move is to the selected pre-adoptee family for the purpose of facilitating adoption. It should be given to the court, the petitioner, the attorney for the parents, each parent for whose address is available, the foster parent or custodian from whom shelter is supposed to move, the child if 12 or more, the child's guardian ad litem, any other child or any other party you're interested. And then it goes down a few lines. It says shall be mailed by first-class mail 30 days in advance of the planned transfer. So it doesn't allow for emails.
I think that I misunderstood you, and I thought you were asking about the best interest staffing. But if you're talking about change of placement, I agree with you. I thought you were talking about the notice of the BIS, and so I misunderstood that.
No, you didn't misunderstand. I was checking on the BIS because I have correspondence here where the foster parents are requesting another BIS because they were just notified within the last 10 days or so of a pending move. And they're requesting a rehearing on that. Well, and I'm just checking on this, so.
Well, there definitely, for change of placement, there is legal notice requirement. There is not a legal notice requirement attached to the BIS because the BIS is not in statute. So just to clarify.
Thank you very much. Yes.
Thank you.
Further questions? Thank you. Okay, a little bit ago, you referred to some research regarding, what was it, sibling splits, that maybe you could circle back with us
Yes,
on?
if we can obtain that, we will get it back to the committee.
Yeah, would appreciate that.
Yes, thank you very much.
Thank you. Okay. Next up, we have Melissa Johnson with the State Child Death Review Board. And is Sarah with you today? Yes. Okay. Okay. Well, welcome. Thank you. Sorry we're running a little late.
Oh, no problem. Thank you. Good afternoon, Madam Chair and members of the committee. We appreciate the opportunity to be here again this year to visit with you about the work of the State Child Death Review Board. Since we were formed in 1994, we've now reviewed the deaths of more than 12,000 children. Those are children that are Kansas residents or children who die within the state of Kansas between birth and age 18. We continue to classify deaths as either natural, unintentional injury, homicide, suicide, or undetermined. Our board composition is made up by the entities set out in the statute, and we file our report with the governor's office each year by October 1st. The report that was issued this last October was based on 2020 data, which is the most recent data that's available. And in 2020, we had 365 deaths of children. 54% of those were natural, 17% were unintentional injury, 16% were undetermined, 7% were suicide, 6% were homicide. SIDS deaths are included as undetermined deaths in the way we collect and categorize our data. And interestingly, we continue to see that males die at a higher rate than females do across almost all categories. And males accounted for 59% of the child deaths in Kansas during the 2020 year. We also noted in our report that there were 727 deaths that occurred between the 2019 and 2020 years, and of those, 36% of those children, or 266 kids, had past Child Protective Services history. When you exclude the natural manner of deaths and look at the percentages of children that had contact with the Child Protective System, that changes. If natural deaths are excluded, 53% of the children, or 318 kids, between 2019 and 2020, had contact with Child Protective Services prior to their death. And if you look only at homicides during that same time period, there were 45 children, or 64% of the homicide deaths had Child Protective Services history. An example that's included in our report this year of child welfare involvement talks about one situation where DCF had 31 previous reports on a family of a teenage suicide victim. Many of those allegations included physical, emotional, and sexual abuse allegations, and none of those reports were substantiated or affirmed, and the board could find no evidence that either that child or any siblings had any physical examinations by a healthcare provider to try and assess for injuries or other indications of abuse that might have provided evidence needed to remove the children from that situation. The child themselves had contacted DCF on multiple occasions in an attempt to try and improve their home situation. The children had reported they were bullied at school because they smelled of urine and had dirty clothing. Because of a clogged drain at their house, they weren't able to shower at their home, and when they were able to, they showered at school or at a friend's home. The child provided pictures to DCF of their living situation, and the children were finally placed out of home at that point. About a year later, they were reintegrated with their mother, and then after that, there was an additional complaint that came in about a year before this child's death, when the report indicated that the kids were again living in a dirty, cluttered home that was infested with fleas and cockroaches, and DCF records indicated that they could not get in touch with mom, and the case was closed as unsubstantiated. This is an example that the board felt was important to share, where closer monitoring and collaboration between lots of different entities might have avoided this outcome. We also looked at child care deaths in our report. During the last 10 years, there have been 38 child deaths that occurred in child care facilities. In the 3 cases that occurred in 2020, 2 of those 3 deaths were in an unlicensed child care location. Most of the children that die in a child care location are going to be under 1 year of age, and a lot of those, 27 out of the 32 were sleep-related, or so all but 3 had unsafe sleep-related factors. Of the 52 sleep-related infant deaths during 2020, 98% had evidence of 1 or more unsafe sleep practices, and 81% occurred when the infant was sleeping in a place other than a safe crib or bassinet. 49% of those families had current or past DCF Protective Services involvement. We also noted in our report this year an increase in drug-related deaths. In 2020, Kansas experienced 16 drug-related deaths in children between 0 and 17. It was a sharp increase from what we had seen in 2019, which was 5 deaths during that calendar year. A lot of the deaths that we started seeing in 2020 were related to fentanyl. In 2019, we found no fentanyl deaths among children, and we had 11 in 2020. We also looked at homicides again this year, and there were 22 homicides in 2020 calendar year. 6 of those were from child abuse. Of the 22 families that the children came from, 13 of those families had prior or current DCF Protective Services involvement prior to the fatality. And there were additional deaths that the board identified that were reclassified from their original cause of death. We also added information this year based on firearm deaths. In Kansas, firearm deaths reported 74% of all weapons-related deaths in the last 5 reporting years. They could be homicides, suicides, or accidental unintentional injuries, if such as the child was playing with a firearm or somebody accidentally discharged a firearm where they weren't intending to hurt the child. Of those, the vast majority occurred in counties with populations over 100,000, and 76 of the 125 firearm deaths, or about 61%, came from Douglas, Shawnee, Wyandotte, Sedgwick, and Johnson counties. In looking beyond the information there about the firearm deaths, it doesn't appear, based on the data the board has, that it's sort of a one-size-fit-all change that needs to occur related to those firearm deaths. You had to look beyond the numbers, and there's a table, it's figure 70 in the annual report that was issued this year, that shows there's a vast difference if you look at the data there between Wyandotte County and Johnson County in particular, since they border each other. You have similar numbers of child deaths, but in Wyandotte County, they're homicides. If you look in Johnson County, they're suicides. So if you just look at firearm deaths, you may get one particular picture, but if you look behind that, there are different types of firearm deaths. So probably need different prevention strategies from the local communities in order to address those. We looked at suicides this year as well. There were 26 suicide deaths, and they were overwhelmingly male. 85% of the suicides were male. 66% were either currently receiving or had previously received mental health services, and about half had communicated suicidal thoughts or actions previously and had had current or past DCF history involving their immediate family. Part of our recommendations this year were improvements to the child welfare system. I know that there was a lot of discussion in a couple of bills that were in the last legislative session regarding having children evaluated by child abuse professionals or additional training. And the board understood that there was some funding provided for that, and we were very appreciative and thought that was a great step. We're asking that be considered for further enhancement, so it wasn't just sort of a one-time fix or a pilot project for that. The other thing that we noted as far as legislative recommendations this year was to enhance or improve the child care licensing laws. The board has found instances of children dying in unlicensed unlicensed care providers or providers that weren't current on their licensing requirements. KSA 65501 requires that persons maintaining a child care facility for children under 16 be licensed. If someone's found to be out of compliance and remedial measures haven't worked, that person could be prosecuted by the county attorney for an unclassified misdemeanor. If they're found guilty, the current penalty is between $5 and $50 per day that they're out of compliance. And the board hoped that through enhanced monitoring, enforcement, additional fines or fees, as well as increased prosecution, that the quality of child care could be improved in the care that's available to Kansas children. And I'd be happy to answer any questions that you do have. And I would note, I forgot to say it at the beginning, last year the committee had asked if we had information about race and ethnicity information as well as sexual orientation. We've tried to add that into the report this year. I know it's kind of an awkward process that you ask a question and a year later you get the answer, but unfortunately that's how our report has to work as far as collecting the data. So we have tried to include that where it was possible. We don't have as much information on sexual orientation, just because if you think about, forms that you fill out on a regular basis, that's not something that there's a box that gets checked a lot of times. So that information we have is a little bit more sporadic. But I'd be happy to answer any questions you have.
Do we have questions? Senator Foscato.
Thank you, Madam Chair. When you mentioned that the suicides, ironically, were by males. What are their ages?
Let me pull up that part.
And then you also mentioned that those males their family or they had been in contact with DCA. Would you clarify that? Because DCF, there's a lot of different departments, divisions under that umbrella. So a lot of families are low income and they get DCF services for medical card, food stamps, a variety of things. And I think sometimes we put it out there as if DCF is only dealing with foster care or adoption. So when you broadly say that, was it DCF in the foster care system or just DCF for those that needed income services or food stamps? Okay.
All right. As far as the ages on suicide, oh, I had it.
And for sake of time, Madam Chair, if she can get that back to me.
Okay.
So the ages of, you said that they were majority male.
Right.
And their ages is what I want to know. And then when you mentioned, and then the second question I asked regarding those who came in contact with DCF, was it just for foster care or just that the family had filled out an application at one time? And then my final question, Madam Chair, when you mentioned that there is now finally, thank God, a concern about those who provide care for children, but they are unlicensed, and that you are looking into that. So is that a bill legislation that you will require, ask for?
That was just a recommendation that the board makes. Generally, we don't introduce legislation. We just tell you that.
A recommendation.
This is a recommendation if you're looking for something.
And so can you give an example? So I know one of our meetings, Madam Chair, we had a group, I'm just going to name one that comes to top of my head, Faith Builders, and they're not actually licensed. They are, but they aren't. So are you familiar with that program?
I am not.
So can you give me an example of a provider that you would like to, that you would require to be licensed as your recommendation? Thank you, Madam Chair.
Right. It wasn't a specific person or entity. It was more when we see a case, hypothetically, you've got a child that is dropped off at a friend's house. And so, they're being cared for. There may be multiple children that are dropped off at that friend's house. And so it's an unlicensed daycare because they've got multiple children there that they're providing care for. They're just not necessarily subjected to the same licensing requirements as other daycares might be that might be in a home.
Madam Chair, thank you. And are you able just to tell me those that, I mean, if you're going to make a statement about those males that committed suicide, but you don't know their ages, right now you don't, and you said they also came in contact with DCF, I want you to be specific and tell me how they came in contact with them. Because, Madam Chair, I'm just saying there are a lot of families in my district that go to DCF, and their families have been intertwined sometime or another because of some hardship. And so I just don't want that negative piece to be there if, in fact, you just want to be specific and talk about those with foster care connections. So if you could clarify that for me now or later, be fine. Thank you, Madam Chair.
Let me double check with Sarah. I believe it's going to be Child Protective Services involvement, but she'll be able to clarify for us.
That's correct.
Okay.
Any of those are CPS referrals directly with that department.
All right. It's going to be with Child Protective Services involvement. Okay. And as far as the death rates, in the report, it talks about by age group. Generally, the firearm deaths are going to be the suicide deaths are going to be the older children, like 10 to 17. You don't see those as much in the younger children.
Senator Gossage.
Thank you, Madam Chair. Just two quick questions. Thank you for being here. I kept trying to write furiously on my piece of paper here from all of the things you have. Obviously, is that your report from 2020 you're reading from?
Yes.
And can you get us a copy of that?
Yes.
Wonderful.
So,
And then it was
so
there.
we do, she has provided a report, and Natalie has emailed it too, so it's in your email.
Wow. Ask and you shall receive, and before you even ask, I guess. And then the last question is, you know, this is the end of 2022. So how soon will we know 2021?
October 1st of next year.
Really?
Yes.
Wow.
We're
Okay.
a couple years behind just because it takes a while for everything to be completed, for all the reports to be done, for that information to be collected, distributed out to all of the board members, for us to be able to review every case from a calendar year and then compile all that information. So unfortunately, there's more of a lag there than we would like.
Thank you so much. Thank you, Madam Chair.
Representative Ousley.
Thank you, Madam Chair. And I apologize, Ms. Johnson, for having to step out of the room for a minute, but I have been informed that you've taken my request into consideration, and I look forward to seeing the data when I get a chance to look at the report.
Very
So
good.
I just wanted to say thank you.
You're very welcome. Sarah and her team did a great job trying to put that in there this year.
Thank you, Sarah.
Any other questions? Okay. Were we going to hear from Sarah too, or?
And if you have any questions, I'm sure she would answer your questions. And
Doesn't look like we have any further questions. So
all right. Thank you.
Thank you. Thanks for being here. Not yet. So hopefully you've had an opportunity to take a look at the minutes that were emailed yesterday. And there's two sets, the September 12th and 13th meeting and the October 26th meeting. At this time, I'd entertain a motion to approve that motion has been made by Representative Johnson and a second by Senator Gossage to approve both sets of minutes. Any discussion? Representative Esau.
Thank you, Madam Chair. I might have been looking at an early draft. There was a roll call vote taken in one of the meetings, and I noticed that that was noted, but the names weren't listed. Should they be? I don't know. I can't remember. You might have made the motion to have your vote recorded or for roll call. That was the part.
Okay, so a roll call vote was requested, but all we did was a show of hands. The names were not read off, so.
I just wanted to
yeah.
make sure we were correct.
Yeah, it was reported then correctly. We just voted wrong. Okay, any other discussion? All in favor, say aye. Aye. Opposed, no? Okay, minutes are passed. Senator Baumgartner.
Thank you, Madam Chair. I move to recess this open meeting for a closed meeting pursuant to KSA 75-4319A to discuss matters under the justification listed in KSA 75-4319B8 relating to the care of children permitted to be discussed in a closed meeting pursuant to KSA 38-2212D1 because discussion of such matters in an open meeting would jeopardize the confidentiality of records concerning such children. To resume the open meeting in room 112N at 3:10 and to record this motion if adopted as part of the committee's permanent record. Designated personnel who would be present in addition to committee members include Secretary Laura Howard, Deputy Secretary Tanya Keys, and Patty Martley. That is my motion.
Okay, it's been moved by Senator Baumgartner to move into executive session, second by Representative Humphreys. All in favor, say aye.
Aye.
Opposed, no. Sorry, I forgot discussion. Okay. Senator Baumgardner.
Thank you, Madam Chair. I don't think we're on, but do we need to be on?
You're on now.
Okay, thank you,
Senator
Madam Chair.
Baumgardner.
Yes. I move to recess this open meeting for a closed meeting pursuant to KSA 25-4319A to discuss matters under the jurisdiction listed in KSA 75-4319B8 relating to the care of children permitted to be discussed in a closed meeting pursuant to KSA 38-2212D1 because discussion of such matters in an open meeting would jeopardize the confidentiality of records concerning such children. To resume the open meeting in room 112N at 3:20 and to record this motion if adopted as a part of the committee's permanent records. Designated personnel who would be present in addition to the committee members include Secretary Laura Howard, Deputy Secretary Tanya Keys, and Patty Markley. That is my motion, Madam Chair.
Okay, it's been moved by Senator Baumgardner, second by Senator Gossage to go into executive session. Any discussion? All in favor say aye. Aye. Opposed, no. Okay, we are back on track. Thank you for your patience. So we are going to open up discussion on any recommendations. Now we can, yeah. So yeah, Natalie is passing out our, the report. The report from our committee of last year. Thought that might be nice to have, just to look at the recommendations that we made, and some of them got traction last year, but some of them I think we need to look at again. And then also just speak up if you have something you want to discuss. So, Senator Baumgartner.
Thank you, Madam Chair. I'm going to just have us look back at yesterday when Tammy Thomas was speaking to us about the Safe Families Kansas and the work that Safe Families are doing. And I think it might have been my colleague, Senator Fauskido, that said that that was the first speaker that was giving us something to be happy about yesterday, and it was happy news. In her testimony, she indicated that they are wanting to expand Safe Families Kansas to McPherson and the Fort Riley Manhattan area. Those are two areas that I certainly support, and I appreciate their receptiveness as communities of wanting something there. And I know that they, one of the things that Tammy shared with us was that end goal to really spread across the state, and they thought that those two areas were good launch sites. So I would recommend, she did share with us a price tag. They believe operationally that they would need an additional $350,000 to expand into McPherson and Manhattan, Fort Riley areas. I think that we learned that the funding currently is through DCF, but I think it's important for the Kansas Legislature to make sure that we say that we do support the Safe Families Kansas program, and that the expansion would be important and positive for Kansans. What?
No, oh, sorry.
Oh.
I was looking at something else that made.
Okay. So that's okay. So that's my first recommendation.
Okay, we have a okay. I think that we are going to have discussion on each one of these, and then if we can approve them by consensus, that's the way I'd like to do it. If there's objection, then we'll go ahead and vote. So discussion, just.
What's the question?
Fiscal year 23 or 24? Let's see, we are in, it would, well, we would have a half a year. We could do.
I would say that if we could get a portion of it started for fiscal year 23 and then fully fund for 24, because we will have that opportunity at the beginning of session to make that budget adjustment.
And that would still be through the budget of DCF.
Mm-hmm. Yeah.
Representative Ousley.
Thank you, Madam Chair. And I agree the presentation was good, but at this point, I think I'd like to dive in a little bit deeper to Safe Families outcomes and processes and oversight before I agree to, making the recommendation for, the expansion funding. I'm all for helping kids and, and expanding anything that does so, but I had some questions yesterday that I'd like to see answered, so maybe this could be something we research or, dive into just a little bit deeper in session. That'd be my consideration on it. I'm not very familiar with the organization, and I don't want to get us too far off topic, but yesterday's beginning was the CASA request for funding, and that's an organization that I'm familiar with. And when we get to that, I'll be happy to make the senator's second for the extended funding.
Representative Ruiz.
Yeah, Safe Families came to the Social Services Budget Committee last session, and we approved, or we recommended the $250,000 at that point. And I thought that was into 2023. I'm not sure now. So I think they're still operating on that, but I understand what Senator Baumgartner is saying, that approving something like that now would get them started. I am also in agreement with Representative Owsley that it would be good if they could come back to Social Services Budget Committee, make their presentation. We could have more of an in-depth conversation about outcomes, as we look at making recommendations for their, I know they were asking for $350,000 more.
Representative Humphreys.
So I think they still would have to make that. I mean, we're just recommending that they are considered, but they still would have to go through the whole appropriations. We are not appropriating anything in this committee, but yeah.
So would you be more comfortable with it if the wording said, fulfill the funding request pending further testimony in the process? Would that, or are you?
Well, I think we need to be clear. This would not be a separate piece of legislation.
No.
This is simply going to have to go through the funding process.
Right.
But I think, none of us are opposed to CASA. We're not even opposed to the guardian ad litem, but we know guardian ad litems get paid. And we also know from testimony they're not doing their job. We heard from testimony yesterday some of those success stories. Now, did we ask them for a breakdown of their budget? In fact, I don't remember any rigorous questions asking to quantify. They provided us the information. But I think additional information is going to occur in that budget process.
Yeah, I'm just wanting to have some, have our recommendations have some influence, and so, did you have, Senator Gossage?
Thank you, Madam Chair. My understanding of recommendations from a committee is that the majority of the committee, it's always great to have a consensus, but that the majority of the committee is in agreement that we heard testimony, we like what we heard, we would recommend that this expansion be approved, but that doesn't mean that we're sitting on the committee, and yes, they would have to go through as Representative Humphreys said. So I honestly, personally, would be more comfortable. I don't know how many you have on the list of recommendations. I only had 2, so I'm sure there are plenty of talking about them one at a time, but to put the list together and it's all in favor, aye for all, or all in, or no, one at a time, unless you feel like that's going to take way too long.
Well, I think we'll just go through them and voice objections, and then if there are any.
Okay. Because I would be in favor of voting for what Senator Baumgartner said, as I had that in my recommendations as well.
Yeah, so unless there's an objection, we're not going to be voting on them individually. So Senator Baumgartner has her recommendation. And if are there any objections to approving that? Okay, we'll put that on our list. What's next? Representative Humphreys.
Thank you. I would like to recommend that we take a close look at a foster parents Bill of Rights bill. Representative Finney introduced one last year, and it was at the end of session, and so we didn't get to hear more about it. but I would be interested in our recommendation on that kind of legislation.
Yeah. Yeah, that one got lost in the process. We had care bill of rights and foster parent and foster youth, and they were two separate bills. So, any objection to that recommendation?
No objection, but discussion.
Sure, you can have discussion.
Thank you. So I appreciate Representative Humphreys bringing that forward. And I think, what was that, House Bill 2227 or 2225, something like that. And Representative Gelfini called me and, asked me if I would help move forward with that. And so I'm glad that you're doing that because, seriously, honestly, Madam Chair, that was a couple of her dying wish to see that those pieces of legislation move forward. So appreciate that, and I support that. Thank you.
Okay, that was House Bill 2469. That was the Parents Bill of Rights. Representative Johnson.
Thank you, Madam Chair. The presentation we got from McPherson Fire Services on the safe, what do we call them, safe boxes, and we had discussed that
Baby boxes.
going forward. Does this committee want to support that? Because
Glad you asked. Do you want to? Yeah. Okay. Go ahead and pass those out. So Jesse's got copies to review of the bill as it was introduced last year. So we can take a look at that, but, we've heard hearings on this. This is the safe haven baby boxes. And is there further discussion on this one? Representative Johnson?
I have taken it home. I've shared, because my involvement with emergency services, I'm getting very positive because it's not a requirement. It's simply for those that wish to do it.
It tweaks the law, allowing it to
It's just very basic, and I was contacted by the McPherson fire chief or whatever, and I've followed up with him on who I've talked to, so I'd like to keep working on that one. Would we bring it through the Children and Seniors Committee?
Actually, we'd like to introduce it through this committee.
Sounds good to me.
Introduced, and we just need to designate which chamber we would like to see it go to. And I, like you, I took the concept home and discussed it with physicians, and thinking that my little town, that wouldn't be it wouldn't be that big a deal, and they said absolutely they wanted it. They wanted it, and they would be making the changes at the. It would have to be at the hospital in our case because the fire station is not fully staffed. We are divided between the Senate and the House here. I didn't realize that till just now. Would the Senate be okay if we had this sent to Children and Seniors, to the Committee on Children and Seniors? Are you okay if we send it to the House? Okay, on this one, because it's introduction of legislation, I believe we probably need to go through the voting process. Yeah, I think I'd feel more comfortable if we did. So we have a motion.
I so move.
We have a motion. I'm not going to say it for you. And with a second by Senator Baumgardner to approve, to introduce the language that was last year's Senate Bill 490 for the safe haven baby boxes.
I'm assuming it would come back, since both of us are on judiciary, I'm assuming it would.
Well, it's up to your leadership where it is assigned. It'll be assigned by LCC to a House committee. Other discussion? Representative Esau.
Thank you, Madam Chair. I'm just thinking on past experience. Should we introduce it in both the House and the Senate so that it doesn't get hung up and whoever comes and testifies can perhaps testify on the same day?
So the process with introducing from an interim committee, it goes to LCC and they introduce it to one chamber or the other. Am I correct? Yeah.
So an individual then could, if they wanted to, take a duplicate copy, introduce it in their chamber later so that it's in both places, just to get things moving. I know how things can get hung up. Okay.
Yeah.
Okay.
Okay. Other questions? Representative Ruiz. I am so tongue-tied. Ruiz.
Thank you, Madam Chair. It's not so much a question, but it's a statement. This is the one thing I have not studied on. I wasn't here, I wasn't present, and I had a substitute when this was presented. I am not anywhere near knowing this bill, so I will not be voting for it because I just don't think I know enough.
Okay.
Thank you.
Representative Ousley.
Along those same lines, I was here, I did take it home, and I did not receive the positive feedback. So I understand this will go through the committee process, and out of respect for the committee, I will not be in objection or a no vote, but I don't think I can support this at this time.
Okay. Further discussion. Senator Faustido.
Madam Chair, thank you. At that time, I believe we were in Wisconsin, and I was going in and out of, I joined on Zoom, and I had a question. I think, and I believe it was Senator Gossett who, or perhaps it was, that we talked about in years past, women could, or didn't we already have in law where you could take your baby to the hospital and without any yeah, so then I wanted to know, was this, I love the concept, the box still, and I thought we were going to name it something else. I didn't like the word box, but don't we already have something like this to whereas this would be a duplication?
Yeah, it's just amending what we have in order to make it legal. Go ahead, Jenna.
Thank you, Madam Chair. Jenna Moyer, Revisor's Office. So the current statute, this KSA 382282, requires an individual to surrender their infant to a person, and this would expand that law that would allow it to be surrendered to the box or to the crib. Yeah, the infant refuge crib.
Okay. Does anybody oppose changing that to bassinet? I do like that. It's okay. Is that okay? All right. Okay, further discussion? All in favor say aye. Aye. Opposed, no? No. Okay. Ayes have it. And so we can move forward on that one. Senator Faustido.
Madam Chair, I'm going to need the help of staff or someone else. I've misplaced the statement this morning from the, or maybe yesterday. I'm going to call him Mr. Blake. Okay, so here's a note that I jotted down that I think he recommended that when foster care decisions or placement decisions are made, that we would also have foster parents, just have everyone involved there at the table. Or, let me take a look.
At which table? Are you talking about like a best interest staffing?
Well, we talked about people who had not had any interaction with the child, and then placement decisions were being made, and but after, oh, I see where it's underlined. Who underlined this? She's wonderful. That the foster parents be somewhat considered as kin or.
Was it Texas? Yeah, okay. So
what she's underlined is what I'm,
Okay, I'm not seeing what you're seeing, so
we'll pass.
can I,
You sure can, thank you.
well, okay. We, as foster parents, we're not allowed, in most conversations, we believe that after 12 to 18 months of care, the foster family should legally be viewed as kin. The statute is done in other states like Texas. So Jesse has info.
Thank you, Madam Chair. So the Texas statute, for those who are listening and have access to a computer, in the Texas code, it's 264.851, where it provides a definition of kinship provider, which is a relative of a foster child or another adult with a long-standing and significant relationship with a foster child before the child was placed with the person by the department with whom the child resides for at least 6 consecutive months after the person becomes licensed by the department and verified by a licensed child placing agency or department to provide foster care. So currently that definition is not in our statutes. That is the definition Texas uses, and it uses it in the context in which it allows a process for that specific person to then apply for adoption and go through a process to adopt that child. So that's what they're referencing, and the committee may do what they with that as they will.
Okay, any discussion on that one? Representative Humphreys.
So thank you, Jesse, for sending that yesterday too when we asked. So, and when I read it, I think the way you just read it out loud makes more sense to me when I was reading it myself. It's or this, or this. It's not, they didn't have to know the child prior to the placement. Is that correct? Just want to double check on that.
There is no qualifier that they needed to know the child before the placement in that definition.
It could be because it's in there, but it's not one of the requirements. Okay, thank you. Just double checking. Thanks.
Okay, any others? Senator Gossage.
Could this be, I heard Senator Baumgardner kind of mumble this to herself. I'm teasing. So I'm going to take her words, but it is, could this be considered in the Bill of Rights? This is one of the things that'd be added into the Bill of Rights, and maybe some of our other recommendations could be as well.
I think it could be, but I also think, if you remember, we introduced a bill in Children and Seniors that did change the definition of kinship. And so we could put it in the Bill of Rights, but changing that definition, I think, would be quite important, and that we could have it in both.
Representative Ruiz.
Thank you, Madam Chair. I looked at the foster parent Bill of Rights of Colorado. Either they just pass it or they're going to pass it. It says 22 sessions, so I'm not sure. And there's a definition about that in that Bill of Rights.
Okay, so are we okay with language, coming up with language that would be similar to what they have in Texas? Are you good with that, Senator?
Madam Chair, yes, and the staff, if we could leave it up to them to kind of pull together what we just all said to try to make sure that all those interested parties are considered.
Okay, any objection? Okay, what else? You want to do CASA? Sure. Representative Ousley.
I don't have anywhere in front of me the CASA paper from yesterday, but they had a budget enhancement request. I don't recall if they had a figure.
Well, this was last year, and that's what their annual.
I want to say it was more than that. If somebody else has.
I don't recall a number, but it's been kind of the last couple of years, kind of volatile funding. Did you know, Representative Ruiz?
I didn't see a number, but one of the things they asked is that they request that there be a separate line item budget for that.
Yeah.
For their funding for whatever.
Yeah, they've been kind of scooted around for the last couple of years for their funding.
And that would be my recommendation, that we look at a line item.
Yeah, I think that's where,
That's
where he was going
All
with
right,
it, so thanks.
If somebody can find the language, I'd like to put that in our recommendations.
Okay. Any objection to when we find the number to provide funding for CASA? Here's my papers from yesterday, but I don't remember seeing it. Was it? Okay, we're going to come back to this one. I guess I'll pop in with one. On last year's recommendations, the first one that we have, we called it expanding Adrian's law, but the CARE network. And if you guys will recall, that bill did not make it through the process, so we lost it in the conference committee. And in appropriations, I made the motion to put it, to create a one-year pilot program. And I think I shared earlier in the year that I attended their first training session in Salina about a month ago. And I was just so pleasantly surprised with the number of physicians that were there for training, physicians, a couple of APRNs, and a PA. I believe there were 23 that were there that day. And I didn't go for the whole training, but anyway, it's off to a great start, and I would like to recommend that we support legislation to put this program into statute. Is there any discussion? Senator Baumgardner.
Thank you, Madam Chair. I'm in absolute agreement. We already have demonstration of the interest and the participation. I think it's good for Kansas.
Okay. Anything else? Any objection? Okay. Anybody? Representative Humphreys.
Thank you, Madam Chair. I was going to bring this up anyway, but I look back at our recommendations from last year, and we did we did recommend that the governor and legislature should collaborate to reach a consensus on a bill during the 2022 legislative session that would establish a true independent and transparent Office of the Child Advocate. And I think we have I don't think we did that, but I think we've continued to hear that families are afraid of retaliation. And I don't think, as much as I appreciate the person who is in the Office of the Child Advocate, I don't really feel like it is truly independent when the governor's appointing the same person as the Secretary of DCF and as the Office of the Child Advocate. It's not truly independent. And so I would like to recommend again that we take a look at that and either put it under the legislature as a House bill or under the Attorney General, which was the Senate version.
Yeah, I think that, I don't see the language right now, but I think that we had some general, oh, here it is. The recommendation was that the governor and legislature should collaborate to reach a consensus on a bill during the 2022 legislative session that would establish a true independent and transparent Office of the Child Advocate.
Yeah.
Is that good?
Yes. Well, I mean, I guess I would like to expand a little bit on that recommendation, just that that we move the office from under the control of the governor's office to a different, I mean,
Yeah,
I know it's more controversial, and we can talk about it, but that would be my preference.
And I appreciate that. I'll just tell you that we were working on some options last year.
Yeah.
And I don't want to, I don't want to see us limit ourselves.
in a box?
Yes.
Okay.
By
Okay.
stating specific ones.
Yeah.
If you want to.
Independent, just
Make sure that
independent, in capital
independent.
letters, independent.
Yeah, yeah.
Okay.
Okay?
Yeah,
Are-
that's
So
fine. That's fine.
are we good with sticking with this
Yes,
language
it's
then?
fine.
Okay, thank you. Any other discussion? Representative Ousley?
Yeah, thank you, Madam Chair. And I don't want to diminish the recommendation, but I also don't want to have in there true independence, because I think that kind of undermines what we have currently. And I'm of the opinion of what we have currently is independent. And I know not everybody on this committee agrees, and not everybody in the audience may agree with that, but I also don't want to undermine what we have on the chance that the legislature doesn't come to an agreement at the end of the next session or the following session, because what we have right now, I think we're seeing progress out of, and I want to make sure that anything that we do doesn't hinder any of that progress as we continue to work towards a legislative solution for office of a child advocate. So I just want to be careful of that as we move forward with that recommendation.
Okay. And I would just say, too, that I don't think any of us are being critical right now of the work that she's doing, but I would say that by us putting this in statute gives that position more authority. Representative Ruiz.
Thank you, Madam Chair, for that clarification, too. I just want the Office of the Child Advocate that we have in place now to give them a chance. They just got going, and they're already, hearing cases and stuff, and now it just feels like we'd be stepping 3 steps back, and I would just ask that we give some latitude for them.
Yeah, we're not going to, I mean, it's not my intention to take away from what she, if you talk to her, she agrees that it needs to be put in statute. So does the governor's office. So, yeah, we're not taking anything away from what's been done. Any other discussion? Any objections to this one? Okay, we are flying along. Anything else? Did we hear an answer on CASA yet?
All I found was this.
Oh.
found the paper on CASA, and at the end it says attached funding breakdown of CASA.
Can you turn your mic on?
Thank you, Madam Chair. It says attached funding breakdown of CASA for local programs in the Kansas CASA Association. Oh, you have it, okay. But then I didn't see anything attached, so I probably missed.
Representative Ousley.
And in scanning the testimony, all I found was it is with this sentiment in mind that CASA asked for continued financial support by all members of this committee. That's the only thing I could find in the written request, so.
Yeah, Madam Chair.
We'll keep moving. I've got a list here. No, Representative Ruiz.
Thank you, Madam Chair. I have a recommendation regarding the MHIT liaisons. And I believe that Representative Brenda Landwehr is also going to be working on this, but it would be great if this committee would recommend that we have funding to make those liaisons permanent. Every year, they don't know if they're going to have a job, those liaisons, and so, it's, the MHIT program is just tremendous.
And this is the one where the counselors are in the schools.
Yes, yes. And so it would require state funding for that, but that, I think at the least, to be able to look at trying to make that funding more permanent.
Any discussion? Senator Baumgartner.
Thank you, Madam Chair. I appreciate the sentiment. I think that we need to be careful with that. Specifically, if you just look at the track record of our school districts. 2 years ago, we were down 19,000 students. A year ago, we were down 16,000 students, and we have not recouped. And to be clear, those liaison positions are CAPERS employees of the district. So we're not talking about the contract with the CMHCs, but we're talking about the person that is in the school acting as a counselor or a social worker or whatever you want to call it, but they are the liaison. So to tie the hands of that they have to have, the ask was it wasn't going to be a year-to-year contract. And the fact of the matter is that is year-to-year for all employees of K through 12 school districts. You are provided a contract to sign, and if there is a reduction in students, then that contract isn't going to be offered to you. And it is mandated within the guidelines of Kansas Department of Education at what time in the school year school employees need to be notified. So I understand what they're looking for, but the fact of the matter is when we talk about we don't have social workers working in our CMHCs, we don't have social workers for DCF or for even their contractors, part of that is because the schools have leached, they have taken those social workers and put them in the schools. So I know they're wanting that guarantee, but that is not how to carve out that for a school employee different from all other school employees isn't appropriate.
Any other discussion? Am I hearing that as an objection? Okay, we can set that one aside then. Yeah, do you want to respond, Senator Foscudo?
Madam Chair, if the Senator Representative Reese just clarify your point of your recommendation. I heard the senator loud and clear, but I didn't hear your main recommendation.
And if there's an objection to it, we will go back to it.
Okay.
I was just kind of going through the ones that were a consensus. Do you want to?
But
do you want to wait till
Madam Chair, what I was saying, I didn't really hear her major recommendation to support or object to.
Okay, Representative.
I was wanting for us to make a recommendation to fund those liaisons, those MHIT liaisons, because they are working year to year. And so, and I hear the objection by Senator Baumgardner, and perhaps I'll just let Representative Landwehr, I know she's going to address this, and so I'll just let her deal with that.
Representative Ousley.
So thank you, Madam Chair. So if there's an objection to one of these recommendations, then it's not going to go into our report, is what I'm to understand?
I'm sorry, I was talking.
If there's objection to one of these recommendations, it won't go in the committee report?
If there's an objection to a recommendation, my plan is that we're just going to go through the ones that are consensus, and then we'll go back to the ones that had an objection, and we'll actually take a vote.
So should I discuss this now? Because I didn't agree to the first recommendation made, but I wasn't going to object as this is just going into our report for the legislature to consider. And maybe I should have objected to that if there's further discussion, or maybe let this lie and we can continue discussion, because I think the mental health in the schools is worth consideration of funding.
Okay, let's, Senator Gossage.
I would just say that in the Education Special Committee that we had, this was a recommendation, as Representative Ruiz was talking about when she said Representative Baumgardner, sorry. That's not who it is. Landwehr, thank you. That Representative Landwehr, who is the chair of that committee, and I serve on that committee, and that was one of the recommendations.
Education?
Well, their mental health going into the schools, so.
Yeah, so.
Yeah, the special committee.
The special committee.
Yeah,
Well, I also believe that we passed it in, okay, yeah. I think we did in Cane Care Oversight as well.
Okay.
So back to the process. We're going to, if there's objection on any of them, we're going to set them aside and go back and take votes on them. So if there's further discussion on that, we'll have that when we return to it. Representative Humphries.
Thank you, Madam Chair. So my recommendation would be that we take a deep dive into the guardian ad litem situation.
Okay. Any discussion on that? Any objection? Okay. Anything else? So I also have on my list the Boys and Girls Club, and they had requested a look at funding. I believe that was through the community to explore funding through the community mental health centers. So anyway, that's my recommendation for the legislature to consider. Any discussion on that one? Any objection? Senator Baumgardner.
Thank you, Madam Chair. You know, they're wanting the funding, but one of the things that they shared was they were going to be coming and making that ask of the Joint Corrections and Juvenile Justice for funds that are awarded and granted through the Department of Corrections. They've never applied for any funding. They've never filled out an application for any of that grant money. So that's one of the things that after they presented, I asked them, you know, if they'd done that yet, and no. So this was just kind of their first bite at the apple. They'd like to do more, but they've not reached out for any attempts yet.
Okay.
So we'll be hearing that in committee at the end of the month.
So are you objecting to?
I'm not objecting. I'm simply saying what they're really asking for is some of that grant money. And so that really is something that's handled by the agency, not so much by the budget. Does that make sense?
Not. This is from the bottom one.
So she's not, so rather than what they mentioned, they're asking for it to come from CMHCs?
So it's my understanding that they were wanting to work with the CMHCs to get, to receive, to work on grant funding. And that, and
I'm
that
not
was,
opposed to them trying to get
Okay.
grant funding. I'll support it.
Okay.
I don't know how we can do it in our committee, but if we can help, we will.
Well, we'll put in our recommendation that we support exploring whatever funding mechanism. Any objection on that one? Okay, Representative Humphries.
Thank you, Madam Chair. I'm only making this recommendation because I'm afraid if we don't say it, then it may come back to us. And it's about the whole attachment issue that we've talked about. And we do think there's going to be legislation introduced. But if we don't mention it, I don't want it, to come back like, well, they didn't recommend it. So I think the Judicial Council will be asking that we introduce legislation about that topic. I don't know exactly what it's going to say, but I just would ask this committee considers that and, would look favorably upon legislation considering attachment once we see it. Thank you.
Okay, any discussion on that one? Representative Esau.
Thank you, Madam Chair. Several of the things that I brought up at the last meeting would fall under that, I think, having to do with bonding assessments, being required and considering the relation to biological siblings when giving priority to sibling placement over foster care, whether that actually exists at the time, and whether or not we should remove someone from a foster care home when they've bonded in the foster care home and haven't bonded with their biological siblings. So I think those are all topics that could fall under what she is saying, that we should watch for that legislation, but that the committee strongly suggests that the legislature consider those when they're looking at the attachment report that we're going to get from the judicial review, if that's possible, because I don't want to have 13 pieces of legislation that are all, this one's for this little point and that's for that point. Am I making sense? It's the end of the day. I apologize.
Yes, you are. Any other discussion? Senator Faustido.
Madam Chair, a question for the good Representative Humphreys. So your attachment legislation, not having seen the language, would it also, I know that we are looking at the foster parents where the child is attached to them and then they're removed, would it also still consider the biological parents that, because we're doing the same thing, we're removing children from those that they are attached to. So would it also, would you entertain the inclusion?
So my suggestion just has to do with the legislation that will be introduced. I don't know what's in it because it came from a judicial council committee, and until the judicial council agrees to it, which is the first week in December, then we don't really know what's in it. But I mean, I would think that they would, that's part of the whole like bonding assessment and everything, to look at who are the children attached to. So not opposed.
And
Thank
Madam
you.
Chair, because I recall one of the conferees stated that, let's try to fix the problem within the home first before removing children. So just keep that in mind, please, as we move forward.
Further discussion? Any objections? Okay. Anything else? Representative Ruiz.
I'm not sure how to state this, so I'll need your help, Madam Chair. One of my concerns has been about supervision of the case management staff and whatever level of staff is actually working with the families and working with the kids in their foster homes. And what I heard over and over is it's monthly, at a minimum, monthly. But some agencies have, it's an open door, so case managers can come in and talk about complicated issues. They're all complicated. Every single one of these situations are all complicated. And I don't believe supervision once a month is adequate. It's not something legislation, that we as legislators can say we're going to have legislation about this, but it is something that needs to be further discussed as to there has to be better ways of accomplishing that. A month goes by, there's so many things that can happen to a child. And I don't believe that there's adequate supervision that is going on. So I don't, if we can emphasize to the contractors, and then if there's going to be any kind of looking at new contracts, that there's some language be in there about supervision has to happen more than monthly. And I know some people that do supervision once a week, and I know that it's difficult to do, but supervision doesn't have to last an hour. It could be very quick. It could be 30 minutes. And just be able to cover, these case managers have so many children on their caseloads, and there's just no way you can go into supervision once a month and be able to know, those supervisors and directors know what is going on with those families. So
You could make that as a recommendation to the agency to have that as a consideration with the rebidding process.
Yes, yes.
Okay.
That would be perfect.
Okay.
Thank you, Madam Chair.
Any other discussion? Senator Baumgartner.
Thank you, Madam Chair. I wholeheartedly support that and would ask the representative to consider that we might add to it. What we heard yesterday was that this year is going to be the first year that we're actually looking at some clawbacks, and the clawbacks are capped at 2%. And we don't have any parameters as to what are other states doing as far as clawbacks for non-performance. And it's not just upholding the actual contract that they signed to, but that also includes what our goals are that are mandated in our settlement. And so some of what we're hearing is numbers are going up, not going down. And I don't think we want to wait for a year from now to get that second annual report and have it, again, have so many of our benchmarks not being met. So I am wholehearted in agreement with it takes more than one visit per month. And also feel that, if we're gonna be change agents as far as kids, as an example, spending the night in offices, it's going to take more than a little slap on the wrist of the 2% clawback. Thank you, Madam Chair.
Representative Esau.
If the representative who made the motion could clarify a little bit, were you talking about supervision of the case managers or the case managers' supervision in interacting with the foster care families?
It would encompass both. So the supervision, what's important about it is those decisions that are being made. All the decision-making that we have heard, that we've had emails and families come and talk to us about decisions that were made and everybody wasn't a part of it. Some of that could have been mitigated by really good supervision ahead of time. So that's more what I'm talking about, yeah.
On that same note, we had a recommendation last year that I would like to consider again this year. The legislature should explore codifying caseworker accredited standard caseloads in statute and add a statutory cap on the number of cases caseworkers may have while maintaining accreditation standards. Any discussion on that one? Okay. No objection? Okay. Senator Foscato.
So we're finished with that?
We're done with that one,
Okay.
yeah.
Madam Chair, committee, I think I've made this recommendation before, and I'm still hearing about it. And so my recommendation would be to the Department of Family and Children Services that we try to implement a different way that after a court hearing, when all the entities that we've talked about or that have presented the last couple of days are in the courtroom, usually from what I hear and from constituents who are in the courtroom, and they say that once they leave, a couple of days later is when the caseworker or social worker contacts them to give them the list of items or that they must complete to reintegrate children. And then we have the turnover of social workers, and then I get people calling me saying, he said, she said, or they said, I've already completed that program. And so just a better way of documenting what the foster parent or biological parents are supposed to do, and so that we have that paper trail. So my recommendation would be for a more uniformed way to get the information to the parents who are attempting to reintegrate children. I hope I'm making,
Yeah, you are. Like a checklist of what
Yes.
needs to be done.
Exactly.
Similar to like what we were looking at earlier as the tool that had been developed.
yes.
So,
That's it, Madam Chair, thank you.
so were you directing that, a recommendation to DCF to develop that, or what?
Yes,
What's your
sir,
thought?
I don't know. I keep hearing, and maybe I need to clarify it with the secretary of what that procedure is. Some biological parents tell me, I'll say, did you get something from the court of what you're supposed to do? And they said, no, they're going to call me later and tell me. And then something happens, they don't get that call in 2 days. Then they call me back and say, I know they told me I need to do this, but it's just no firm list of what they need to
Yeah,
do.
something to help them. Okay.
I mean,
Okay,
they get a
let's
call
direct
later.
that at-
I want them to leave the courtroom that day with something in writing.
Okay.
And if there's a way to do that.
Let's make the recommendation then to
yes.
DCF to investigate, not investigate, that's not, or to develop, to.
Well, what I'm hearing, Madam Chair, is that social workers do it differently. Some will jot out something and give it to the parents. Some will text them. Some will call them in a couple of days after the court hearing to say, the judge said you need to go get a DNA test, or the judge, I mean, it's just no.
Oh, I see. So you're saying that it's hard to have a checklist and be consistent when it varies from court to court, but that there could be some that are consistent and then have blanks there to fill in the blank as the hearing is moving
Madam Chair,
forward to
we've
be able to
heard
hand
that
it to
there's
them.
a great turnover of social workers.
Yeah.
And usually by the time, even if we're all in the courtroom, when I leave here today and I drive to Wichita, 2 days later, I'm going to kind of have forgotten something. And what I'm told is the social worker will call the biological parent 2 days later and say, the judge said you need to do this and that.
Okay.
So now they're writing, can they leave with something in hand?
So you're saying to create some uniformity statewide across all
Not
of
statewide, because we know that they do it differently
but we
in
could
each
ask
county.
them to make it conform. Yeah, I understand that it's different in each county, but it can have some blanks to make it, to individualize it. You see what I'm saying? Have it be a checklist. And, yeah. I think we're on the same page.
Thank you.
But on your recommendation, what are you wanting are you wanting action? Who are you wanting action from? The courts or
DCF.
from DCF?
And I don't
Okay.
know if they can network with the courts. The court reporter in the room is typing something. Perhaps they could get a printout and give it to the social worker and the biological parent as they leave the courtroom.
Okay, are we good? Any discussion on that? Representative Carlson.
Thank you, Madam Chair. Senator, on other recommendations for last year, is this the one that says each court should provide biological parents and other family members or kin who attend court for the first time with a document outlining requirements to accomplish reintegration or regain custody of their children?
Madam Chair, thank you, Representative. And I don't know, the secretary's here, if she could speak and say, are they doing that already or not?
It was just it was on recommendations from last year, and it sounded like it was similar, so.
Yeah, that's it, and they're still not doing anything about it.
We can renew that one. It is different. Representative Esau.
And I realize they may have all left, but pieces of paper get lost, all that kind of thing. I know people might have a phone, they might not have a phone. They often can find a way to walk in the library, go check on the internet or something. Maybe also as they are working on this, if they could have some way that someone could even log in online and see, or the caseworker can show them when they're in the office, here's what you need to do. Just a suggestion to either the agency or the court, whoever it is that we're directing this to do, to be creative, not just paper and not just an email. And I understand some people, they're moving around with their permanent home location too, and so sometimes even snail mail doesn't work. We need something so that they can access that information no matter what the best way is. So,
Madam Chair,
we need to be
just
creative.
one last time, I'm going to take a stab at explaining what I mean. I'm not talking about necessarily paper. So here's what happens. I was actually there. So you're in the courtroom, the hearing takes place. You walk out of the courtroom, I'm standing outside speaking to the parents, and I say, did they tell you what you need to do? Because they went over and talked to the caseworker, and they said, no. She said she's going to call us in a couple of days. By that time, there's a new social worker, and the information gets lost. So they could text them right then and there. They could write a note down and give them something to let them know what to do moving forward. And they just don't know once they leave the courtroom sometimes.
Any objection? Okay. Representative Ousley.
Committee, I don't know if I'm ready to make this a recommendation, but I'll throw it out there for discussion currently. When we were talking about our system the other day and being, the public-private partnership to the extent that it is, I don't know if it would be worth recommending that discussions occur looking at the benefits and cons of our system and the potential of bringing caseworkers back into house under the Department of DCF.
Sir, discussion.
That was a response I got the last time I mentioned that too. But I thought I'd throw it against the wall again and see if it stuck.
Any objection?
It is.
You said you weren't ready, didn't know if you were ready to make that as a recommendation?
Yeah, if there's no objection to making that recommendation.
We're just looking at it. Okay.
We'll print it.
Okay. I don't know that we have the authority to do what I'm going to say here, but I'm wondering if we could say that when children are being removed from a home, that the police should not arrive with lights on. Did you have that one too? Can you use your mic?
Sorry, Madam Chair. We do need to find a collaboration mechanism with law enforcement to come up with some best practices. We've done that in the past with law enforcement as far as kids with autism and that are also nonverbal, and so it needs to be done.
Well, I like that language to work with law enforcement to collaborate for best practices, including turn off the lights. Representative Ruiz.
I just have an additional question. We didn't hear this, but I'm wondering if there's ever times that children are placed in handcuffs.
That would certainly fall under
I would
not best
hate
practices.
to hear if that happens, but it's possible, I guess.
For adolescents, maybe.
It'd be great to hear from law enforcement about why the flashing lights, why the...
Yeah, that would fall under the same, so good.
I know that law enforcement, it can be a safety issue for law enforcement.
Sure.
So.
Sure. Okay, anything else? Senator Fauskido.
Madam Chair, it would just really help me after all these years. I'm serious. Some of these things, we're still talking about the same problems. Small, minute issues that would make a big difference in people's lives. So that what Senator Baumgartner and we're talking about now, just turning off the lights of a police car would make a big difference. But when we make these recommendations, I have a stack of them. I would just ask and appreciate that those agencies, those entities, when we have another meeting at the beginning of it, they share, did this ever happen? I mean, I sound like a broken record, and when I drive home, I'm like, dang, I'm still talking about the same issue. I do see Tanya here in the audience with DCF. She would know if, in fact, when there is a hearing in the courtroom, judge makes recommendations, CASA makes recommendations, the social worker, caseworker, they know, they understand the lingo that's going on in the courtroom. But sometimes the parents leave out, they're actually terrified. They don't know what's going on. No one really told them other than, I'll call you tomorrow. Then they call me. I just like somebody let me know what is required for social workers in Sedgwick County when there's a hearing. Do they tell the client what the list of things that they need to do? Do they tell them then? Do they call them the next day? Do they email them? Do they text them? What do they do? And then I tell the social worker or the constituent, I'll say to them, oh, well, can't you just call them? And they'll say, no, they have their own personal phone and they're not answering. I'm like,
Okay. Tanya, would you like to respond to that now, or you want to get back with us on it? Do you have information?
Thank you, Tanya Keys. I do recall the recommendation from the past 2 years. I know we had a conversation with Office of Judicial Administration to think about a template or some type of uniformity that could be available in each court that could be used as a communication tool. I specifically don't know about Sedgwick County, so we'd be happy to get back to you about Sedgwick County. I don't think, to my knowledge, no statewide I'll call it a form or some type of method was initiated. But I know we had those conversations. I don't know the status of it. I also don't know that it was implemented statewide. And I can follow up to know how that's being completed in Sedgwick County.
thank you, Madam Chair, but it defeats the purpose. I mean, seriously, and I'm not asking for a statewide law. I'm asking for DCF to implement something in the largest city in Kansas, in Sedgwick County. And I'm asking for it to come from DCF. Tell your social workers to do it one way. When they go to court or CASA or who's ever in the courtroom, I don't know why the parents, biological or foster parents, cannot leave that courtroom with something letting them know what they need to do. Then it would stop all the he said, she said. They'll say, oh, I completed that program. Then the new social worker says, I don't see a list where you did or a check off where you've done that. And then they call me, and heck, I don't know. So then I call you, I call everybody over and over for 2 years. Can you do something? Thank you.
Yeah, thank you. And I'm sorry I don't know their current procedure, but we can get that to you.
Thank you, Madam Chair.
Anything else? Okay, so we have consensus items that we have all agreed on. We will, we'll back up to Representative Owsley for the CASA recommendation.
Thank you, Madam Chair.
Madam Chair,
Yeah,
okay.
we'll come back to you, Senator.
So the CASA request, as I understand it, was $350,000 to go to the locals, which 60 to 75,000 per association. That'd be the recommendation out of this committee.
So the total then is 350? No. 350 plus? Per association? Just, so, okay. Okay. Clears my, yep, we've got it. Any objection to that? Okay, Senator.
No objection. I support CASA, but I'd also just add in here that they be a little more intentional on accepting black people or those that go through the program, that they call them and engage them. Everyone we know, whenever we watch the videos, it always shows pictures of black children over and over, but the representation in the audience and the CASA members, the ad litem, everybody, it looks totally, it's a different color the majority of the time. And so I'm just asking that they'll do that.
Okay, any discussion on that?
Please, thank you.
Yep. Any objection? Okay. Senator Gossage.
Thank you. It was kind of brought up here. I'd forgotten that we had talked about, because I think it was yesterday, about the grandparents not really being notified. They have to petition the court to be considered, that we make a recommendation that they be notified. As far as if a parent has terminated, that the grandparent be notified.
Okay. Is there any discussion on that one? Senator Faustido.
Madam Chair, the interested party status, we need to have legislative research look that up. I know for a fact that the interested party status law in Kansas says that the court should notify that grandparent or other interested parties. They do not have to petition the court to do it. It says if the court, let's say that my daughter has a baby and it's removed from her, if in fact, and that's where the legislation that Gail Finney was talking about would be helpful, sometimes the mothers don't tell who their family members are. But if the court knows, they are supposed to automatically reach out to that grandparent as an interested party. The grandparent is not supposed to petition them. I mean, they can, but the law says it should be automatic.
Yeah, they did tell us that. So I think, yeah, we're getting conflicting information. So I think your request would be the correct thing, is to, let's find out. Let's find out. Senator Baumgartner.
Can we just circle back to the CASA? I'm not in opposition of the funding request, but I think in speaking to what Senator Faustido brought up, I don't think that they've ever provided us with any demographic information of the folks that are serving in CASA, and I think that would be helpful. I think, you know, if we're going to be able to hold them accountable, then they have to provide that type of demographic information.
Okay, we can add that to the request. Any objection? Okay, so we had one there was an objection earlier on the MHIT. So the information that I have here is that the Bethel Can Care Oversight Committee's recommendation was that KSDE work with MHIT to put the MHIT program into statute. So let's see, that was Representative Ruiz. Do you want to make any other statement on your recommendation? that the Kansas State Department of Education work with MHIT to put the MHIT program into statute. That's the recommendation you would like to make? Okay. If, is, well, is there still an objection then? Senator Baumgartner.
Thank you, Madam Chair. The only thing I spoke to is when they came and testified, their ask was that those contracts not be year to year. And that's what their ask was that the contracts for the liaisons not be year to year. We can't change that. That's the way those are handled, year to year. Funding is a different issue.
Well, I think
I'm in
that
support of that.
part of the funding and the year to year is the fact that it's not in statute. It was a proviso? And so by putting it into statute gives it a little bit more of a consistency. And I mean, that's the way that it was explained in our committee, in the Camp Care Oversight Committee. So anyway, is there any other discussion with using this language then for a recommendation? Okay, all in favor say aye. Opposed, no. Okay. That's the only one I had to go back to. Anything else? Okay, Senator Vasquez.
So, Madam Chair, I stayed late tonight, and I don't mind driving in on your dark highways back to Wichita.
My dark highways, your dark highways.
About two and
You
a
live
half
in
hours
Wichita.
here. I stayed late so that I could see this whole thing all the way through. You know, I just told Senator Molly Baumgartner that perhaps I need to have a press conference to force or to bring more attention to an issue I've been talking about for a couple of years now, which just, you know, goes in one ear and out the other. And it's like, I guess my concern is not that important. Also, Madam Chair, I'd like to say, no disrespect to anybody, but the CASA issue, you know, don't lay it on me. I mean, I've been talking about for 18 years to be more inclusive, to we talk about diversity and we show the films and all of that, but every year I go home and it's still the same representation. I hear the same things from my constituents. And so I didn't want to stand in the way, Senator Baumgartner and Representative Jared Owsley, of the CASA issue on, you know, my point. So please don't do that if it's, for whatever reason, it's not. You know, I just want them to, if we talk about the lack of African Americans who are foster parents or who want to be CASAs, I know a host of them who are applying, have the status, but they're not included. And so that's my only piece. So I don't, if you could clarify, did we move forward with?
Yeah, there was no objection.
With your concern, okay.
With both demographics and your concern to encourage more diversity in the CASA program. And
thank you.
Yeah, I don't think you should feel alone in that. I think that as I looked around for objection, that I was seeing nodding heads, and that the committee is supporting you in that.
And staff, I don't know, just as a member of the Joint Committee on Rules and Regs, Madam Chair, I just want clarification though. So all senators and representatives we have, you know, that's one of the things we get to do is introduce bills. But we've taken this objection thing so seriously. And so I just want to, because committee chairs do it differently. So what's your pleasure? I mean, so in order for our recommendation to go, we have to vote?
No, we did those, the ones that had no objection, we approved those by consensus. Those, that was on there, that is
I
a
understand. I just
recommendation.
want clarification for
Yeah, that was
our
my
next
pleasure.
meetings.
That was my decision ahead of
Okay.
time, and that if there were any objections, that we would handle it like we did the one that we just did there at the end and actually take a vote. But all others were approved by consensus, and so yours is on there. Every one of
No,
them
I
you
was
mentioned.
advocating for Representative Owsley this time.
Why would you do that?
For CASA. But Madam Chair, I do want to say this is one of the best meetings ever. The conferees that you've had and the information that you've brought forward today, it's just been really informative. Thank you so much.
Well, thank you for saying that. I feel like sometimes we get overwhelmed with material, and but we wanted to do a deep dive, and we did. So, any other comments, Senator Gossage?
I'll make it very quick. I too had an event in Overland Park that I contacted them and said I won't be there. I think this is very important that we look at these. There's so much that we need to quote fix, end quote, here. And those of us that have sat in and have been working on things for a long time really want everything to get better. I think everyone in this room would agree. But I also just want to say, I recognize that this is kind of a Solomon's choice in a lot of situations. However, when you have all of us who come from diverse backgrounds, politically and otherwise, different parts of the state, who are in full agreement on some things, I think we could definitely move ahead with those things. I too have sat in the courtroom like my fellow senator here. I 100% agree with her. I've said this before. When you've got this young mother or you've got someone who really wants their child back and they're trying to do what they're supposed to do, and you ask, do you have the list? Can I help you with that? And they're like, they didn't give me a list. They said this or that, and they said they were going to send me something. So I'm in full agreement to that. People want to do what they want to do. We want to try to help them. We'd like to reunite this mother with her children, and they don't fully understand what they're supposed to do, and if we could try to help them do that. So I agree that a list, they don't all have emails, that a list would be terrific for them to walk out of that court with, I know I need to do this, and if somebody can help them, they can, and they have the list as well, and they can see that. So thank you, Madam Chair, for indulging me.
Senator Holscher has a comment online.
All right, I'm there. Sorry, I was getting ready to move rooms because I feared it would be a while. Are we to the point, and I'm sorry, because I know we had a few different conversations going. I just wanted to make sure I've got a couple of things written down for whenever we're towards the end and we've gone through your list. I don't know if we're there yet.
Yeah, we're ready, almost ready to adjourn. So you have
Okay, well,
recommendations?
okay. Just wanted to make sure. There were a couple things mentioned that I don't know if they're in our documents. One of them, there was a mention of the fentanyl issue, and I don't know if we have put any type of recommendations in what we're putting together to somehow address that issue. I think we've already talked about manpower and pay issues, but there was also childcare licensing and firearms. Safe storage of firearms was brought up in one of the reports. And I don't know that we've addressed that at all in any of our information as far as recommendations.
Okay, are you wanting those as recommendations?
Yeah,
So let's take them one at a time. Fentanyl?
I would make a recommendation that we take a look at what was outlined. I can't remember which individual it was as far as addressing, what we need to do to address the fentanyl issue as it applies to foster care.
Okay. Okay, yeah, it was the Child Death Review Board, and yeah, it wasn't there wasn't anything there specific to foster care, but I mean we can we can make a recommendation to look into the impact on foster care.
Yeah, or I mean, I'm open to
The connection.
whatever else makes sense to the committee. I mean, obviously, there's an issue there that's growing pretty rapidly, that probably deserves some type of attention, whether it come through this or another avenue.
Any discussion on this? Representative Owsley.
Thank you, Madam Chair. And it did come up in the Kansas Securities Committee here over the interim. You know, we've heard about an opioid crisis in the nation for years, and it is on the rise here in Kansas. We didn't discuss, you know, any policy changes with it, but I do know that there are other committees that are looking into it, not necessarily addressed to foster care, but addressed to the deaths caused by the dangerous substance fentanyl.
So the recommendation would be to request some information on the impact of fentanyl on foster care?
Yeah.
Okay. Any objection? Okay, what was the next one?
Safe storage of firearms was brought up in the presentation yesterday, that it has an impact as far as mental health, teen suicides, and then other violence among teens.
Okay, then the same thing, request information on safe storage of firearms, as the impact on foster youth?
Yeah.
Okay, any objection? Yes? Okay, what was the next one?
Well, the other one was in regard to manpower and pay on all these different positions. And I think my question, I really had a question. I think we covered that earlier, but I think we did. So just clarification.
A workforce question. I don't think that we've made a recommendation as far as workforce. We've had a lot of discussion. Of the caseloads.
Yeah, I mean, I just feel like we need to put some type of attention on ensuring that we're
Well,
really
I
looking
put that
at
away.
the pay and the caseload and manpower issues. Whatever the form that is.
Which one was that? Oh, yeah, the one that I had that on the accreditation. Yeah, we did address that part of it.
Okay.
All right, so back to the one, there was an objection on just seeking some information on safe storage of guns, impact on foster care. There was an objection. Is there any further discussion on it? Okay, we're going to need to vote on it. All in favor, say aye.
Aye.
Opposed, no? The noes have it. One more announcement. Natalie sent the committee an email with follow-up information from DCF regarding foster family level definitions. So we have that. Yeah. Represent. Okay. So I just want to make one more statement, and that this is the last, I can't do this. This is the last meeting for Representative Esau and Representative Carlson, and I appreciate you both and all of the help. And Representative Esau was my vice chair on Children and Seniors, and I'm obviously very sad about this. And I really thank you both for your attendance and your input and, yeah, all the help.
Well, I wasn't going to do this, but I just wish everyone in this room at this hour the best of luck, because this is one of the most important things. It's our children, and everybody that is in here is here because they do care. And all of you out there, all the hard work that you do, oh, I just wish you the very best of luck And I've absolutely loved being on this committee, and I thank you to all of you. Thank you.
Representative Esau.
Hopefully I can get through this. So I echo what they said. This is, it's been an honor serving the last 4 years. And frankly, when the speaker called and said, "You want to be vice chair?" I told him I'd have to think about it for an hour because I was like, no, no, I don't want to be vice chair of children and seniors. I can't do it. After an hour, I said, okay. And I have not regretted it. And thank you for allowing me to work with you. And I think we've done good things, and I hope that we continue to move forward for the kids. And I hope this isn't the last time I sit here and talk with all of you in this capacity, but we shall see what the next 2 years brings.
We hope not to. Okay, anything else? Representative Humphreys.
Thank you, Madam Chair, for sometimes an unwieldy committee, and you've done a great, and hard topics, and thank you for your leadership.
Okay, we're adjourned.